ಮೆಮೊ ಈಗ ತಗೊಳ್ತೀರಾ ಮೆಮೊ ಈಗ ತಗೊಳ್ತೀರಾ ಆಮೇಲೆ
ನಮ್ಮ GMR ಹೇಳ್ತೀನಿ. One matter.
Lord.
One matter.
May be taken up at, yes, may kindly be taken up at 2:30 despite an order of the registrar. To list it today, it is not listed, it is in the board branch at list.
Come tomorrow.
One matter, my lords. Your lordship had given date, my lords, on memo on 20th. Lords, I'm seeking only to withdraw the writ petition, my lords. The matter is not listed.
Withdraw, it will come in next week.
I request tomorrow, my lords. Lords,
Yes.
Senior citizen matter,
Hmm.
and she's hospitalized, she wants to see that the matter be heard.
Senior citizen is hospitalized.
Yes,
Uh,
she's hospitalized, senior citizen. The Deputy Commissioner's order has been challenged before it's on court. The Deputy Commissioner has cancelled the decree against which the challenge is done before this court, and we procrastinated, therefore, responded, mother.
The gift deed is cancelled.
We have filed objections now.
That's okay. Then there's no urgency. It will come.
My lords, I was the next.
Uh, Hospitalized. Tomorrow, serve a copy.
My lords,
We'll get it verified. ಯಾವ್ದು ಅರ್ಜೆನ್ಸಿ ಇದೆಯೋ ನಾಳೆ ಎರಡು ಅಡ್ಮಿಟ್ Jafar, verify if the medical, Jafar, verify if the medical certificate is proper or not. Emergency parole. No, what is your submission? We did not hear your submission at all. ಏನು? ಏನು emergency ಏನು?
Administrator, unauthorized occupant is being occupied. Administrator is appointed. Tomorrow.
Is a fresh matter or pending matter?
Medical.
Pending matter will come in sequence.
I'm requesting a matter for 2:30, my lord. The reason is this.
Hmm.
Day before yesterday, my lord, in the night, the respondent police issue a notice under 106, blanket debit freezing my entire bank account, my lord. My lords, I was before this court on a similar notice issued on the same ground. There is already an interim order operating. Despite that, my lord, I'm not even, one of the petitioners is not even an accused in the crime. Now, my lords, my entire business is
Doesn't
brought
need to be an accused,
Please.
as long as the fund comes tomorrow.
my lord, this is a pending matter, my lord.
So sorry, my lord. May I just make one submission? The reason is this, my lord. I run an app, my lord, where the customers can sell gold and take
You want it
back.
tomorrow, you don't want it tomorrow.
I just wanted to.
Don't
clear
want it,
urgency.
leave.
My lord, this is
There
a
are two
pending
petitions.
matter, my lord. Your lordships have directed Niman's doctors to examine the petitioner's husband. They have filed a report. This had come up in yesterday, my lord. I made a submission when your lordships were about to
Given
raise.
the addresses.
Please, my lord, I have also sought, I may be permitted to file on, serve the copy on the panel council. As well as the respondent number 8 has a joint venture with Kotak Mahindra Bank, who has an Indian address.
Joint venture cannot be.
My lord, the insurance, my lord, the insurance
Certainly
company.
for you, all of them are companies which are outside India. And you need a direction against
My
them.
lord, the premium is being paid through Kotak Mahindra Bank. I may be permitted to serve on the respondent number 3 also, my lord.
Counsel, your writ petition is not maintainable. We are trying to help you out with this. Don't try to cut corners like this. Without service, we won't be passing any orders. Please get it served and then come.
May be permitted to serve on the panel
You
council,
serve on whoever, if they come, it is fine.
please.
My lord,
The petition before my lords is, my lord, had sustained life-threatening injuries by the firearm. The matter was listed yesterday, it could not reach. Now, my lord has directed the SP to file an affidavit of the, my lord, the investigation progress. That they are supposed to file it. So the reason is that, my lord, the police have let off all the,
They'll file it. When is the date given?
no, it is 13/8, my lords.
Whenever the date is given, they'll file it.
The urgency is that, my lord, I'm sorry to interrupt, my lord. Now, the crime is almost 1 month ago. The investigation that, my lord, all the accused have been let off except the one accused been apprehended. Now, the critical attitude of the police in not, my lord, following procedure, that it is an apprehension that I just request, my lord, that at least day after tomorrow, or whenever my lord's convinced, not on 13th, that is too late, that's what reason. They have,
Anything else you want to say, please continue saying. and
that's all it is, my lord. I just request that,
Reject it. Yes.
my lord.
I am petitioner, my lord. I filed a writ of mandamus before his court, my lord, only for return of my documents, my lord. I'm already signing the same order.
Is it a fresh matter or a pending
It
matter?
is a pending matter, my lord.
It'll come in seriality.
My lord,
Ramesh is asking for 13th to be taken. Everybody will ask for, we can't do that.
one request, my lord, can you fix any date, my lord? Because my senior citizens, my lord, 1974 said date, my lord, They are holding.
Whatever pending matter will come in seniority, we will not disturb it, because then your neighbor will be,
No, I would not take that, my lord,
it is not fair, it's not proper.
My lord.
Come in seniority.
My lord, here the petitioner is,
General parole.
General parole,
my lord,
ಇವತ್ತಿದೆಲ್ಲ 5th July.
my lord,
5th August.
Parole is 5th August.
5th August.
5th August, sorry.
ಗಡಿಪಾರ ಆಗಿದೆ my lord. Externment order has been passed against
ಹಾ.
the petitioner. my lord.
Fresh matter,
Fresh matter. 2:30.
not 2:30, tomorrow.
Based on my position as an ex-director of Attica Gold, my lords, I have been falsely implicated in multiple cases. There is a threat of arrest, my lords. Just because my face is there on the advertisements, they are unnecessarily harassed.
So you are the face of the company. They saw your face and tomorrow.
my lord,
My lord,
Hmm? Huh.
because they are announcing the interim,
It's a appellate remedy is available. It's a pending matter.
I thought the direction.
Yes. Hmm. Fresh matter tomorrow.
My lord,
Administrative term has been finished, my lord, and there's a maintenance issue in the society. So we have filed an application regarding that.
House build, apartment, society.
My lord, we have filed a memo. last-
Enough and more judgments have been passed on that. Even then you are insisting on this.
We have filed a memo at the last 2 days back, because listed.
Kodi, it has to be dismissed, aste. Kodi.
my lord, my lord,
Yes, madam.
Your Lordship, the petitioner is in detention with the FRRO, Your Lordship.
Hmm?
And this court,
We can't hear you well.
the petitioner
Hmm?
is detained by the FRRO.
Detained, yes.
Was detained since March. You heard, Your Lordship heard the matter, and the counsel for FRRO was directed to secure instructions because the petitioner is already being tried in Ahmedabad.
There must be a date given in the matter.
Your Lordship, it reached twice, it was listed twice, Your Lordship, and the matter didn't reach. And the next date is on 13th, Your Lordship.
It will be on 13th only, yes.
my lord, this petitioner is a third party to the arbitral agreement, my lord. He has obtained stay on my arbitral award. Basis that, my lord, they have proceeded for e-auction, and now they are set to take possession of the property also, my lord. I have a binding arbitral award in my favor, my lord. This petitioner, who is not even a party to the arbitral award, has obtained stay in this matter, my lord, against the arbitral award, and basis which the e-auction has been proceeded, my lord, and they are yet to take possession, my lord. That is the urgency, my lord. My entire agreement to sale and arbitral award, entire thing will become infructuous, my lord.
Yes.
Kindly.
Next. Fresh matter, pending matter. Huh. Of the society. The society. How is the writ petition maintainable? Kodi, it will come in the regular.
My lord, a date may be fixed in this matter. Kindly.
Yes.
List number 1, page number 5, number 35 to 37. Page number 6, serial number 38 to 40.
Serial number
42.
Yes, my lord.
Therefore,
I'm for the petitioner, my lord.
have you informed the respondents?
Yes, my lord. The senior is not well
No,
today.
and for respondent here in your honor, they have not even informed your honor, please.
I'm the proxy counsel, my lord. Senior is not well today.
We asked you if you are informed. Don't make false submissions.
Apologies.
Never ever do that. That
On
is
last occasion, I said the same thing, your honor.
rejected.
Page number 7, serial number 44 to 47. Page number 8, serial number 48 to 53.
Lordship, serial number 52, your Lordship, for the petitioner, your Lordship, seeking short adjournment, your Lordship.
You inform the respondent?
I am for the petitioner, your Lordship. We have.
You inform the respondent?
Yeah, I have informed.
My lord,
I have informed. I am informed.
42, 52, my lord. My lord, 52, this is that matter, leave India notice, your lordship has given him 1 week's time to decide.
Lordship, the thing is, we have applied for FRR.
He's that Iranian
permission
citizen.
to visit the detention center.
Iranian citizen, my
Sorry.
lord.
Your Lordship, we have got the permission to visit the detention center. We are visiting today. We have got the permission to visit.
We are not
yesterday.
adjourning the matter.
That's a short
Please.
accommodation, my lord.
Sorry, next.
Page number 9, serial number 54 to 58.
58 post before a bench of which SGRJ is not a party.
Page number 10, serial number 59 to 61.
Serial number 59, my lord.
Hmm.
Informed the other side, my lord.
Hmm.
This time may be granted to file objection.
59 at the request of counsel.
Morning I called them.
Inform Madidira Tane. No, we'll go by what you submit. We don't. But when such things happen, yes.
Morning I spoke to the other petitioner.
Then counsel for respond number 1 to 3 seeks for and is granted 2 weeks time to file a statement of objections. Released on 14th August.
Page number 11, serial number 62 to 67.
Milords, serial number 67, Milords.
Yes.
We have filed wakalat for respondent number 2, Milords, but her name is not been reflected. So we got to know in the morning the matter is listed, Milords.
Have you informed the petitioner?
Milords, I undertake to inform them, Milords. My
Sorry.
apologies.
Memo filed infructuous, dismissed as infructuous 66. Yes.
Page number 12, serial number 68 to 74.
Your Lordship, serial number 68, Your Lordships.
Yes. Yes,
I'm
madam.
for the petitioner in the matter. I'm for the petitioner in the matter, Your Lordship. I seek for a short accommodation.
68 at the request of counsel for the petitioner, 14th August, interim order earlier granted is extended till next.
Much obliged, Your Lordships.
Page number 13, serial number 75 to 80.
Lordship, serial number 77, Lordship.
Hmm.
Just for a short accommodation.
Have you informed the respondent?
There is other private respondent also. There is no private respondent.
This
Mr. M. Ananda is appearing for respondent. So without informing, no agenda. Yes. memo.
98 appear for petitioner withdraw.
Memo for withdrawal.
File ಮಾಡಿದ್ದೀನಿ sir.
ಆಯ್ತು. ಯಾವುದು? 93. 93 memo of withdrawal dismissed as withdrawn.
List number 1, fresh matter, serial number 1. Saroja Vicham.
Yes, madam.
Appearing for the petitioner, my lord. My lord, the petitioner in this is a victim, my lord. He is not an accused. Kindly open annexure D, my lord.
Lien of the account.
Yes, my lord.
This is.
My lord, here the account number is the petitioner's account number, but the accused mention is not the petitioner, my lord.
You'll never be the accused. Thankfully, you are not the accused. It's a.
My lord, there's no notification or notice.
Where is that?
Annexure D, my lord. Page number 39, my lord.
39. This is Bangalore.
Due to gross negligence, the name is different, my lord. They have not mentioned the proper name, my lord.
Madam, your account number is mentioned. There's no negligence.
Yes, ma'am.
You may not be the accused, but if the money has come into your account, they mark the lien on it.
My lord, there was two lien, my lord.
Amount 2,50,000, 4,09,000. What have they done now? They marked a lien or they've
They marked lien, my lord.
lien only, not
Yes.
debit freezed. Then you'll have to make an application crime number 716. The criminal proceedings which are pending.
My lord.
There's a criminal proceedings which are pending. For removal of the lien, you'll have to approach that court.
My lord, but he is not involved in the crime, my lord. It was the.
He's the layer 2, man.
He's not involved in the crime, my lord. It was in.
Adam, if money comes into your account, it can be, lien can be marked.
Yes,
Layer 1, layer 2, layer 3, layer 4, they are different transactions. Even if somebody else has transferred it to somebody, please read up on that.
Yes.
So now that there's a proceeding which is pending in 716, you'll have to file an application there for lifting the lien by placing your documents on record. That we can't do here in this matter.
Okay.
We'll reserve that liberty and dispose the matter. And AGA for respond number 1, HDFC.
Francis Xavier.
Francis Xavier for respondent. Petitioner is before this court seeking for the following reliefs. The respond number 1 at vide annexure D dated 4/4/25 called upon the respond number 2 bank to mark a lien for an amount of rupees 2,50,000,000 as also an amount of rupees 4,00,000,000 in pursuance of CN crime PS crime number 716/2024 registered under section 66 bracket C, 66 bracket D, IT Act -2000 and 318 bracket 4 of the BNS Act. Since the police station which had issued the notice under section 94 and 106 is situated within the state of Karnataka, and there is already a crime number registered pending before the reserving liberty to the petitioner to approach the court seized of the said criminal proceedings for lifting the lien. The petition stands disposed.
Serial number 2, Venkatesh S. Arbat.
Hearing for the petitioner.
12th August. Service agilva. 12th August. And AGA for respond number 1 issue emergent notice to respond R2 issue emergent notice to respond number 1 written by 12th August.
Serial number 3,
The petitioner in this case.
Yes.
MEC case dismiss agis.
Dismiss agili.
Condemnation of delay.
Yeah, insurance, United Insurance yaru.
Janardhan Reddy.
Janardhan Reddy for respond
Connected
number
matter
3.
BC Sivanegowda agis. Connected matter is BC Sivanegowda.
BC Shivanegowda. BC Shivanegowda for respond number 3 or panel illidara.
Yes.
Issue notice to respond number 1 and 2. Connect with WP number
3707 of 26. 3407. 3407.
3407 of
26.
26. Birth code.
Serial number 4, Ashwath Reddy.
In this case, I prefer petitioner, my lord.
Yes.
I am challenging annexure G, my lord. Order passed by the tribunal senior maintenance of that the petitioner is a elder member of the family, my lord. He has already contributed his entire income to the family, and he has already constructed the house in the scheduled property, my lord. He has performed the marriages to the sisters and brother,
Yes.
younger brother. But now, due to the accident, he is bedridden, my lord. Now, to deprive the property from the that suitable property, the brother and sisters collusion with the mother, they have filed the petition before the tribunal, my lord. Mother already received the rents from the houses regularly, but petitioner is bedridden, my lord, due to the accident. Still, he is not able to earn and work any this thing. This is the reality, my lord.
Your
Now,
mother
due
is
to
much
the-
older than you. She's 75 years.
My lord.
Your mother has to be taken care of.
No. My mother is already taken rents from the houses.
ಯಾವ
That is the subject property. Property number 10, my lord. That is the subject property of the this present petition, my lord. I am producing that sale deed, my lord, annexure A, and also gift deed executed by the mother, that is annexure B, and impugned order is annexure G, my lord. My mother already executed another property in favor of my sisters and brother, that is the annexure F, my lord.
Yes, that is the problem. They should not do it during their lifetime.
Idರಲ್ಲಿ intention is reason and
That one
different,
is-
my lord. ಅಲ್ಲ ಟು ಡಿಪ್ರೈವ್
Senior citizen act ಅಲ್ಲಿ ಒಂದು
ಅಲ್ಲಲ್ಲ ನಮ್ಗೆ ಅವ್ರು
caution
ತೊಂದರೆ
ಹಾಕ್ಬೇಕು.
ಕೊಡ್ತಾ ಇಲ್ಲ ಆಕ್ಚುಲಿ ಅವರೇ ರೆಂಟ್
So
ತಗೊಂತಾ
you are
ಇದ್ದಾರೆ
doing so at your risk.
ಅವರೇ ರೆಂಟ್ ತಗೊಂತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ therefore I request this honorable
And
kindly
AG accepts notice for respond number 1 and 2, issue notice to respond number 3, returnable by 7th September. Respond number 3 is restrained from any manner alienating, dealing with, or changing the character of the scheduled property, subject property till the next date of hearing.
Much.
Process fee and copies to be furnished by end of day 23rd July, failing with the interim order will stand automatically vacated.
Number 5. Madhusudan.
My lord, I appear for the petitioners.
Yes.
My lord, the petitioners are impugning the judgment and decree passed by the Honorable Trial Court in a partition suit clandestinely filed by the respondents.
Hmm.
And the suit
Where
scheduled
the
properties
plaint-
are the absolute properties of the mother.
Where is the plaint?
My lord, annexure C1 at page 75 onwards.
75. 75 is the order sheet. Where is the plaint? Who are the parties?
My lord, it's at page 41.
40.
41, annexure A2.
You are not a party to the proceedings.
We are not the parties to the proceedings.
What do you have to show that you have interest in the property?
The documents evidencing title, my lord should actually find it at annexure C3 and annexure D.
Page?
Page 85. Annexure C3 is page 85.
85. 85 is an application, Mr. Counsel.
No, it is a compromise decree. It does say between the petitioner husband's family, in which the petitioner one receives Schedule A property in lieu of maintenance. Your Honor.
Where is the petitioner's name here?
My lords, actually, at
87.
page 81 is the plaint.
8790. Where is the plaint in 8790?
At page 81. Annexure C2, my lords.
Your defendant number 5.
Defendant number 5.
Yes, where is the entitlement of defendant number 5 in this compromise?
My lords, page 86. And 88 is
D property is allotted to 5th defendant.
page 88, my lords.
What is Schedule D? You have to be clear, Mr. Counsel. We can't be searching it for you.
I'm sorry, ma'am. Page 88.
So you are allotted survey number 128 bar 2.
Those properties are disposed of. The item B property.
House list number 100. How is that relatable to BBMP Kata 482?
Sorry, my lord.
How is that relatable to the suit scheduled property in this suit?
No. The respondents have clandestinely filed. Respondent number 1 is the daughter-in-law of petitioner 1.
What is your right over the plain scheduled property is what we have been asking you.
By virtue of this partition, the petitioner is actually given this item B property, which is at page 88.
Item D property.
Item B property, yes.
Yes, that is 128 bar 2. That is not subject matter here.
Correct.
Then
And
there
the
is
other
house
property,
list number 100,
correct.
which is not the property here. These are different properties.
No, my lords.
So
Number 6. Yes, Jagan Babu.
Lords, at ink page number 17, Lords, the petitioner is an highest bidder.
Waiting for petitioner.
yes.
challenging the annexure F compromise decree entered before the Lok Adalat. Petitioner father purchased the property in the year of.
Where the plaint in OS number 30? Plaint in OS number 30.
30 of 22.
Plaint ಎಲ್ಲಿದೆ?
Page number 26. Annexure C.
ನಂಜಮ್ಮ ಚಿಕ್ಕನಂಜಪ್ಪ ಮುನಿರಾಜು.
Petitioner father purchased the property in the year of 1978 under registered sale deed. That sale deed was suppressed and compromise decree were entered between respondents.
Where is the sale deed in? That your
It's in
father
annexure A.
purchased? Page number?
Page number 18. Typed copy also furnished in page number 22.
Schedule ಎಲ್ಲಿದೆ?
Schedule survey number 4/2 ಪೈಕಿ 25 ಗುಂಟೆ.
Page number ಹೇಳಿ.
22. Page number 22 of typed copy of annexure A. Para, third para.
Survey 4ನೇ sub number ಪೈಕಿ. Is the encumbrance certificate?
Encumbrance certificate I have not produced. I have produced the sale deed.
Sale deed was long ago. After that, what happened?
I'll produce this sale deed.
Where is?
Encumbrance certificate.
First stage is that. Second is encumbrance, your tax paid. What is the khata of this property? Is it in your name?
Khata what not transferred. On that basis, they have.
ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇರೋದು. Place that on record.
I'll furnish the.
That counsel for the petitioner seeks fund is granted a week's time to place on record the title documents relating to the property subject matter of the suit in OS number 30 of 2022.
22.
When will you produce it?
Next week.
Released on 30th July.
Much.
Serial number 8.
That appear on the petitioner.
Yes.
The order under the Senior Citizens Act, my lord. I am the daughter-in-law. There are 3 other daughters, out of which 2 daughters are working in the police department. So the father-in-law files petition against the daughter-in-law, not making daughters as parties. We make an impleading application and they are impleaded. They also file their objection saying that it is the responsibility of the daughter-in-law to take care because the father was with the
daughter-in-law is not covered under child.
She's not
Children.
covered, but she will come under the relative manner.
It won't be relative also.
There are no direct judgments on that point, my lord, because several matters that was to be considered.
We'll have to issue note, we'll have to stay.
Yes.
The daughter-in-law, son-in-law not
Very well,
covered.
my lord.
And AGA for respond number 1, issue notice to respond number 2 to 7, returnable by 24th August. The operation of the order passed by respond number 1, dated 30/4/2026 in MSC bracket 2 of 2020 stroke 2 of 20 stroke 2 stroke 2026 at annexure A. He stayed till the next date of hearing since the maintenance order has been passed against a daughter-in-law who does not come within the definition of children. Senior Citizen Act of the section, subsection. Under clause A of section 2 or clause G of section 2. Process fee and copy till the next date of hearing. Process fee and copies to be furnished by end of day 23rd July, failing which the interim order will stand automatic vacated.
Serial number 9. Agar NS Iyer.
Yes.
For the petitioner, my lord. The petitioner is the member of the Karnataka Rajyada Saligara Sangha. This society was registered under the Societies Registration Act in the year 1999. This Sangha was established for the welfare of the Saligara community. In the year 2004, the annual general board meeting happened, and in this meeting, the proposal was passed regarding the establishment of Saleh Community Charitable Trust. After the establishment of the Community Charitable Trust, my lord, the rental income, the funds, affairs of the Sangha, and the immovable property belonging to the Sangha was diverted to the trust by the respondent number 7 and 8. Upon noticing the illegal diversion of funds and properties, the complaint was made by the petitioner and the several members of the Sangha on 29/11/2024. Upon considering the complaint,
Madam, all the reliefs that you have sought for are in nature of civil suit. It's a society.
yes, my lord.
We cannot be directing.
My lord, already
all
the
these
order
things
been
here.
passed by the deputy commissioner. It is marked as Annexure A. And also show cause notice was issued under section 27A, Annexure F. And also enquiry report has been submitted by the enquiry officer under section 25. And the enquiry report records the findings of diversion of the funds, mismanagement.
But this court cannot direct all these things that you are seeking for. If you want them to act on the enquiry report, which you are not sought for, we can only direct them to act on the enquiry report.
My lord, I am seeking for
Indirectly asked here. Part of prayer A can be considered.
nearly 2 crores fund has been misused by the respondent number
Current
7.
AGA accepts notice for respondent number 1 to 4. Issue notice to respondent number 5 to 8. Returnable by 7th September. And AGA is directed to secure instruction, make a submission on the action taken pursuant to the enquiry report dated 25/11/2025 and place the same on record.
Much obliged.
Serial number 10.
My lord, I'm challenging the order passed by the KDB, my lord, at Annexure A, my lord.
By the KDB.
My lord, initially this scheduled property in the present writ petition was allotted to an entity called KK Industries, my lord. So lease cum sale agreement was executed by the KDB in favor of KK Industries, my lord. So he fails to utilize that land, my lord. Immediately what he does is that he approaches, KDB issues him a notice to give the land back to the KDB. But he approaches the Honorable High Court with writ petition number 1824/2013, my lord, where stay was granted, saying that you have to pay the amount demanded by the KDB, that is 3 crore 1,88,000 within 45 days, my lord. So he immediately approaches the present petitioner, my lord. He enters into a MOU with me and asks me to pay the amount on behalf of him, KDB, my lord. So that amount was paid, my lord. Again, he fails to develop the land, my lord. Again, again, a notice was issued by the KDB saying that you are not utilized it. He challenges the same, and a writ petition was filed. In that writ petition, the court had directed him to approach the KDB, my lord. Against that, writ appeal was filed. In that, again, the division bench was pleased to direct the petitioner to approach the KDB with respect to submission, my lord. So again, there was failure on part of the KK Industries, my lord, to develop the land. So what he does is that he again challenges the same before the High Court, my lord, and obtains the stay.
Yes.
Meanwhile, I also give representation saying that I have paid on behalf of him. So consider my application also. My
How
petition
can you
also,
be considered?
my lord. What happens is that, my lord, both the writ petitions gets disposed of. Is it in the in the writ petition, my lord? There's during the pendence of the writ petition, my lord, there was a stay. So he gives a letter to the KDB saying that transfer it to the.
What is your locus, Mr. Counsel?
My lord, I'm one of the I'm the MOU holder, man, along with him.
At the most, you are a creditor of KK Industries.
Yes, my lord.
Who is the allottee? KK Industries has violated all the terms
Yes,
for the
my lord.
last 15 years.
My
They
lord,
have
but-
cancelled it thrice.
Yes, my lord.
He has not implemented the
But
project.
during the pendency of the writ petition, my lords, he gives a letter to the KDB to transfer to the third entity. That is Security Ventures, my lord. So what happens is that that was done during the pendency of the writ petition, my lord. So he gives a letter to the KDB to transfer
Where
it.
where is that letter?
My lord,
Where is that letter?
letter, my lord. My lord, it's at page number 271, my lord.
271. Two 71 is not any letter by them. It's the return of files by the council.
My lord, sorry, my lord, 270, my lord. He writes a letter. It is 21/5/2025, my lord. Annexure AR, my lord. And the same was not disclosed to the Honorable High Court also, my lord. What they do is that after submitting this letter, my lord, they they file a withdrawal memo before the court, my lord, suppressing this fact. So accordingly, lease cum sale agreement was executed by KDB in favor of the Security Ventures on base of the letter of KK Industries, my lord. Without informing me, lease cum sale agreement was executed. So that lease cum sale and my writ petition also got disposed, my lord. I approached the KDB. I gave representation to KDB to consider my representation.
What is the representation?
My lord, to allot that land in my favor, my lord, because the amount was paid by me, my lord.
At the most, it's a recovery proceeding that you can have. You
My lord,
can't have
but,
allotment.
my
Allotment
lord,
proceeding, you have to follow the procedure. You can't just
my
by
lord,
giving somebody
that-
a money, you can't
My
get
lord,
it.
representation was disposed on the present speaking annexure has been passed, my lord. But this representation was passed after I approached this honorable court with writ petition, my lord, challenging the lease cum sale deed and sale deed executed in favor of the Security Ventures, my lord. And in that stay has also been granted, which is at annexure AQ, my lord.
Page?
286, my lord. Page number 287, my lord. And that lease cum sale agreement, my lord, during the pendency they execute. And after disposal of the
Who
two
had
petitions, my
appeared?
lord, sale deed was executed within 2 days.
Vasudevan is directed to accept notice for
My
respondent.
lord, in the other petition, my lord, P. Chandrasekhar has been given, my lord. Ma'am, but in the other petition,
Vasudevan
name
is
of,
directed to take notice until
my
that.
lord, it was subsequently
P.V.
allotted.
Chandrasekhar. Shri P.V. Chandrasekhar is directed to accept notice for respondent number 1 and 2. Connect the above matter with WP number 7263 of 23 and WP number 28745 of 23
My lord, not that writ petitions are disposed,
and
my lord. It has to be connected.
8476 of 2026.
The other 7263 is already disposed.
Let the files come. Relist on 6th August.
Ma'am, in the preliminary hearing, my lord.
Yes, next.
Number 11, Kaveri Vinaya.
Here for petitioners counsel.
I1 of 26 is allowed. Yes, Mr. Sridhar.
My lords, the issue involved is award of tender to the second respondent in this.
You are appearing for whom, Mr. Panindra?
Lords, the first respondent, Kaveta,
the employer.
There's a connected matter with the same petitioner at serial number 61.
61.
That is where, my lords, the earlier termination order is challenged. His tender, my lords, he was awarded a contract that was terminated with a debarment clause.
We'll take it up with 61 when if and when it reaches.
Because
My lords-
unless that is decided,
My lords, may I just place two facts before this thing, because the tender has been awarded and it is being now executed, and there is my technical bid is rejected prior to awarding the tender to the second respondent.
On what ground?
That is not disclosed, my lords.
That is what Ms. Panindra said because of your earlier termination.
My lords, no, technical bid, my lords. Earlier termination, if I was blacklisted, on 27/4, I got a stay order where my blacklisting was stayed. After that,
Until that is considered, this cannot be considered.
It is not
So
blacklisting.
If it reaches, we'll consider both.
barring, not blacklisting.
they have not disclosed the, my lords, if I understand now, they are stating that the technical bid is rejected only on the ground of blacklisting.
Will, my lords,
Blacklisting, debarring, or a clause in the contract.
it is debarring. My lords, what happened in the earlier termination order, he was debarred for 1 year for the same product.
Debarring in terms of 26AB or in terms of
The contract.
contractual?
Contract. It's a contractual thing.
We'll have to consider that.
Otherwise, we'll file our, my lords, the tender was awarded, work order is issued, he is supplying already. Can I, my lords, file my counter insofar as this is concerned? That we have filed our counter. In 61, we have filed.
You have
Here,
filed.
the successful tenderer also has to. In 61, we have filed our counter.
61.
Next week.
11 connect with 61. 11 LIA 1 of 26 is allowed. Ms. Manjula D, who has filed caveat for respond number 1, accepts notice for respond number 1. What about respond number 2?
2 is the successful tenderer.
Issue emergent notice to respond number 2. Counsel for the petitioner is also permitted to take out hand summons on respond number 2. Since it is submitted that respond number 2 is carrying out the works on behalf of respond number 1, respond number 1 is directed to inform respond number 2 about the above proceedings.
Please.
And the next date of hearing. Learned Shri K.N. Panindra, learned senior counsel on behalf of respond number 1 seeks for and is granted a week's time to file a statement of objection. Objections, if any, by 31st July, relist on 5th August.
Let's may I request Rachita K to be shown as Srimati Rachita K for caveator 1. I mean, sorry for
Caveat has
respondent.
been filed by Manjula D.
Manjula, the panel advocates. Panel advocates.
Panel, soaps and detergent. Though the caveat has been filed by Ms. Manjula D, Ms.
Rachita K. I will write it and I'll pass it over.
Submit that she would be appearing for respond number 1. Registry is direct, print her name as such and delete the name of Ms. Manjula D as that appearing for respond.
Please.
Serial number 12, H.C. Suramu.
I appear for petition, Lord. Petition, Lord, was issued with a license, my Lord. It's the fourth round litigation after remand order passed by your Lordship, my Lord. The respondents have passed the very same order. I will just tell the brief facts of the case, your Lordship. In 2002, my Lord, the authorization came to be granted, and subsequently, my Lord, that came to be in my favor. That came to be challenged by the respondent number 4, my Lord. That was set aside, your Lordship. However, I must continue to distribute the commodities till today.
May respond number 3.
Respond number 3, my Lord. Now, my Lord, kindly see the earlier order passed by His Lordship Justice Bopanna and then to your Lordship, my Lord. Petitioner had produced the documents to indicate that he possesses his own premises to run faith pay depot, which is a factual aspect to be determined. If in the said circumstances it is found that the petitioner has owned the premises, then the compliance of section 5 of the control order by the petitioner would be more satisfactory than that of the fifth respondent, that is Shivkumar, your Lordship, the third respondent hearing. Fifth respondent, and in such a event, the benefit of priority would not be available to the fifth respondent. This is the order passed, my Lord. Then, my Lord, again the authority, my Lord, passed the very same order, though there was no suit available. It was a residential premises, not standing in the name of the respondent number 3, my Lord. Again, I challenged it, my Lord, before this honorable court, my Lord. My Lord was pleased to annexure H, my Lord, your Lordship's order, your Lordship. Annexure H.
Just.
Page 54. Your Lordship.
Just.
They proceeds
Yes.
only on the
Page.
basis that page, annexure H, Your Lordship, page 54, Your Lordship.
Yes.
Page 54. My Lord, relevant portion of the order will, Lordship will get it, my Lord. Page 83, my Lord. Page 83, my Lord. After quashing the order, my Lord, the matter is remitted to respondent number 1 to consider the eligibility. This is the first one, my Lord. Of the petitioner and respondent number 3 in terms of the observation made herein above and in terms of class 5(1) of the PDS Control Order 1992, which shall be done within 30 days from the date of receipt of a certified copy of this order. This thereafter priority to be applied on the basis of the category of the petitioner and respondent number 3. Annexure H2 pursuant to the order passed by this honorable court. However, I continue to distribute the commodity since 2002 till date, Your Lordship. Mahajar, my Lord, got it in page 88, Your Lordship. Page 88. Second para, I will read, Your Lordship. First para is the joint director, Ellaru Bandidru antadu, pursuant to the order of Your Lordship. ಮಂಜುನಾಥ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿಯ ಪ್ರಕರಣದ ಬಗ್ಗೆ ತಿಳಿದುಕೊಂಡಿರುತ್ತೇವೆ. ಪ್ರಕರಣದಲ್ಲಿನ ಮೇಲ್ಮನವಿದಾರರಾದ ಶಿವಕುಮಾರ್ ಸನ್ ಆಫ್ ಲೇಟೆಸ್ಟ್ ಸಿದ್ದಯ್ಯ ಕಾಳಮ್ಮನ ದೇವಸ್ಥಾನದ ಬೀದಿ ಇವರು ರಮ್ಮನಹಳ್ಳಿಯಲ್ಲಿ ವಾಸ ಇರುವುದಿಲ್ಲ. Kindly note it, Your Lordship. He is a resident of Mysore. He is not residing in Rammanalli. First point. ಸದರಿ ಸ್ಥಳದಲ್ಲಿ ಅವರ ಮನೆ ಇರುವುದಿಲ್ಲ. There is no house, my Lord, in the said area. ಪ್ರಸ್ತುತ ಅವರು ಮೈಸೂರು ನಗರದಲ್ಲಿ ವಾಸವಿರುತ್ತಾರೆ. That I have produced the Aadhaar card, my Lord, along with the writ petition. ವಾಸವಿರುತ್ತಾರೆ. ಕಾಳಮ್ಮನ ಗುಡಿ ಬೀದಿಯಲ್ಲಿ ಶ್ರೀ ಶಿವಕುಮಾರ್ ಅವರ ಸಾಕು ತಂದೆಯವರಾದ ಶ್ರೀ ಲೇಟ್ ಸಿದ್ದಯ್ಯ ಇವರ ಕುಟುಂಬಸ್ಥರುಗಳು ವಾಸವಿರುತ್ತಾರೆ. This is the house which is now shown as a business premises. Next, my Lord, ಮುಂದುವರೆದು ಪ್ರಸ್ತುತ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿ ನಡೆಸುವ ಮಂಜುನಾಥ ಸನ್ ಆಫ್ ಲೇಔಟ್ ಶಿವಣ್ಣರವರು ಲೇಟ್ ಶಿವಣ್ಣ ಇವರು ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿಯ ಅಧಿಕಾರ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಅನ್ನು ಹೊಂದಿದ್ದು ಮಳಿಗೆ ಮನೆ ಹೊಂದಿದ್ದು ಡೋರ್ ನಂಬರ್ 232 ಮಹದೇವಪುರ ಮುಖ್ಯ ರಸ್ತೆಯಲ್ಲಿ. This also relevant, Your Lordship, for the purpose of delivery of the commodity by the loading and unloading of the goods, my Lord. ಇದೇ ಜಾಗ ಮುಖ್ಯ ರಸ್ತೆಯಲ್ಲಿ 15-30 ಅಡಿ ವಿಸ್ತೀರ್ಣದ ಮಳಿಗೆ ಮನೆ ಹೊಂದಿದ್ದು ಸಾಲಿ ನಾವುಗಳು ಇದೇ ಜಾಗದಲ್ಲಿ ಸುಮಾರು 23 ವರ್ಷಗಳಿಂದ ಪಡಿತರ ವಸ್ತುಗಳನ್ನು ಪಡೆದುಕೊಳ್ಳುತ್ತಿರುತ್ತೇವೆ. ಮಂಜುನಾಥ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿ ಸಂಖ್ಯೆ 389ರಲ್ಲಿ ಪ್ರತಿ ತಿಂಗಳು ನಿಗದಿತ ಸಮಯದಲ್ಲಿ ಪಡಿತರ ಎತ್ತುವಳಿ ಮಾಡಿ ನಿಗದಿತ ಸಮಯದಲ್ಲಿ ಪಡಿತರ ವಸ್ತುಗಳನ್ನು ನಿಗದಿತ ಪ್ರಮಾಣವನ್ನು ಎಲೆಕ್ಟ್ರಾನಿಕ್ಸ್ ತೂಕದ ಯಂತ್ರದಲ್ಲಿ ನೀಡುತ್ತಿದ್ದು ಯಾವುದೇ ಲೋಪ ವಂಚನೆಗಳಿಲ್ಲದೆ ವಿತರಣೆ ಮಾಡುತ್ತಿದ್ದು ಸ್ಥಳೀಯರಾದ ನಮಗೆಲ್ಲ ಅನುಕೂಲವಾಗಿರುತ್ತದೆ. ಸೋ ಮಂಜುನಾಥ್ ಅವರ ನಿಯಮಾನುಸಾರ ನಡೆದುಕೊಳ್ಳುತ್ತಿದ್ದು ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿ ಮುಂದುವರಿಸಲು ಸೋ. This is the major.
ಮಳಿಗೆ ಇದೆ, but is it owned by you?
This is my own. I have produced the extract.
Document.
Assessment extract is next, Your Lordship.
The Mazar doesn't say that.
My Lord.
Mazar doesn't say that.
ಸರಿ, ನಾನು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ತೋರಿಸಿದ್ದೀನಿ. ಅವ್ರು ಏನ್
ಡೈರೆಕ್ಷನ್ ಇದ್ದಿದ್ದೆ ಅಷ್ಟು
ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
2 ಸತಿ ಡೈರೆಕ್ಷನ್
ಅಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಷನ್ ಅದನ್ನೇ ಈ ಅಸೆಸ್ಮೆಂಟ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮೈ ಲಾರ್ಡ್ ಮೈ ಕೈಂಡ್ಲಿ ಸಿ ಮೈ ಲಾರ್ಡ್ ರಮನಹಳ್ಳಿ which I have shown my Lord annexure H2 page 90. Page 90, Your Lordship.
Ramnalli
house where I have been running the APD point, Your Lordship. Manjunath bin Batamali, my Lord may kindly see annexure H44 page 90 Batamali, Manjunath son of B late Sivanna. My Lord got it from Batamali. Assessment extract, B register.
Malikara Yesru.
Yes, Your Lordship. My Lord may now kindly come to the Aadhaar card, Your Lordship, to show that premises, my Lord, photographs page 92 is my shop, Your Lordship, annexure H5. Next, my Lord, annexure H6, my Lord, H5 enclosure, my Lord, house belongs to the respondent step father, Your Lordship.
Yes.
And Aadhaar card, my Lord, I have produced, my Lord.
Now, what is the order passed?
Now, order passed, my Lord. Kindly come to the order, Your Lordship. Kindly see page 97 for a moment, Your Lordship. But what I have read, it is stated, Your Lordship. ಮಳಿಗೆ ಹೊಂದಿರುವ ಬಗ್ಗೆ ಪರಿಶೀಲನೆ ನಡೆಸಿ ವರದಿ ನೀಡಿದ್ದು ವರದಿಯಲ್ಲಿ ಕೆಳಕಂಡ ಅಂಶಗಳು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಟಾಪ್ ಅಲ್ಲಿ ಮೇಲೆ
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
97, Your Lordship. ತಾಲೂಕಿನ ಶಿರಸ್ತೇದಾರರು ಖುದ್ದು ಭೇಟಿ ನೀಡಿ ಮಂಜುನಾಥ್ ಬಿನ್ ಲೇಟ್ ಶಿವಣ್ಣ ಮತ್ತು ಶ್ರೀ ಶಿವಕುಮಾರ್ ಬಿನ್ ಲೇಟ್ RP ಸಿದ್ದಯ್ಯ ಅವರ ಸಮಕ್ಷಮದಲ್ಲಿ ಈ ಇಬ್ಬರು ಆಹಾರ ಧಾನ್ಯಗಳನ್ನು ದಾಸ್ತಾನಿಡಲು ಸೂಕ್ತ ಸ್ಥಳಾವಕಾಶ ಮಳಿಗೆ ಹೊಂದಿರುವ ಬಗ್ಗೆ ಪರಿಶೀಲನೆ ನಡೆಸಿ ವರದಿ ನೀಡಿದ್ದು, ವರದಿಯಲ್ಲಿ ಈ ಕೆಳಕಂಡ ಅಂಶಗಳು ಬಂದಿರುತ್ತದೆ. ಲೆಫ್ಟ್ ಸೈಡ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಇಸ್ ಮೈನ್. ಮಂಜುನಾಥರವರ ಪರಿಶೀಲನೆ ಸಂದರ್ಭದಲ್ಲಿ ತೋರಿರುವ ಕಟ್ಟಡವು ಶ್ರೀ ಮಂಜುನಾಥರವರ ಹೆಸರಿನಲ್ಲಿ ಇದ್ದು 15 ಅಡಿ ಅಗಲ ಮತ್ತು 30 ಅಡಿ ಉದ್ದದ ಅಳತೆಯ ಕಟ್ಟಡವಾಗಿದ್ದು, ಈ ನೆಲ ಅಂತಸ್ತಿನಲ್ಲಿ ವ್ಯಾಪಾರ ಮಾಡಲು 10 ಅಡಿ ಅಗಲ 6 ಅಡಿ ಉದ್ದದ ಅಳತೆಯ ವಾಣಿಜ್ಯ ಮಳಿಗೆ ಮತ್ತು ಮಳಿಗೆಗೆ ಹೊಂದಿಕೊಂಡಿರುವ ಅದೇ ಕಟ್ಟಡದ 20 ಅಡಿ ಉದ್ದ 8.5 ಅಡಿ ಅಳತೆಯಲ್ಲಿ ಆಹಾರ ಧಾನ್ಯ ದಾಸ್ತಾನಿಡಲು ಮತ್ತು ವ್ಯಾಪಾರ ಮಾಡಲು ಸೂಕ್ತ ಸ್ಥಳಾವಕಾಶ ಹೊಂದಿರುತ್ತಾರೆ. ಅಡ್ಕ ಸೋ ಅಂಡ್ ಸೋ. ನೆಕ್ಸ್ಟ್ ಮೇಲಾಡ್, ರೈಟ್ ಸೈಡ್ ಮೇಲಾಡ್. ಶಿವಕುಮಾರ್ ಅವರು ಪರಿಶೀಲನೆ ಸಂದರ್ಭದಲ್ಲಿ ತೋರಿರುವ ಮನೆಯು 18 ಅಡಿ ಅಗಲ 45 ಅಡಿ ಉದ್ದ ಇರುವ ಮನೆಯಾಗಿರುತ್ತದೆ. ಈ ಮನೆಯು ಶಿವಕುಮಾರ್ ಅವರ ತಾಯಿಯ ಹೆಸರಿನಲ್ಲಿ ಇರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಇದು ವಾಸದ ಮನೆಯಾಗಿರುತ್ತದೆ.
Yes.
And now, my lord, you passed an order. We belong to a scheduled caste community. Therefore, we are granting authorization.
It belongs to his mother.
My lord?
It belongs to the mother.
No, it is his stepfather, my lord. That's what it was stated, my lord.
Stepfather andre.
No, he is not residing at all, my lord. In the premises, my lord, he is not residing at all. He is residing in Mysore, my lord. I have produced the card also, my lord. May kindly see annexure H3, page 89, my lord. He lives
89
in town. Yes, my lord. In Mysore town. Annexure H3, page 89. Shivakumar. Resides, my lord, Shivakumar. Number 758, first floor, 44/5 E and F block, Ramakrishna Nagara, Mysore. Ramakrishna Nagara. This Ramnalli comes within Pattan Panchayat. Where he lives comes within Mysore Mahanagara Palike. And I have been distributing uninterruptedly, my lord, since 2 to 23 years, my lord, in the premises owned by me and possessed by me. Priority class comes only after, as your lordship observed and as the my lord Justice Bopanna has observed, your lordship. Upon fulfilling the conditions of eligibility, only priority will come. Anybody for that matter.
Yes,
Here,
for whose house is this? ಅಲ್ಲಿ ಸಾಕು ತಂದೆ ಅಂತಾರೆ, ನಿಮ್ಮ ಆರ್ಡರ್ ಅಲ್ಲಿ ತಾಯಿ ಅಂತೀರಿ. ಸಾಕು ತಂದೆ ಅಂದ್ರೆ ಸ್ಟೆಪ್ ಫಾದರ್ ಅಲ್ಲ. And his document indicates that yes, your own ration card.
That is the previous one. We are residing in the same village. We have a Aadhaar card, voter ID.
No, but
this is 2018.
Just one. The ration card issued by your department
only
indicates a different address. These details are available with you.
So you will have to ascertain that. Both of them have given
What do you have to say about this annexure H3?
But before that, my lord, this is the order is under impugned is passed on 19/5/2026. 19/5/2026. After expiry of 30 days, as per section 17, then the order is issued in favor of the respondent number 3 on 4/7/2026. After issuance of the order, my lord, this writ petition is filed on 10/7/2026.
Please explain annexure H3.
H3, my lord, it is in the year 2018, my lord. It is in the year 2018. Subsequently, my lord, they are shifted to the Ramnalli and they have a voter ID, my lord, and Aadhaar card in the Ramnalli village.
Produce the document. Produce it. We'll give you a week's time.
And before that, my lord, Dissanam Court, my lord, my lordship has clarified about the eligibility and the priority. Even that para, may kindly even residential house, like kindly para number.
To that effect, the report has been called for.
Kindly see the
matter is listed today. You will have
75. Kindly see 75.
75.
Matter
this is the core question before Dissanam Court, my lord, in the previous proceedings. My lord, in page number 74 before that, 14.99. Is sufficient to say that if the business of the fair price depot cannot be run in the residential premises as per the zoning regulation, even a residence can be considered as a suitable business premises in respect of the particular residential premises coming under the particular zone. Insofar as the village is concerned, there being no zonal regulation which are applicable and there being no zoning or classification made as regards to residential, commercial, industrial in a separate manner. all the premises come under the common zone irrespective of the use to which the said premises is put to. In view of the matter, I am the considered opinion that insofar as an area where there are no zoning regulations, then even a residential premises being permitted to be used as a business premises can be considered as suitable business premises under subclass B of class 5 of the order of 1982. This being for another reason that if such an interpretation is not given to subclass B of 5 of the order 1982, then no premises in a village would be eligible to be considered to be suitable business premises, since there is no classification of any premises as business premises. Of course,
What is your submission? What do you want to say?
we are residing in the
That is what we are asking. What is the document for that? This is not, this we have to interpret it that way so that any village anybody could do it. That's all.
that is considered by the appellant authority as possible.
The issue is not whether it's residential zone or non-residential zone, because there is no zone. The issue is whether you are resident of or not.
Priority.
For the purpose of priority. If you are resident, then you will get a priority. If you are not, you won't get a priority. But one, firstly, resident. Secondly, that you should own the premises. So if it is owned by somebody else, you won't get the priority. This property is in his name. If it is owned by your stepfather or anybody, you won't get the priority. You should show it in your name. That is the only issue, nothing else.
Apart from you have got now we manage the rental agreement also, we have got the property.
Rental agreement will not give you priority, Mr. Counsel. Please
Yes,
understand that.
Prior to that, my lord, we have property. In view of the matter is seized in the court, my lord.
You show us only two documents or any number of documents for two issues. One, that you are resident in Ramanalli. Two, that you own a premises in Ramanalli. You own a premises. Don't come back with a lease. If you come back with a lease, we'll reject it. That counsel for that AG accepts notice for respond number
1, 2, and 4, Mala.
1, 2, and 4.
Kindly
The
pass
JC
on, my
Kumar,
lord.
who has filed, gave it for respond number 3, accepts notice for respond number 3. He seeks for and is granted a week's time to place on record any and all documents evidencing that respond number 3 is a resident of Ramanalli.
Kindly, I will have a document, my lord. Kindly pass
Next
on.
week, ನಿಮ್ಗೆ ಕೊಡ್ತಾ ಏನು stay ಕೊಡ್ತಾ ಇಲ್ಲ.
I am seeking for stay for the reason I have been distributing the commodity.
In 2 months it has been there.
Like
So
ivaga, let.
nothing will happen in a week,
Produce
Mr.
the bill, your lordship, next H1 page 85, my lord. I have been protected, my lord. This is
I
normal
pass
court.
over.
The order, my lord, it is
Pass over.
issued in subsequent to the.
Yes, your lord.
Pass over.
Please, my lord.
Serial number 13. Naveen, yes.
I seek for next week, my lord. So the advocate on record is not in station today. Seek for next week. Advocate on record is not in
ಏನಿದು?
station.
Assisted reproduction. The assisted reproduction, who is appearing? Sadhana Desai.
Sadhana Desai.
The Sadhana Desai is directed to accept notice for respond number 1 and 2. And AGA for respond number 3. Appropriate authority, you will appear.
This is, Malad, both, Malad, the appropriate authority, there is one state, Malad, Sara and Kara, Malad. Sara is state authority. If they made appropriate authority.
National Assisted Reproductive Technology and Surrogacy Board, the center will appear. Appropriate authority under the assisted reproductive.
Four, I'll take.
4 you will appear. AGA for respond number 3 and 4. Why you made respond number 5 a party?
That's, I think it's a doctor, my lord. So respond number 5 is a doctor.
Notice to respond number 5 is dispensed with for deferred for now. Counsel for the petition furnished 2 sets of the petition along with annexures on the said counsels 53 and 58. Released on 3rd August.
Please.
Serial number 14. Narayan Sene.
Lordship, I appear for the petitioner.
Yes.
The subject complaint 463 of 2021 is pending since 4 years. It was remanded, Lordship, in 2023 June. Again, 3 years is over. Still, it is not heard and disposed of. So, for expeditious decision of maybe disposed of within 1 month or at least.
Very good. One day badwa. Notice to respondents is dispensed with in view of the
May be
proposed order.
permitted to take notice on the their advocate in
ಯಾರಿದ್ದಾರೆ?
MTN associate, MTN
association. You have to give a name.
MTN and VH advocates and associates.
To give a name of a council.
Not able to get it from their lordship. That's a problem. I'll find out. Lordship may mention a council in appearing in the complaint.
Petitioner is permitted to take out notice on the council appearing for the respondent before the second additional, before the Consumer Redressal Commission. Released on 6th August.
I have that.
16, GM Sharat Kumar.
Petition challenging the annexure C, my lordship, endorsement given by the respondent number 3, my lordship. Earlier, my lordship, petitioner approached this honorable court, annexure D, page number 37, my lordship. For mandamus.
37.
Please, annexure D, 37.
Yes.
Seeking mandamus to direct the respondent number 3 implement the order passed by the magistrate court, my lordship. The petitioner filed section 12 for DV Act, my lordship.
Because you had not brought to notice the said order. Now after this, what did you do?
They gave a annexure C endorsement, my lordship.
Did you bring that to the notice of them about the order passed?
Please.
Where was that?
ಅಲ್ಲ ಅದು ಎಂಡಾಸ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅವರೇ ಹೇಳಿದ್ದಾರೆ.
ನಿಮ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಇಲ್ಲಪ್ಪ, ಏನಂತ ಹೇಳಿದಿರ ನೋಡೋಣ.
ನಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅನ್ನಕ್ಷೆ ಡಿ ಪ್ರಕಾರ ಪೊಲೀಸ್ನರಿಗೆ ಕೊಡಕ್ಕೆ ಹೇಳಿದ್ರಿ, ತಾವೇ ಡೈರೆಕ್ಷನ್ ಮಾಡಿದ್ರಿ ಫ್ರೆಶ್ ಆಗಿ ಎಂಡಾಸ್ಮೆಂಟ್ ಕೊಡಿ ಅಂತ ಹೇಳಿ. ಎಂಡಾಸ್ಮೆಂಟ್
May I submit, my lord?
If a proper representation is made accompanied by said order, we'll take immediate action.
ಎಂಡಾಸ್ಮೆಂಟ್ ಕೊಟ್ಟ ಮೇಲೆ ಅವರು ಇಂಬರ್ ಆಗಿ ಕೊಟ್ಟರು.
ಎಲ್ಲಿದೆ ನಿಮ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್? ಎಲ್ಲಿದೆ
ರೆಪ್ರೆಸೆಂಟೇಷನ್? ಅದು ಅನ್ನಕ್ಷರ್ ಮಾಡಿಲ್ಲ ಸರ್.
ಕೊಟ್ಟಿದಿರೋ ಇಲ್ವೋ?
ಕೊಟ್ಟಿದೀವಿ. ಕೊಟ್ಟಾದ್ಮೇಲೆ ಅವರು
I submit, my lord. They have not brought all the facts before this court. If my lords kindly peruse this judgment, my lord, the father-in-law of the son, my lord, matter also pertains to senior citizen, my lord. There was a order passed by this honorable court, my lord, to hand over the property. Son had preferred writ petition, my lord. This court had directed the son to hand over the possession of the property, my lord. That order is executed. These proceedings, my lord, they are not brought to the notice of this honorable court. And earlier, my lord, they had sought for mandamus, and your lordships had passed order in page 36. So, my lord, that order is executed.
I grant the interim order on 22/11/2025, my lordship. Against my husband and my father-in-law, my lordship. In DV Act, my lordship.
There's an order passed here by this court, which you should have brought it to the notice of this court. And without bringing it to notice,
I made a party, my husband and my father-in-law both in DV Act, my lordship.
You are aware of this order?
ನಮಗೆ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ. ಹಸ್ಬೆಂಡ್ ಮತ್ತೆ ಫಾದರ್-ಇನ್-ಲಾ ಇಬ್ರು ಸೇರಿ ನಮ್ಮನ್ನ ಮನೆಯಿಂದ ಹೊರಗೆ ಹಾಕೋದಕ್ಕೆ.
Mr. Counsel, we are there to assist any litigant to get any relief that is permissible. But if a litigant were to try and abuse the process of the court and overreach the orders of this court, we have no option but to take proper action. This suppression cannot do. Will not be accepted. 5-figure cost on your client, deposit with the legal service authority. Petitioner is before this court seeking for the following reliefs. The petitioner had earlier approached this court via WP number 18382 of 26, contending that the respondents had not implemented the ex parte order dated 22/11/25. And AG had, on that occasion, made a submission that there was no representation which had been submitted by the petitioner. If a representation were to be submitted accompanied by necessary orders, the same would be considered. The petitioner is once again before this court, contending that despite the order dated 22nd June 26, no orders have been passed.
I challenge the Annexure C endorsement, my lord.
The endorsement at Annexure C has been issued. A perusal of Annexure C indicates that it is in view of the order passed by a coordinate bench of this court dated 26 February 26 in WP number 30153 of 2025 that the respondents have declined to interfere, have expressed their inability to take any further action on the request made by the oral request made by the petitioner. WP number 30153 of 25 arose out of proceedings under the Maintenance and Welfare of Parents and Senior Citizens Act 2007, wherein the husband of the petitioner had challenged an order passed by the Assistant Commissioner dated 9/7/2025 in MSC number 51 of 23 and order dated 30/12/24 passed by Special Deputy Commissioner in appeal number MAG-4/SC CR:24/2024-25. And this court, considering the various aspects, including the aspect of the petitioner having filed proceeding against her husband and the father in criminal misdemeanor number 197 of 2025, observing that the petitioner and her husband were harassing the senior citizen, including by filing a false case under Section 8 of the Protection of Children from Sexual Offences Act 2012, had directed the petitioner therein, that is the husband of the petitioner, to vacate and hand over the portion of the property subject matter of the said proceedings by 30/5/2026, and further directed the jurisdictional police to intervene and ensure that the senior citizen has the possession of the property. In the teeth of that order having been passed against the husband of the petitioner, and the coordinate bench of this court having come to a conclusion, having more or less come to a conclusion that the petitioner and her husband were acting in concert, the question of filing these proceedings seeking for police help after the implementation of the order passed by the coordinate bench is, in the considered opinion of this court, a gross abuse of the process of this court. A litigant who approaches this court in a genuine manner by disclosing all facts would always be entitled for consideration and grant of such orders as may be permissible. But when litigants approach this court by suppressing facts, more particularly orders passed by a coordinate bench of this court, it is but required for this court to take necessary action against such litigants who have abused the process of court. In that view of the matter, the above writ petition is dismissed by imposing exemplary cost of rupees 1,00,000,000 payable to the Karnataka State Legal Service Authority within a period of 4 weeks from today, that is on or before 24th August. If the said payments are not made by 24th August, said payment of cost is not made by 24th August, the member secretary Legal Service Authority would be entitled to initiate such proceedings as may be necessary to recover the said cost as arrears of land revenue from the petitioner. Not this kind.
16, Venkateshappa.
Mr. Venkateshappa? ಹೇಳಿ.
Petitioner property eco-sensitive journal ಬರುತ್ತೆ ಅಂತ ಬಿಟ್ಟು.
ಏನಪ್ಪ?
ಏನು information ತಗೊಂತೀವಿ ಅಂತ. Government account.
Order
This
sheet.
matter was listed yesterday, my lord. Eco-sensitive zone, my lord.
ಅದು survey
Yes, my
number.
lord, please, my lord.
Correct. Survey number
81/2.
Chikkamudde.
81/2, my lord.
Yes.
Lord, if my lords may kindly peruse the notification in page 57.
Yes.
Lord, it is about monitoring committee, my lord.
Right.
It has to be placed before the monitoring committee, my lord. Now, if my lords may kindly see annexure 1, my lord, which is at page 58. It says, my lord, boundary description of the eco-sensitive zone and Kaveri Wild Sanctuary, my lord.
Around Kaveri Wild.
Please, my lord.
Yes.
If my lords may kindly, the relevant portion, my lord, maybe from 9th line. The then line passes through border villages of Chillandawadi Reserve Forest at 1000 meters distance or complete survey numbers from the forest boundary. Bohalli so-and-so survey number passes through Satunur Mutati Road and Duntur so-and-so survey numbers. Then Chikkumudde, my lord, the survey numbers they have shown.
Yes.
However, my lord, 81/2 is not shown here, my lord.
Correct.
My initial instructions are that, my lord, if my lords may kindly peruse this sketch, my lord, may I?
Yes.
My lord, my instructions are that, my lord, since the said boundary, my lord, for a moment, my lord, even the notification at page number, I beg a pardon, my lord, 61, my lord, Chikkamudde, only a partial village is notified as eco-sensitive zone, my lord,
Correct.
not the entire
Yes.
village, my lord. If my lords may kindly peruse the map, my lord, since the said map, my lord, the boundary falls within the as such, my lord, the notice is issued.
How does it form within the boundary when it is not mentioned?
81/2 is marked there, my lord.
ತುಂಬಾ ಡಿಸ್ಟೆನ್ಸ್ ಅಲ್ಲಿ ಇದೆ ಸರ್.
How can you mark it also?
It passes
Your
through
upper
survey number
portion-
81/2, my lord. The boundary is marked it in the red pen, my lord.
ಹೌದು.
Right hand side, my lord, 81/2 is shown.
82, 84, 85.
Yes, my lord. It passes through the 80, the said survey numbers which are notified in the notification, my lord.
Madam, this and the notification don't match. 48, 47, 46, 30, 29, 27.
At the right hand side, my lord, 81/2 is shown.
ಆಯ್ತು.
They say
You-
that, my lord, it comes within the boundary.
This is a line drawn by your officers. We are
I
not
leave it to
concerned
my
with your line drawn. We are concerned with the notification.
Moreover, my lord, they have challenged the notice. Let them answer.
It is without jurisdiction.
Please,
Without
I leave it to
jurisdiction.
my lord.
Petitioner is before this court seeking for the following leaves. Petitioner is before this court seeking for the following leaves. Aitala. Though the relief which has been sought for is for quashing a show cause notice dated 19/11/25 at annexure F. The ground for seeking for such quashing is that the respondents have no jurisdiction to issue such notice. The notice suffering from foundational jurisdictional error, this court is required to intercede in the matter and quash a show cause notice which would serve no purpose. The notice which has been issued to the petitioner is that the petitioner is alleged to have violated the eco-sensitive zone and set up its business activities And in that background, the petitioner has been called upon to produce documents and explain the same. The petitioner land is the petitioner is the owner of the land in survey number 81/2 of Chikka
Muddude village.
Muddude, MUDUD, Muddude village, and has established his business in the said land. By relying on the notification dated 22nd August 2017, more particularly Annexure 1 thereto, the submission of learned counsel for the petitioner is that the boundary description of the eco-sensitive zone around Kaveri Wildlife Sanctuary, insofar as Chikmudde village is concerned, relates only to survey number 48, 47, 46, 30, 29, 27, 35, 101, and 80. Survey number 81 or any sub-numbers of survey number 81, including survey number 81/2, are not part of the said boundary description. And on that ground is the submission is that no notice could have been issued as so issued by the respondent when survey number 81 is not part of the eco-sensitive zone. Learned AG on instruction has produced a memo along with a sketch indicating a line drawn on around various survey numbers to contend that survey number 81/2 is also a survey number 81, including 81/2, is also part of the Kaveri Wildlife Sanctuary. The said map, which has been sketched,
It's a village
said
map.
village map with the marking which has been produced, expressly is not in conformity with the boundary description of the aforesaid notification. Inasmuch as the said line which has been drawn incorporates and extends to various other survey numbers other than and over and above the notification dated 22nd August 2017. The respondents could have claimed violation only if if the said land came within the purview of the aforesaid notification, not otherwise. Ex facie, the land in survey number 81 not being covered under the said notification, the foundational jurisdictional error committed in the exercise of powers by the respondents, requiring this court to intervene, since no such show-cause notice could have been issued in respect of land which is not part of the eco-sensitive zone in terms of the notification dated 22nd August 2017, there being no other further notification which has been placed on record indicating that 81 is part of the eco-sensitive zone. In that view of the matter, this court passes the following order. Writ petitions allowed, a certiorari is issued. The notice dated 19/11/2025, bearing number so and so at Annexure F, and the consequent memorandum dated 26/12/2025 at Annexure H. The communication dated 29/12/25 at Annexure J, and the communication dated 31/3/26 at Annexure M are hereby quashed.
17, आपकी सजा से बोलता है।
The nice name. Best of 7 ration card holders. My lord. Best of 7 ration card holders. You have only 7 ration cards.
ಅಲ್ಲ ಹೆಸರಿರೋದು ಬೆಸ್ಟ್ ಆಫ್ 7 ರೇಷನ್ ಕಾರ್ಡ್ ಹೋಲ್ಡರ್ ಸೊಸೈಟಿ.
Yes.
My lord finds the impugned order of suspension of the authorization on page 15, my lord. This order is passed by the joint director. Joint director is an appellate authority. And it is on a false complaint stating that
one Mr. Akram Pasha. I have not figured anywhere, nor he is connected with us. Akram Pasha. And they say certain bags, rice bags were lifting from the yard, wholesale godown.
Yes.
On this complaint, my lord, they say that my authorization given to me is suspended. And I have produced the FIR also before the court. My lord finds it at page 49, my lord, annexure J.
Page?
J.
Page?
Page, my lord, 49.
49. Yes.
In 50, my lord finds the name of Mr. Muhammad Akram. He is shown as
Megawda manager.
license holder.
Bharti owner. Bharat. Muhammad Akram Pasha. Yes.
So on the basis of this FIR, they suspend the license or say authorization given to me. And without prior notice to me, nothing of the kind, who is Akram Pasha, or nothing is called upon me to explain. Secondly, authorized authority, my lord finds, is defined on annexure C, page 31.
Page 31.
31, my lord.
Yes.
My lord finds amendment of clause 2, so and so. E, 2E. Authorized authority means the Deputy Director of Food, Civil Supplies and Consumer Affairs, Department of Revenue District concerned in the rural, urban and the informal rationing areas in the district concerned, within bracket, except Bangalore informal ration area, and Deputy Director of the concerned range in Bangalore, informal ration area. This is what applies to us. Now the order is passed, as I just pointed out, from the Joint Director, which is an appellate authority. It is stated in the order that she is exercising the powers under 2E of clause 12. My lord finds it here in the middle. Mishima Valayada Nanu Karnataka Agatya Vastugala ನಿಯಂತ್ರಣ ಆದೇಶ 2016 ರ ತಿದ್ದುಪಡಿ ಆದೇಶ ದಿನಾಂಕ 5/6/2017 ಕ್ಲಾಸ್ 2E ಮತ್ತು ಕ್ಲಾಸ್ 12 ಅಡಿ ಪದದತ್ತವಾದಂತಹ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಬೆಸ್ಟ್ ಆಫ್ 7 ರೇಷನ್ ಕಾರ್ಡ್ ಹೋಲ್ಡರ್ ಸೊಸೈಟಿ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿ ಪ್ರಾಧಿಕಾರವನ್ನು ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ಅಮಾನತು ಪಡಿಸಿದೆ. This 5/6/2017, the notification, my lord, that is where I read the definition of authorized authority. Under annexure C.
Rule 17, they can file
All
review.
this is.
Rule 17 says they can file review petition for the commissioner.
It's without jurisdiction. He doesn't have the authority. Because he also refers to 2E. 2E speaks of only the deputy director. So how does the joint director exercise power? When it's the deputy director alone who can exercise it.
Okay. He can, my lord.
Jurisdiction error will intervene. Otherwise, appellate remedy is there, appellate remedy. And AGI accepts notice for respond number 1 to 4. The impugned order indicates that it has been passed under clause 2E of the amended the Karnataka Essential Commodities Public Distribution System bracket control second amendment order 2017 by the joint director. Clause 2E indicates that the authorized authority would be the deputy director of food and civil supplies. And before the amendment, it was the deputy commissioner of the district concerned in the rural urban area, and the informal area, it was the additional director. Neither in the unamended form nor in the amended form, a joint director is the authorized authority. Hence, the operation of the order dated 16/6/26 at annexure passed by the fourth respondent at annexure A is stayed till the next date of hearing. And AGA to place on record if there is any authorization on part of the joint director to pass such an order. Released on 3rd August.
Please, read.
The petitioner is the RC owner of the vehicle. He entrusted the vehicle to the VRL company with the help of the respondent number 6, who is a relative of the petitioner. He handed over the original document to the respondent number 6 with the hope and take the responsibility of the vehicle. He posed the signature of the petitioner and sold the vehicle, transferred his vehicle to in his name, and he is running, taking benefits of the vehicle. I lodged the complaint in the year 2024. Till date, they have not done anything. When they have sent message of vehicle, seizing of vehicle, kindly take the page number 34 and 35, Lordship. The police have sent the message to me. The vehicle has been seized. When I asked them to, what happened to my vehicle? They no, they were similar.
Where is your complaint?
My complaint is, Lordship. One second. Page number 29, Lordship.
29.
Yes, Lord. Typed copy is 30.
FIR has been registered.
FIR has been registered, Lordship. Several times I approached the police station, then there is no action. Even I sent
My instructions, this
mail
was listed
also.
yesterday also, my lord. They will complete the investigation within 15 days, my lord.
15 days.
Please, my lord. Moreover, it is stalled because, my lord, they are waiting for forensic report, my lord.
When are you going to get the forensic?
That, my lord, they will follow up and get it done within 15 days is my instruction. Your lordship's may
Petitioner is
direct.
before this court seeking for the following leaves. The grievance of the petitioner is that the complaint which had been filed by the petitioner in the year 2024, registered as crime number 337 of 2024 by the Gnanabharati police station, is still pending investigation. And in that background that the aforesaid reliefs have been sought for. And AG on instruction submit that investigation is more or less complete. The investigating officer is awaiting
Please,
the FSL report, which is expected in 15 days time. Thereafter, necessary final report would be filed.
Please,
While the said submission answers the grievance of the petitioner by directing the director, Forensic Science Laboratory, to ensure that there is expeditious
Please.
dispatch of the report
Please.
in the above matter, the petition stands disposed.
One makes submission, Lordship. Vehicle, I am suffering every day. Last vehicle is there, his custody, accused custody. Whether they have seized the vehicle or not.
They have seized and you only have produced. So you'll have to go to the criminal court and file an application.
They have not seized as of now, Lordship. There is no information. Anytime I request.
That's the message that you read out just now. Property
34.
has been seized on May 17, 25 in
They have
connection
seized,
with FIR.
there are similar message has been sent like that they are saying. They are not seized like that. Only they have sent message
Then you'll
in the
have
year
to-
2025, Lordship.
Crime number ನಿಮ್ಗೆ ಹೇಳ್ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ನೋಡಿ PF ನಮ್ಮ ಇದೆಯಾ ಅಂತ.
Please. Oblige.
19. Manoj here.
Petition in this matter.
Yes.
But this matter is Mullahs, the defreeze and to mark D lien Mullahs. My account has been freeze Mullahs and marked lien.
By?
The allegation Mullahs against me is Mullahs that I have taken a fake input Mullahs of the tax. 35(3) notice has been issued.
Annexure A.
Page 39 Mullahs, annexure. In fact, Mullahs, there is no transaction between the said enterprise and the alleged accused Mullahs. The reason that
Lien
my
mark,
lord-
it's not a debit freeze, it's a lien which
Lien
has
mark,
been
my lord,
marked.
lien mark, my lord.
So now the proceedings are pending.
Please, my lord.
Pending.
You'll have to approach that court. In a writ petition, we can't do this.
I seek instruction, one accommodation may be granted.
In
my lord.
accommodation,
Proxy
may
counsel, my lord, I-
we'll permit you to approach the concerned. Petitioner is before the land AG accepts notice for
Maybe taken
respondent
up
number.
tomorrow, my lord, kindly, my lord, I seek instruction.
Petitioner is before this court seeking for the following leaves. The a lien has been marked in respect of the petitioner's account by the respondent, which is a criminal proceedings. How criminal
Proceedings in
proceedings?
that, this one, my lord, crime number. It's demand regard to
633/25 minutes.
CRM.
Elide, page number?
FIR is at 46, my lords.
FIR 633 of 2025. Annexure F.
In connection with crime number 633 of 225 registered by Kadugodi Police Station on 18/12/2025 for various offences as indicated therein. The lien having been marked and reported to the said court, it is always available for the petitioner to file necessary application before the court seized of the said proceedings for lifting of the lien. With the above liberty, petition stands disposed. I 1 of 26 allowed.
Petitioner. First petitioner's running.
Spa matter. When is the spa matter? Ivathe idea. Paso.
Please.
You're filing that policy today.
I beg your pardon?
Spa, the policy,
Yes, my lord.
230, na?
It may be taken, my lord. I'll secure.
Paso.
21. Sandeep Lalit.
May I please?
Yes.
Lord, challenges to the proceedings under the.
Respondent is led by the ASG, my lord. He's on his legs in another court. It's the DRDO land, my lord. It's on the Public Premises Act.
Paso.
Please.
22. Hariprasad.
China is manufacturing the sprinkler and other materials, my lord.
Hmm.
In Pradhana Mantri Yojana, your lordship may kindly see annexure D in page number 50.
50.
50.
Yes.
Relevant to para, my lord,
Hmm.
at 86, page 86.
86.
17(4), my lord, regarding any violations on all these things. 17(4). Fourth time, same year, a show cause notice may be issued to the company and the case may be referred to SLSC for delisting the company for a period of 1 year or more decided by SLC. This is the state committee. Now your lordship may kindly to annexure J in page number 139.
Hmm.
Annexure J.
Yes.
In last paragraph, my lord, in page 141.
Hmm.
ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ 24 ಸಾಲಿನ ಕೇಂದ್ರ ಸರ್ಕಾರದ PMG ಕಾರ್ಯಕ್ರಮದ ಮಾರ್ಗಸೂಚಿಯಲ್ಲಿ ಇನ್ ಕೇಸ್ ಆಫ್ ವೈಲೇಷನ್ ಇನ್ ಫೈಲ್ಯೂರ್ ಟು ಕ್ವಾಲಿಟಿ ಕಂಟ್ರೋಲ್ assurance and to provide maintenance after sale service, there is a provision item number 17/34 what I read, my lord, from fourth time the same year a show cause notice may be issued to the company and the case may be referred to SLC for listing the company for a period of 1 year or more decided by the SLC. That is the provision, my lord. Then the next part. ಆದ್ದರಿಂದ ಮೇಲೆ ವಿವರಿಸಿದ ಕೇಂದ್ರ ಸರ್ಕಾರದ ಸೂಚನೆ ಪ್ರಕಾರ 4ಕ್ಕಿಂತ ಹೆಚ್ಚಿನ ಗುಣಮಟ್ಟ ನಕಾರಾತ್ಮಕವಾಗಿ ವರದಿಗಳು ಬಂದಲ್ಲಿ ಸದರಿ ಕಂಪನಿಯ ನೋಂದಣಿಯನ್ನು ರದ್ದುಪಡಿಸಲು ಡಿಲಿಸ್ಟಿಂಗ್ ಮಾಡುವ ಬಗ್ಗೆ SLC ಸಮಿತಿ ಸಭೆಯಲ್ಲಿ ವಿಷಯ ಮಂಡಿಸಿ ಸಭೆಯ ತೀರ್ಮಾನಕ್ಕೆ ಕ್ರಮ ವಹಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಅಲ್ಲಿವರೆಗೆ ಮೆಸರ್ಸ್ ಮೇಘಾ ಎಗ್ರೋ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಕಂಪನಿ ಸಂಬಂಧಿಸಿದ ಹಸಿರು ಛತ್ರಾಂಶದಲ್ಲಿ ಈ ದಿನಾಂಕದಿಂದ ಯಾವುದೇ ಬಿಡ್ಗಳನ್ನು ಹಾಗೂ ಕಾರ್ಯಗಳನ್ನು ನೀಡದಂತೆ ತಡೆ ಹಿಡಿಯಲು ಕ್ರಮ ವಹಿಸಲು. Yes, no jurisdiction at without jurisdiction. Because of this order, my entire order, everything is.
Suspension has to be made, it has to be done by SLSC.
Yes.
Not by
this. They will not furnish the file.
Stay ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ, ವರ್ಕೇ ನಡೀತಾ ಇಲ್ಲ, ಯಾವುದು ಇದು ಕೊಡ್ತಾ ಇಲ್ಲ.
Not got the file.
And AGA accepts notice.
ಆಮೇಲೆ ಶೋಕಾಸ್ ಇದರಲ್ಲೇ ಇದೆ, ಶೋಕಾಸ್ ನೋಡಿ ಕೊಡಿ, ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಆಫ್ ನ್ಯಾಚುರಲ್ ಜಸ್ಟಿಸ್ ಹ್ಯಾಸ್ ಟು ಫಾಲೋ ಔಟ್, ಅದನ್ನು ಮಾಡಿಯೇ ಇಲ್ಲ.
1 to 5, petitioner is before this court seeking for the following leave.
ಅದು ನ್ಯಾಚುರಲ್ ಜಸ್ಟಿಸ್ ಫಾಲೋ ಮಾಡಲಿ ಸ್ವಾಮಿ, ಅದನ್ನು ತಾವು ಅಬ್ಸರ್ವ್ ಮಾಡಿ ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟು.
SLSC will have to do that. The petitioner was registered under the per drop more crop scheme, PDMC scheme. Respondent number 2, while the impugned order dated 7/7, which is a centrally sponsored scheme. Respondent number 2, while order dated 7/7/26, while referring the matter relating to delisting of the petitioner to the, what is the full form of SLSC? Full form, Mr. Prasad.
Page 86.
86 ಅಲ್ಲಿ SLSC ಅಂತಿದೆ. There must be a full form somewhere.
State committees.
ಏನಪ್ಪ ಫುಲ್ ಫಾರ್ಮ್ ಹೇಳಿ. SLSC ಅಂದ್ರೆ ಆಮೇಲೆ ಸ್ಟೇಟ್ ಲೆವೆಲ್ ಸ್ಯಾಂಕ್ಷನಿಂಗ್ ಕಮಿಟಿ bracket SLSC for delisting of the company for a period of 1 year in terms of clause Roman 4 of item number 17.3 of the operation guidelines. Clause 17.3, page 86, is reproduced hereunder for easy reference. A perusal of subclause 4 of clause 17.3 would indicate that if there is a violation in respect of failure in quality control and quality assurance and providing maintenance and after sales service, for the 4th time in the same year, a show cause notice may be issued to the company and the case may be referred to the SLSC for delisting the company for a period of 1 year or more as decided by SLSC. The decision is not that of the director but of the SLSC. The director could at the most have referred the matter to the SLSC and it is for the SLSC to have taken necessary action, pass necessary orders and take necessary action. In that view of the matter, this court is of the considered opinion that the director could not have suspended the registration of the petitioner while referring the matter to the SLSC. Once a reference is made to the SLSC, it is for the SLSC to consider whether there is any suspension order to be passed and or what penalty is required to be imposed. In that view of the matter, this court passes the following order. Writ petition is allowed. A certiorari is issued. The impugned order dated so and so at annexure 7/7/26 at annexure J, passed by second respondent, is set aside. Now that the matter has been referred to the SLSC, it would be for the SLSC to take such decision as may be necessary in accordance with the applicable.
ಆಮೇಲೆ ಹಿಯರಿಂಗ್ ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ, ಈ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಬೇಕು ಮೊದಲು.
ಇದರಲ್ಲಿ ಹಿಯರಿಂಗ್ ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಇದೆ,
ಎಲ್ಲಿದೆ?
ಇದರಲ್ಲೇ ಇದೆ, ಪಾರಾಗ್ರಾಫ್ ನಂಬರ್ 85.
ಎಲ್ಲಿದೆ?
85 ನಲ್ಲಿ 17(1), 71, 72. Due process where the show cause no issued, the adequate time allowed for response allowed, and the MI company will as the benefit shall be adequately heard and natural
Following
justice.
due process
Due
in
process.
clause 17.
That's clause 70. ಅದು ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ ನಮಗೆ.
ಅದೇ ಹೇಳಿದೀವಲ್ಲ.
Much obliged.
Yes, Puneet.
55 of the KP Act. For KP Act, Milord, extended orders. Milord, 2021, please, Milord, your lordship may kindly peruse my synopsis for a moment. 2021, please, Milord, he was implicated in a crime. Milord, in a 302 offense as an accused number 13, please, Milord. Subsequently, in the year 2023, another crime, Milord, for 399 and 402.
Yes.
Milord, from 2023.
That is not, we are not considering you on merit. Have you been given an opportunity?
Milord, yes, Milord, I appeared before the lordship may kindly peruse for a moment, Milord, the order sheet at page 30. Milord, page 31, Milord, is the order of issuing notice on 20/2/2026. Milord, immediately on page 32, please, Milord, I appeared and I requested, please, Milord, not to pass any orders since I am not involved in any of the offences concerned. Matter got adjourned to 27/2/2026. Next page, Milord, page 33. Milord, and the matter was posted, Milord, for orders on 4/3/2026 is concerned. Milord, on 4/3, please, Milord, the matter, Milord, takes up and he produces a document marked as exhibit P1 to P3. But please, Milord, in the previous date, please, Milord, the matter was posted for orders. Milord, read this particular portion, Milord, page 33. ಈ ಪ್ರಕರಣದ ಅಂತಿಮ ಆದೇಶಕ್ಕಾಗಿ ದಿನಾಂಕ 4/3/26ಕ್ಕೆ ಮುಂದೂಡಿದೆ. And Milord, and on the day of passing of reserving the orders, please, Milord, documents is marked as exhibit P1 to P3 is concerned. And Milord, an order is passed. Even otherwise, please, Milord, your lordship may kindly appreciate the show cause notice. So, ದಯವಿಟ್ಟು ಒಂದು ನಿಮಿಷ, whether Milord he has a jurisdiction ಅನ್ನೋದಕ್ಕೆ ಒಂದೇ ಒಂದು ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ ಸರ್.
ಹೇಳಿ.
Milord, page 19, the show cause notice. May I read this, please, Milord?
Yes, read.
Milord, ಎದುರುದಾರರಾದ ನಿಮ್ಮ, Milord, I am reading from below 4th line. ಎದುರುದಾರರಾದ ನಿಮ್ಮ ವಿರುದ್ಧ ಪೀಣ್ಯ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಕೊಲೆ ಮತ್ತು ದರೋಡೆ ಯತ್ನದಂತ ಗಂಭೀರ ಸ್ವರೂಪ ಪ್ರಕರಣಗಳಲ್ಲಿ ಭಾಗಿಯಾಗಿ ಈ ಆಸಾಮಿಯು ನ್ಯಾಯಾಲಯದ ಜಾಮೀನಿನ ಮೇಲೆ ಬಿಡುಗಡೆ ಹೊಂದಿದ್ದರೂ ಸಹ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನೀಡಿದ ಷರತ್ತುಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿ ಪುನಃ ಅಪರಾಧಗಳಲ್ಲಿ ಭಾಗಿಯಾವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. Milord, if this being so, please, Milord, they are entitled to seek for cancellation of my bail is concerned.
Yes.
As I already pointed out, please, Milord, 2021 to 2023, 2 offences, please, Milord, which have been falsely implicated. In fact, in the first offence is concerned.
Whether it is falsely or not will be decided by the court,
Alla,
not by you.
Please, Milord. Milord, adralli first case alli, Milord, witnesses have turned hostile is concerned.
We don't know anything about it. We are not dealing with those matters.
Please, Milord.
That would be decided by the, you have been given an opportunity of being heard. You have participated in the proceeding.
4/3 nalli, Milord, they mark the documents as exhibit P1 to P3 when the matter was posted for orders is concerned.
ಅದಾದ್ಮೇಲೆ you have argued.
I have not heard ಅದು absent ಅಂತ ಬರ್ತಿದ್ದಾರೆ.
ಅರ್ಜಿದಾರರು ಹಾಗೂ ಎದುರುದಾರರು ವಾದವನ್ನು ಆಲಿಸಿದೆ.
ಅಲ್ಲ 4/3 ನಾನು ಅಪಿಯರೇ ಆಗಿಲ್ಲ. That is what they say. Please, Milord, kindly for a moment ಇಲ್ಲಿ ನಾನು ಅದು ತೋರಿಸ್ತೀನಿ ಸರ್. 4/3 ನಲ್ಲಿ ಪೇಜ್ 34 ನಲ್ಲಿ ಈ ದಿನ ಪ್ರಕರಣ ವಿಚಾರಣೆಗೆ ಕರೆಯಲಾಯಿತು. ಎದುರುದಾರರಾದ ಸಂತೋಷ್ ಅಲಿಯಾ ಸಂತೋ ನೆಲಗಡೆ ಈತನು ಹಾಜರಾಗಿರುವುದಿಲ್ಲ. I was told that, please, Milord, on 4/3/2026 the matter is posted for orders on 27/2/2026.
Yes, ಆಲಿಸಿದ್ದು is the earlier argument, not that day. He
But
did
my
not
lord,
have the
this-
opportunity to make his
The submission is that, my lord, opportunity was given, my lord, and
No, opportunity was given earlier. But thereafter on 4/3/26, when you mark these 3 documents, he did not have an opportunity to either cross-examine or make a submission in respect of those documents.
And also, my lord, the complainant was also not present.
We'll remand it to that stage of 4/3/26.
please,
And from 4/3/26, you can.
please.
My submission and ಒಂದೇ ಒಂದು apart from this, my lord, apart from this, my submission, my lord, 129 you have, my lord, executed a bond also.
Don't convert this court into an appellate court.
Please, my lord.
This court is being converted into Tahsildar court, Assistant Commissioner court, every
Please, my lord.
court. Don't do those things. Because the genuine matters cannot be taken now.
Please, my lord.
Wherever you have the appellate remedy, go there.
Please, my lord.
And AGA accepts notice for respondent number 1, 2, 3. The grievance of the petitioner is that an externment order has been passed under section 55 of the Karnataka Police Act 1963 without providing adequate opportunity to the petitioner. Inasmuch as though earlier a notice had been issued and the petitioner had made his submissions, matter was posted for orders on 4/3/26. When considering that the matter was posted for orders, the petitioner did not appear. However, on that day, 3 documents were marked and the impugned order passed. In the considered opinion of this court, the above would indicate that insofar as the marking of the documents are concerned, the petitioner did not have an opportunity to make his submissions in relation thereto. And in the absence of the petitioner, which has been noted in the order sheet dated 4/3/26, the marking having occurred and subsequently the impugned order having been passed, the said order is in violation of the principles of natural justice. As such, this court passes the following order. Writ petition is partly allowed. The order dated so and so at annexure
4/3/26.
4/3/26 and annexure A is set aside. The matter is remitted to respondent number 2 for consideration from the stage that the matter was on 4/3/26 by providing opportunity to the petitioner to make his reply in respect to the documents which are produced and marked on 4/3/26. Hear the petitioner on those documents and pass necessary orders in accordance with law.
Permitted to file reply also, my lord.
The petitioner would be at liberty to file any reply or any objection in writing in respect of the documents which had been so produced.
24, Varun Tripathi.
I appear for the petitioner in this matter, Your Lordship. The petitioner filed OS number 2172 of 2026 on 26/3/2026, Your Lordships, which subsequently was disposed of as parties had arrived at a settlement and a compromise decree was issued, Your Lordships. Your Lordships may kindly come to page number 29, annexure B. The City Civil Court addresses a letter along with the copy of the decree to the registrar, sub-registrar Bangalore, stating that the decree has to be registered. For which, at page number 30, annexure C, the respondent number 3 issues an endorsement. Your Lordship may be permitted to read. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖದನ್ವಯ ತಾವು ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಉತ್ತರಹಳ್ಳಿ ಹೋಬಳಿ ರಘುವನಪಾಳ್ಯ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 39/3 ರಲ್ಲಿ ನಿವೇಶನ ಸಂಖ್ಯೆ 4 ವಿಸ್ತೀರ್ಣ 1200 ಚದರ ಅಡಿಗಳ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಗೌರವಾನ್ವಿತ ಸಿಟಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಪ್ರಕರಣ ಸಂಖ್ಯೆ OS 2172 ಆಫ್ 2026 ರಂತೆ ಪಾರ್ಟಿಷನ್ ಮಾಡಿ ನೋಂದಣಿ ಮಾಡಲು ಆದೇಶಿಸಿರುವುದರಿಂದ ಸದರಿ ಪಾರ್ಟಿಷನ್ ಅನ್ನು ನೋಂದಣಿ ಮಾಡಲು ಕೋರಿರುತ್ತೀರಿ. ಅದರಂತೆ ಈ ಕಚೇರಿಯಲ್ಲಿ ಎಲ್ಲಾ ದಸ್ತಾವೇಜಿನ ನೋಂದಣಿಯು ಕಾವೇರಿ 2.0 ತಂತ್ರಾಂಶ ಮುಖಾಂತರ ನಡೆಯುತ್ತಿದ್ದು, ತಾವು ಕಾವೇರಿ 2.0 ತಂತ್ರಾಂಶ ಸಿಟಿಸನ್ ಲಾಗಿನ್ ನಲ್ಲಿ ಈ ಆಸ್ತಿ ಈ ಖಾತಾ ಮುಖಾಂತರ ಅಪ್ಲೋಡ್ ಮಾಡಿ ನೋಂದಣಿ ಮಾಡಬೇಕಾಗಿರುತ್ತದೆ. ಆದುದರಿಂದ ತಾವು ರೆಸಿಡೆನ್ಷಿಯಲ್ ಸೈಟ್ ಫಾಲನ್ ಟು ದ ಶೇರ್ ಆಫ್ ಪ್ಲೇಂಟಿಫ್ ಸುಹಾಸ್ ಬಿ ರವರಿಗೆ ಬಂದಿರುವ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಉತ್ತರಹಳ್ಳಿ ಹೋಬಳಿ ರಘುವನಪಾಳ್ಯ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 39/3 ಯಲ್ಲಿ ನಿವೇಶನ ಸಂಖ್ಯೆ 4 ವಿಸ್ತರಣ 1200 ಚದರ ಅಡಿಗಳ ಸ್ವತ್ತಿಗೆ ಪ್ರತ್ಯೇಕವಾಗಿ ಈ ಆಸ್ತಿ ಈ ಖಾತಾ ಮುಖಾಂತರ ಕಾವೇರಿ ತಂತ್ರಾಂಶದಲ್ಲಿ ಅಪ್ಲೋಡ್ ಮಾಡಿಕೊಂಡು ಬಂದಲ್ಲಿ ದಸ್ತಾವೇಜಿನ ನೋಂದಣಿ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಕೈಗೊಳ್ಳುವುದು ಎಂಬ ಮಾಹಿತಿಯನ್ನು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. Lordships, now the practical difficulty is in the Kaveri app that option does not come, Your Lordships. Court decree.
This is a site, my lord. This is not particular. These are sites, my lord. They are partitioned certain. They have to get a khata.
A khata barutte. Now the contention that is saying is there is no sale deed, lease agreement, lease deed, all those things are there. What the submission of Varun is that there is no option to select a court decree.
Decree has to be uploaded.
No, my lord, that decree has to be registered, my lord.
To register that also e-khata is required.
That is the case, my lord. They made the
They were
VVP
putting
also.
the cart before the horse or horse before the
It
cart.
is a peculiar. Well,
Both
it's a
ways
peculiar,
the
no, no,
same.
it is a peculiar condition, even I understand. my lord. These kind of difficulties, my lord, because of this Kaveri 2 arising. my lord.
Right, now you got this problem, how do you solve it?
I will accept notice, my lord. And also BBMP also is, they have made BBMP also a party. So they are the authorities who have to
Issue the kata.
Kata and also integrate it with our website Kaveri 2. Now, my lord, e-asti and they have to get integrated. Automatically, once it is integrated, automatically it will be done.
You'll
Now
have
that
many
will-
problems, but each problem that it comes up, you have to go.
We will.
This matter had come up for consideration before this honorable court in another matter, your lordships. Page number 31 onwards, that judgment have produced, your lordship.
But in that judgment, my lord, your lordship may kindly see it.
What had happened was a specific performance suit was filed and then it was decreed and execution was filed. The judgment debtor did not come and appear before the court. Then the court sale deed was issued. That was not registered and e-kata was not issued in that matter, your lordships. That matter, certain directions were issued to the state government, your lordships. May kindly, the directions, your lordships will,
But e-kata is not issued by a sub-registrar.
it is not registered.
No, my lord,
He has to register the decree.
the facts of that case, my lord, where the coordinate bench has issued. In that case, my lord, I will, I was part of a petition where we dealt with this. My lord, the banks are facing this problem, my lord. When there is an auction under the SARFACI, the bank executes a sale certificate. Now, the previous kata stands in the name of the default.
This was a specific performance.
Specific performance suit. Then an execution was filed,
Not
not relating to this one.
No, no, my lord. What happens is, my lord, similarly in this case, my lord, a defaulter, assumingly, my lord, the defaulter's name, the kata is there. He does not turn up to execute the document. What happens is, my lord,
These facts are completely different.
completely different. No, my lord, to resolve
This
this
is-
issue, my lord, at that point in time,
This is where there was arrears of property tax and e-kata was not issued. Here there is no such arrears, but direction has been issued to sub-registrar. The BBMP has to issue the e-kata. So e-kata, for that, how do we bridge this gap between registration and e-kata issuance is the
that's what, my lord,
issue.
as far as the banks, my lord, they said bank can get a time khata, my lord, transit khata kind of a thing was allotted for the banks. So once the bank, bank's name will have for a short period between the period of the registration of the sale certificate, enabling them to upload the document. If similarly, that can be done, my lord, we can
Give us this one, we'll make it part of the order so everybody will get to know.
Please.
that notification
can
will share
follow
with my
it.
learned friend regarding the SARFACI part. This one I will get the instructions. The
And
BBMP
AG
also has
accepts
to.
notice for respond number 1, 2 and 3. Shri Pawan Kumar is directed to accept notice for respond number 4 and 5. Counsel for the petitioner to serve 2 sets of the petition along with annexure on the said counsels. The above matter gives rise to a peculiar situation inasmuch as a partition having been effected and a particular plot being required to be registered in the name of the petitioner. The submission of learned counsel for the petitioner is that e-kata has not been issued by the BBM, by the GBA, and without e-kata being issued, the sub-registrar is not registering the property. The reason why the e-kata has not been issued is since there is no registration of any document in the name of the petitioner. This becomes a classic chicken or egg story, which requires to be resolved by both the state and the GBA. The Chief Commissioner of the GBA and the Inspector General of Registration and Stamps are directed to consider this issue and come up with a solution and file an affidavit in that regard by next date. Released on 10th August.
24, 25, 27 and 28 all same, different site
24.
numbers.
25, 26, 27.
Not 26, 27 and 28.
26 illa, 28. Connect to each other, same order.
Please.
Serial number 26, Vinay Swami.
Yes, Vinay.
It's the mandamus that I'm seeking. My lord, I seek for eviction of the.
And this filing is not like this. Part of it you are done. This is like a folder and use a shoelace. This is an hybrid what you have done.
We'll implement from the next.
If you want to stick this on the folder, you can stick it.
No, it's the old filing. I'll implement the new filing.
Old filing. 17 July.
That's what.
Yes.
IOC was running a petrol bunk in my premises. I seek for ejectment of IOC after 20 years. And I get a decree against that. They prefer an appeal before this court. The court says.
What is your representation?
Representation is to take out their petroleum products, diesel products and gas, which is there in the suit schedule premises, my lord. I have taken possession of the property. But those dangerous petrol, diesel is kept vacant. I have locked the premises.
Use it. They don't want it.
PESO has some directions. They can respond.
IOC yaru.
Kavita Damodaran.
Girish Kodgi. Girish Kodgi is in appearing in the trial court.
Illi Kavita Damodaran for respond number 1. Shri Shanti Bhushan is direct to accept notice for respond number 2. Counsel for the petitioner serve 2 sets of the petition along with annexures.
R2 he can.
R2. You appear for R2.
Yes.
So and so submit that you would appear for respond number 2. Registry's direct print his name as such. Counsel for the petitioner serve 2 sets of the petition along with annexures on the said counsel. Counsel for respond number, who has to remove it? Respond number 1.
Yes, madam. IOC has to remove.
The counsel for respond number 1 is direct to secure instruction and make his submission as to by when the products of the respond number 1 situated on the property of the petitioners would be removed. Counsel for respond number 2 is also direct secure instruction, make a submission as to what are the steps to be taken by respond number 1 before such removal. For such removal, for such removal. Relist on 6th August.
At 2:30.
It will come in preliminary hearing. Yes.
29, R.K. Mahadeva.
Externment without giving any notice.
Externment.
Externment without
Have
giving
been
any
heard?
notice. First, the attached to the court, page number 25, my lord. But first one extension ಮಾಡ್ತಾರೆ, page number 25. 26 first para, my lord. Page number 26 first para. Petitioners filed a criminal revision petition 28/11/25 ನಲ್ಲಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತಾರೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ grant stay till the disposal of the petition. On 2nd July, page number 30, my lord. Operative portion of the order, there is no jurisdiction ಅಂತ dismiss ಮಾಡ್ತಾರೆ. Page number 30, the petitioner filed the petition, dismiss, has no jurisdiction ಅಂತ.
What did you file? Challenging what?
External pattern ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ, 25/11 ಮಾಡ್ತಾರೆ, ಅಲ್ಲಿ jurisdiction ಇಲ್ಲ ಅಂತ ಸ್ಟೇ ಕೊಟ್ಟು ಮೊನ್ನೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. Page number 30, no jurisdiction ನಮ್ಗೆ ಬರೋದಿಲ್ಲ.
Note this one because you had filed under 438. Your remedy is under 59.
Yes, ಅದರ ಅದನ್ನ ಅಲ್ಲಿ ಮಾಡಿ ಅಲ್ಲ ಆಯ್ತು. ಇಲ್ಲಿಗೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಮೊನ್ನೆ ಇನ್ನೊಂದು ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ ಸರ್, ಅದು ನೋಟಿಸ್ ಕೊಡದೆ ಇನ್ನೊಂದು ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ. Page number 16.
16.
Page number 16 annexure 14/7 ನಲ್ಲಿ ತಿರುಗಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ತಿರುಗಿ ಬಳ್ಳಾರಿ ಕಳಿಸ್ಬಿಡ್ತಾರೆ ಸರ್. ಏನೂ ಇಲ್ಲ, ನೋಟಿಸ್ ಇಲ್ಲ, ಏನೂ ಇಲ್ಲ. 2019 ಒಂದು ಕೇಸ್ ಇದೆ, ಯಾವುದೂ ಕೇಸ್ ಇಲ್ಲ, ಏನೂ ಇಲ್ಲ. ಒಂದು ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ, ಅದು ಪೆನಾಲ್ಟಿ ಕ್ಲಾಸ್ 5 ಕೇಸ್ ವಿತೌಟ್ ಗಿವಿಂಗ್ ಎನಿ ನೋಟಿಸ್ 14/7 ನಲ್ಲಿ.
Page 21 may kindly be perused, my lord.
Yes.
Paragraph 2, my lord.
ಮೇಲ್ಕಂಡ ಎಲ್ಲ ವಿಷಯಗಳು.
ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಅಂಶಗಳು ಆಧರಿಸಿ ಕರ್ನಾಟಕ ಪೊಲೀಸ್ ಅಧಿನಿಯಮ 1963 ಕಾಲಂ 55 ಅಧಿಕಾರದ ಅನ್ವಯ ಮೈಸೂರು ನಗರದಿಂದ ಅಪರಾಧಿಗಳನ್ನು ಯಾಕೆ ಗಡೀಪಾರು ಮಾಡಬಾರದು ಎಂಬ ಬಗ್ಗೆ ಖುದ್ದಾಗಿ ಹಾಜರಾಗಿ ಹೇಳಿಕೆ ನೀಡುವಂತೆ ಈಗ ಹಾಗೂ ಈ ನ್ಯಾಯಾಲಯವು ನೀಡುವ ಪ್ರತಿ ಮುದ್ದಿತು ವಿಚಾರಣೆಗಳಿಗೆ ಹಾಜರಾಗಿರುವ ಬಗ್ಗೆ ಕೂಡ ಇದ್ದು ಕಾಯ್ದೆ ಕಲಂ 58 ಅಡಿ ಅಪರಾಧಿಗಳಿಗೆ ನೋಟಿಸ್ ನೀಡಿ ವಿಚಾರಣೆಗೆ ದಿನಾಂಕವನ್ನು ಗೊತ್ತುಪಡಿಸಿ ದಿನಾಂಕ 24/11/25 ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಲು ಪ್ರತಿವಾದಿಗೂ ಕಾರಣ ಕೇಳಿ ನೋಟಿಸ್ ನೀಡಿದ್ದು ಸದ್ರಿ ನೋಟಿಸ್ ಅನ್ನು ಮಂಡಿ ಪೊಲೀಸ್ ಠಾಣೆ ಆರಕ್ಷಕರು ನಿರೀಕ್ಷಕರು ಸಿಬ್ಬಂದಿಯ ಮೂಲಕ ಜಾರಿ ಮಾಡಿ ಪ್ರತಿವಾದಿಗೆ ತಿಳಿದಿರುವ ಭಾಷೆಯಲ್ಲಿ ಖುದ್ದಾಗಿ ಓದಿ ಹೇಳಿ ಆದೇಶದಲ್ಲಿರುವ ವಿಚಾರಣೆಯನ್ನು ಅಥೈತ ದಾಖಲೆಗಳೊಂದಿಗೆ ಇರುವ ಅರ್ಜಿಯ ಪ್ರತಿ ಮತ್ತು ಕಾರಣ ಕೇಳುವ ಆದೇಶವನ್ನು ಪ್ರತಿವಾದಿಗೆ ಖುದ್ದು ಜಾರಿ ಮಾಡಿರುವುದೆಂದು ಫಲಾನಾ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. So my lord, opportunity was given, my lord.
Sorry, my lord.
learned friend is strongly submitted. ಅದನ್ನ 28/11 ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ 24/11 ಪೇರ್ ಆಯ್ತಾರೆ 28
May I submit, my lord?
Wrongly
If my lords
submitted.
may kindly see annexure B,
B,
which was wrongly filed before the sessions court, my lord.
28/11 ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತಾರೆ
That is in 2025, my lord. Kindly see page 25, my lord.
Different order.
ಅದನ್ನ ಹೇಳಿದ್ದು ಈ ಫ್ರೆಶ್ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ ಇವರು 24/11 ಪೇರ್ ಆಗ್ತಾರೆ
Maybe,
ಆರ್ಡರ್
my
ಪಾಸ್
lord.
ಮಾಡ್ತಾರೆ ಇಲ್ಲಿ ಯಾವಾಗ ರಿವಿಷನ್
Simultaneously, they have filed both the cases.
ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀವಿ 24/11 ಪೇರ್ ಆಯ್ತಾರೆ ಸೊ 28 ಒಂದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತಾರೆ ಟ್ರಯಲ್ ಓವರ್ ಸೈಟ್ ಆಗಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ತಾರೆ ಸ್ಟೇನೂ ಕೊಡ್ತಾರೆ 2/11 ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ ಜುರಿಸ್ಡಿಕ್ಷನ್ ಇಲ್ಲ ಅಂತ ಆಲ್ ಆಫ್ ಎ ಸಡನ್ 14/7 ನಲ್ಲಿ ಅನ್ನೆಕ್ಸ್ಚರ್ ಪಾಸ್ ಮಾಡ್ತಾರೆ ವಿತೌಟ್ ಗಿವಿಂಗ್ ಎನಿ ಆಪರ್ಚುನಿಟಿ ಫ್ರೆಶ್ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ.
Where is the order of 28/11?
28/11 ಅಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಈ ಆರ್ಡರ್ ಜೊತೆ ಅಲ್ಲೇ ಬರ್ದಿದ್ದಾರೆ 28/11 ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 26 ಅಲ್ಲೇ ಬರ್ದಿದ್ದಾರೆ 28/11 ಪೇಜ್ ನಂಬರ್ 25 ಸೆಷನ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಬರ್ದಿದ್ದಾರೆ ಪೇಜ್ ನಂಬರ್ 26.
There appears to be two orders, madam.
My lord.
One of 28/11/25.
28/11
passed after that notice of
Yes,
24/11.
ಅಪಿಯರ್ ಆದ್ರೂ ಸ್ವಾಮಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ ಜುರಿಸ್ಡಿಕ್ಷನ್ ಇಲ್ಲ ಅಂತ.
Then thereafter this 14/7.
My submission is that, my lord, annexure B and this both proceedings have been filed simultaneously, my lord. I presume that, my lord,
Sorry, wrong.
annexure B was dismissed for without
Lack of jurisdiction.
lack of jurisdiction, my lord.
Yes.
But, my
No,
lord,
but the order
this-
reference.
if my lords may kindly see
Order
annexure
reference ಕೊಡ್ತಾರೆ
A,
ಸ್ವಾಮಿ.
annexure
See
A, my
the-
lord, case number is
ಇಲ್ಲ
58/25.
ಸಾರಿ
One ನಿಮಿಷ, if both of you keep on talking.
ಸಾರಿ ಮೈ ಲಾರ್ಡ್ಸ್ ಪೇಜ್ ನಂಬರ್ 23 ಅಲ್ಲಿ ಅಬ್ಸರ್ವ್ ಮಾಡ್ತಾರೆ ಪೇಜ್ ನಂಬರ್ 23
ಒಂದು ನಿಮಿಷ ಇರ್ತೀರಾ?
ಸಾರಿ ಮೈ ಲಾರ್ಡ್ಸ್.
If you come to page 26,
Please, my
the
lord.
reference is to an order of 28/11/25. Now, the impugned order in the present matter is 14/7/26.
Please, my lord.
There are two different orders.
Please, my lord.
If notice had been issued, that was served on 24/11/25 and subsequently this 28/11 might have been passed. Are there two orders or is it only one order? It appears to be two orders.
I have to seek instructions on
Seek
that, my lord.
instructions.
Please.
If 14/7, what you will have to show us is before this 14/7/26 was passed, there was a notice which had been issued, they participated,
I will
not
place it, my
participated.
lord, the entire records.
Until then, we'll stay it.
State and release the
Because it
petitioner.
appears to be that there are two different orders. And AG accepts notice for respondent 1 and 2. Once earlier, the contention of the petitioner is once earlier, the notice dated 24/11/25 had been issued. Consequently, an externment order had been passed on 28/11/25, which had been challenged by the petitioner before the 7th Additional District and Session Judge Mysuru on 2nd July 2020, in criminal RP number 230 of 25, which came to be dismissed on 2nd July 2026. Subsequent thereto, without issuance of notice, the impugned order dated 14/7/26 at Annexure A has been passed. Then AGA is direct secure instruction and make a submission as to whether a notice had been issued to the petitioner prior to the order dated 14/7/26 having been passed. If so, to place the same on record. Until then, the operation of annexure, the order dated 14/7/26 at Annexure A is stayed. Released on 10th August.
Director, the petitioner release ಬಳ್ಳಾರಿ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ directive to release the petition.
Release in custody ಅಲ್ಲಿ ಇದ್ದಾರೆ.
ಅಲ್ಲಿ ಬಳ್ಳಾರಿಗೆ ಅಲ್ಲಿಗೆ ಮತ್ತೆ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಮನೆ.
ನೀವು ವಾಪಸ್ ಬನ್ನಿ.
ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರೆ ಇದಾಗ್ತದೆ.
We have stayed that.
Stayed. My handle over manage. Handle. ಬಳ್ಳಾರಿ.
Mr. Mahadeva, please don't. ನಾಳೆ ಬಂದ್ರೆ ಏನಾಗುತ್ತೆ?
ಮೈಸೂರಿನ ಬರುತ್ತೆ ಸರ್.
Yes, next.
And I came from Mysore, my lord.
And delivery.
But in this matter, I'll challenge the
It
police.
is only going to be postponed by 1 week ಅಷ್ಟೇ. He still go back.
ಏನ್ ಮಾಡೋದು ಸರ್ ಕರ್ತವ್ಯ ಮಾಡ್ಬೇಕಲ್ಲ ಸರ್.
It appears he has filed both the cases simultaneously.
Yes, filed, no, this has been filed subsequent.
Annexure.
This has been filed subsequent.
Lord, annexure A1, A and A1, my lord, is issued without mentioning provision of law as well as the crime under which is, my lord, the petitioner has been summoned to the police station. And it is, my lord, it is a contemptuous act because this honorable court has already, my lord, issued a guidelines.
Yes, madam, for what purpose is this?
No mention of crime or offense, my lord.
They have called for only inquiry, my lord.
Inquiry in what regard?
It is not forthcoming, my lord. It is not forthcoming in the
You'll have to
notice.
tell us what it is. Learn AGA accepts notice for respondent 1 to 3. She is called upon to secure instruction and make a submission as to on what basis annexure A and A1 have been issued. Until then, the operation of annexure A and A1 are stayed. Released on 10th August.
Not preliminary.
A1 of 26 is allowed.
Preliminary.
It will come in whichever state.
31, Manjunath PS.
Should we kindly pass over this matter, my lord? The learned AG is appearing in this matter, my lord.
AG is it?
AG, man. Ruben.
Pass over.
32.
That I will permitted to appear for my friend, my lord. Yesterday's matter, my lord, where it was passed over, my lord, yesterday to seek, the government advocate was directed to seek instructions.
Yes.
My lord. Annexure A is the impugned order, which is at page number 10.
What are the facts?
My lord, the petitioner herein have been appointed as a president of the Kolar Kurubara Sangha, my lord. Now, my lord, the respondent number 4 have issued a respondent number 3 have issued an order which is at annexure A. Now, my lord, the reasons, my lord, only last paragraph in that, my lord, page number 10 is the only reason. ಉಲ್ಲೇಖ ರೀತಿಯ ಸಂಘದ ಸೋನ್ಸೋ ವಾರ್ಷಿಕ ಸಾಲಿನ ನವೀಕರಣಕ್ಕಾಗಿ ಸಲ್ಲಿಸಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ದಿನಾಂಕ 22/4/25 ನಡೆಸಿದ ವಾರ್ಷಿಕ ಸಭೆಯ ಠರಾವಿನಲ್ಲಿ ಸಂಘದ ನೈಜ ಸದಸ್ಯರಲ್ಲದ 10ಕ್ಕಿಂತ ಹೆಚ್ಚು ಸದಸ್ಯರು ಸಹಿ ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. Now, my lord, this is the only reason that he is exercising his, he is trying to exercise his power. He has asked us to call for a annual general body meeting and, my lord, to form a fresh managing committee within 90 days from the date of notice.
Yes.
Lord, the petitioner has resigned from the president post. As of now, he is not a president, my lord.
He is resigned.
He is resigned.
Thereafter, he was again elected. After election,
When did he resign?
Please, my lord. On 15/12/2024, he has.
Long ago. This is.
Please,
this is resolution.
On that day, on 15/12/2024, the petitioner has resigned from the president post. He, in the said meeting, the respondent number 4 has elected as a president of the same.
2/4/2025.
Please read annexure A, Mr. Sadri ರಾಜೀನಾಮೆ ದಿನಾಂಕ 15/12/24 ನಡೆದ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ಸಭೆಯಲ್ಲಿ ಅಂಗೀಕರಿಸಲಾಗಿದ್ದು ಸದರಿ ಸಭೆಯಲ್ಲಿ ಸಂಘದ ಖಾಲಿ ಇರುವ ಅಧ್ಯಕ್ಷರ ಸ್ಥಾನಕ್ಕೆ ಶ್ರೀ ಜಯರಾಮ್ ಅವರನ್ನು ಅಧ್ಯಕ್ಷವಾಗಿ
ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. So therefore, Lord,
so your resignation has been accepted. When is the election thereafter which took place?
Lord, the reasons assigned.
When is the next election after?
Lord, on 2/4/2025. Your Lordship may kindly come to annexure page number 19.
Yes. After your resignation,
yes,
you said you were elected.
Yes, madam.
When was the next election which took place?
2/4/2025, which is at annexure D, page number 17.
Please, we are repeating the question once again. You resigned on 15/12/24.
Yes.
Which was accepted. After that, when did the election take place?
2/4/2025.
Is that
annexure
after?
D.
We'll have a 5-figure cost.
My lord, on 22/4/2025, Your Lordship may kindly see one more resolution.
On
22/4/2025. He is quoting 2024 date, my lord. He is quoting 2024 date.
Where is the election?
My lord, this is the resolution, my lord. This is the resolution what they have passed. And my lord, the newly elected committee members list is at annexure C.
Where the election results Where is the notice?
Unanimously, my lord, he was elected as a president. Therefore, a resolution was made. Your lordship may kindly come page number 29,
Where is
I mean
the
19.
notification for election?
That we have not produced, my lord, that we have not produced.
We are getting all these kind of things. 5 people sit there and they declare themselves unanimously elected.
But
Without
it
even
was
elections
signed
being
by
called.
all the managing committee members, my lord.
We are not
These-
concerned about your managing committee.
All 10, my lord, all the
Everybody has to
persons.
be elected, Alva.
Yes, my lord.
You are saying it's a AGM which has been.
Yes, my lord.
So where is that AGM electing all these people?
My lord, your lordship may kindly see 22 annexure, my lord, page number 21, my lord. This is the Sangada Varshika Sarva Sadasyara Sabhe. Typed portion is in the back side, my lord. If your lordship permits, I'll read typed
How
portion.
many
in the back
members
side.
are there
My lord, there are only 22 members.
of your Sangha?
Yes, my lord. Directors, only 22 directors were present.
Kolar Jilla Kuruburu Sangha.
It's only the IK of president and vice president, my lord. ಕೋಲಾರ ಜಿಲ್ಲಾ ಕುರುಬರ ಸಂಘ ಕುವೆಂಪು ನಗರ ಕೋಲಾರ ಸಂಸ್ಥೆಯಲ್ಲಿ ಅಧ್ಯಕ್ಷರಾದ ಬಿ.ವಿ. ಮುನಿಯಪ್ಪ ಅವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ನಡೆದ ವಾರ್ಷಿಕ ಸರ್ವಸದ ಸಭೆಯಲ್ಲಿ ನಡೆದ ವಿಷಯ ಮತ್ತು ತೀರ್ಮಾನಗಳು. ಮಿಲಾಡ್ ಸಾಲಿಗೆ ಮಿಲಾಡ್ ಸೆಕೆಂಡ್ ರೆಸಲ್ಯೂಷನ್ ಮಿಲಾಡ್ 24
You have only 22 members.
ಮಿಲಾಡ್ these are the directors of the
Directors we understand.
yes ಮಿಲಾಡ್
Where is the election of the directors?
ಅಧ್ಯಕ್ಷ ಅಂಡ್ ಉಪಾಧ್ಯಕ್ಷ ಅಷ್ಟೇ ಇದು.
ಅವ್ರು ಹೇಳ್ತಾರೆ ನಿಮ್ ಎಲೆಕ್ಷನ್ ಆಗಿಲ್ಲ ಫಾರ್ ಡೈರೆಕ್ಟರ್ಸ್ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇಲ್ಲ. ಆಮೇಲೆ ಕ್ವಶನ್ ಆಫ್ ಅಧ್ಯಕ್ಷ ಉಪಾಧ್ಯಕ್ಷ ವಿಲ್ ಕಮ್. First is the directors have to be elected.
First directors has to be elected.
So you have to be elected as a director first after resigning. You resigned
Milord, this
as a director. You cannot come back without election.
Milord, the resolution what my learned friend is stating, Milord, I'll read that one, 15/12/2024.
Where is that
Taa
resolution?
Kurubara Sanghada,
Where is the
just now
resolution?
handed over a copy. Yes, just now handed over a copy.
What is copy? Yes.
Milord, this is dated 15/12/2024. Milord, second resolution what my learned friend is relaying. ಜಿಲ್ಲಾ ಕುರುಬರ ಸಂಘದ ಅಧ್ಯಕ್ಷರಾದ ಟಿ.ವಿ. ಮುನಿಯಪ್ಪರವರು ಜಿಲ್ಲಾ ಕುರುಬರ ಸಂಘ ಅಧ್ಯಕ್ಷರ ಸ್ಥಾನಕ್ಕೆ ನೀಡಿರುವ ರಾಜೀನಾಮೆಯನ್ನು ಅಧ್ಯಕ್ಷರ ಸ್ಥಾನಕ್ಕೆ ನೀಡಿರುವ ರಾಜೀನಾಮೆಯನ್ನು ಅಂಗೀಕರಿಸಬೇಕೆಂದು ಸಭೆಯ ಒಪ್ಪಿಗೆ ನೀಡಿತು. Now, my lord, he has not resigned as a director. It's only resigned as a ಅಧ್ಯಕ್ಷ.
That is what you should have told us.
Next. And thereafter, my lord, again.
ಅದೇ ಕೇಳ್ತಾ ಇದೀವಿ ನೀವು ಡೈರೆಕ್ಟರ್ ಅಂತ.
Thereafter, my lord, again on 2/4/2025, one more resolution has taken place. Your lordship may kindly come to annexure D, which is 2/4/2025.
So same body of directors continue.
Continue. And again he was elected. Adral tirga second one, second resolution. Now, my lord, he is not, the third respondent have not issued notice on these counts. What he is stating is, my lord, the only count what he is telling is, my lord, 10 ಜನ ಸದಸ್ಯರಲ್ದೇರೋ ಸಹಿ ಮಾಡಿರೋದು ಕಂಡು ಬಂದಿರ್ತದೆ. ಯಾವ 10 ಜನ ಅನ್ನೋದು ಹೇಳದೇ ಇಲ್ಲ ಅವರು. And nobody has given such an objection. And it is nobody's case that 10 people, 10 non-members have signed the resolution.
All these people who have signed Annexure B are members.
Yes, my lord. All of them are members. He doesn't state who are those 10 members.
Yes.
I have to take instructions to that effect, my lord, that
Third time is
members of Kurubara Sangha, the entire list will be with the fourth respondent. As of now, the summons to the fourth member is deferred. I will take instruction from the DRCS and get back to maybe next week.
But 10/6, same submission was made.
We will stay Annexure A.
Who are the present member? Who are the 10 new members? I'll take that entire records, my lord.
We will stay Annexure A till then.
Yes, my lord. Because let respondent number 4 be notice may be issued to him. He is the present as of now. He is the present president of Kurubara Sangha Kolar.
Resolution is then.
I have submitted records for his verification.
He claims he is the president, fourth respondent. The petitioner claims he is the president. The annexure A is very clear. The complaint given by the petitioner as well as the fourth respondent.
Why are you getting involved in this? You should have asked them to go to civil court to sort out their differences. This is a society.
Society, madam.
It's not a cooperative society. You get involved and they involve the court also by filing these petitions.
Yes, madam.
Society is only by contract. You are only to see 25, 27, limited.
Please, madam.
None of the other things are there for you.
Please.
Issue notice to respond number 4, written up by 24th August. Considering that the details of who are the non-members who have signed the notice has not been provided in annexure A, the operation of the annexure A is stayed till the next date of hearing.
Much.
Process fee and copies to be furnished by end of day 23rd, failing which the interim order would stand automatically vacated.
33. Achilles C. Mohan.
Case where I've been placed as a rowdy at annexure A. My lord, the cases that have been shown in annexure A have been acquitted and compromised, and B report has been filed, my lord.
All of them?
All of them. The last one has been stayed by the Honorable High Court, and there is one.
Only a notice, so you reply to them, give them this.
We have made representation, my lord. We have made representation.
When have you given the representation?
My lord, at annexure. At annexure D, what may Lord may find at page number 30.
Not you're asking for representation to be considered, you're asking for certiorari to quash a notice.
My lord?
Your relief you are seeking for is quashing the notice.
Indeed, my lord. My lord, in the notice, the crimes that they have shown has either been acquitted, the very offences that they're alleging that I'm
I have to go and show it to them. That is there in the register.
Indeed, my lord. It is there in the register, my lord.
When did you give the representation?
My lord, I gave the representation on 21/4/2026.
Annexure?
Annexure D. They're not given a reply to that said notice, my lord. I've also forwarded the same to the DCP as well.
Accepts notice for the respondents. Petitioner is before this court seeking.
My lord, also they have issued now 110 notice, my lord, saying that I have to go and give bond on this particular, because I've been placed as a rowdy. For safeguard measures, I have to go and give a bond now.
Is before this court seeking for the following reliefs. What has been essentially challenged is a show cause notice which had been issued by respondents on 12/1/25 at annexure A. The petitioner has already replied and submitted representation on 21/4/26 at annexure D. Hence the question of quashing annexure A would not arise. Directing respond number 2 to consider the reply, 2 and 3 to consider the reply, stroke representation dated 21/4/26 at annexure D, and pass necessary orders within 15 days from the date of receipt of a copy of this order. The petition stands disposed.
Much obliged, madam.
34. L. Narasimhamurthy.
Appealing for petitioner.
Yes, madam, final notification.
I beg your pardon.
Final notification on 17.
Please, my lord, I
Preliminary
have
notification has been issued
notification, my
under
lord, I
force.
have the notification, gazette notification, I'll produce it, my lord.
What is this you're having now?
This it is. Preliminary notification.
Lordship, that looks like, that's not gazette notification, my lord. I've already enclosed that copy of that in page number 66. In my petition, annexure R. Page 66, man. That's the Adhisuchane, but wherein what they have mentioned is.
This is a preliminary notification, section 4.
Yeah, section preliminary notification.
Final
The
gazette is
final-
not it. Lord, may I submit, my lord? If my lords may kindly see page 16. Their case is that, my lord.
16.
Please, my lord, the ground searched by the petitioner is that, my lord. The entire eviction proceedings under 64A are structurally incorrect because final notification has not yet been published under the Karnataka Forest Act. A preliminary notification under 14 has no legal force unless it culminates in publication of final gazette notification by the state government under section 17. Because section 17 notification remains unpublished, the land is legally revenue land, stripping respondent number 7 of any right to initiate under 64. So, my lord, the proceedings under 64A is erroneous. That is the contention, my lord.
Yes.
My lords may kindly permit me to produce a judgment. Para number 64, my lord.
Copy there.
Ganapati.
Para 46, I beg.
Para?
46, my lord.
Yes.
Further, in the aforesaid context, we do not think that there can be any distinction with regard to a piece of land which has been decided to be constituted as a reserved forest under section 4 subclause 1 of the act, and land being deemed to be reserved forest under section 17 of the act, which is like a final notification. The reason being, once the land is constituted as a reserved forest under section 4 subclause 1 of the act, it is the issuance of a notification, then the claim would have to be made, and it is only on the consideration of the claim that an application for exclusion of the land constituted as a reserve forest under section 4 subclause 1 of the act could be ordered, merely because the procedure contemplated under the act subsequent to the issuance of a notification under section 4 of the act is not yet completed, or no notification has been issued under section 17 subclause 1 of the act. In our view, we do not make any difference, as the object and the purpose of reserving any land is to treat the said land as being constituted as a reserve forest. If such a land or a portion thereof is excluded on adjudication of claim, it would not find a place in notification issued under section 17 of the act. In such a case, it would be no longer be constituted as a reserve forest, but till that procedure is not completed by the forest settlement officer, it remains to be constituted as a reserve forest.
There's a different context.
Lord, here they are challenged 64A eviction order, my lord.
In the judgment that you are referring to,
Please, my lord.
is not one passed under 64A.
Lord, they say that
This was a challenge that it is not so declared that it is not a forest land before 17 was there. And that is why it was dismissed, saying 17 still there's time to do.
Please, my lord.
In this matter, when they are still in possession, you have issued only 4.
Please, my lord.
Without 17 happening, you are dispossessing them.
Lord, my instructions are that, my lord, only boundaries marked.
Be happy with it. We'll record your submission and dispose the matter.
That's not the case, my lord. I'll produce that. What?
May I make one submission? I'll accept notice, my lord. I'll file my objections.
File your objection,
Please,
but
my
don't dispossess.
Please.
Lordship, I need to make one kind
But, my
submission.
lord, however, my instructions are also that, my lord, they had a house which was not evicted. They were not evicted from that particular portion of the land. That
They've
is my
already marked the
instruction.
land. They've fenced it.
Don't evict them until we'll have to
And
decide whether you can do
They
it.
are not evicted.
Your Lordship, I'll mention their.
Even if they are evicted, put them in possession.
Please.
You can't be doing that like that. By afternoon, you'll go and evict them. Don't do that.
Lordship, I'll just take your Lordship attention to page number 92, annexure U. Lordship, what happens is, this is the notice issued by respondent number 8, my lord. The initial order
22/6/2026, this is the eviction order issued by the Assistant Conservator of Forest. He gives us in the Adesha, my lord, page number 90, I'll just read out. ಅರಣ್ಯ ಪ್ರದೇಶ ಅನಧಿಕೃತ ಸ್ವಾಧೀನಕ್ಕೆ ತೆಗೆದುಕೊಂಡ ಸದರಿ ಅರಣ್ಯ ಪ್ರದೇಶವನ್ನು ಈ ಆದೇಶದ ದಿನದಿಂದ 30 ದಿನದಲ್ಲಿ ಬಿಟ್ಕೊಡ್ಬೇಕಾಗಿ ಅಂತ he writes.
ಏನಪ್ಪ ಸ್ಟೇ ಬೇಕಾ ಬೇಡವಾ?
Stay ಬೇಕು. But
why are you arguing?
I'm not arguing. I just wanted to bring their aggression to your lordship notice. That's all, my lord.
They have to be aggressive. They have to safeguard forest land. They are facing a lot of trouble in safeguarding forest land.
Correct, my lord. But
they are trying to do their job, so don't. We can't find fault with that. This is not for any. Considering that only a preliminary notification in section 4 has been issued, and final notification in section 17 has not been placed on record. The operation, the order dated 22/6/26, passed by respondent number 7 in case number 270 of 21/22 at annexure T so and so eviction notice bearing number so and so dated 24/6/26 at annexure U are stayed till the next date of hearing. The point that would arise for consideration is whether on issuance of a notification under section 4 for constitution of a reserved forest, proceedings under section 64A could be taken against the persons who are residing in the said property notified without a final notification of section 17 being issued. And AGS seeks for and is granted 4 weeks time to file a statement of objections. Objections, if any, to be filed on or before 17th August, relist on 24th August.
May I request my lords to kindly peruse page 82 for a moment, my lord?
82.
Please, my lord.
Yes.
FSO has 82, my lord, the relevant portion, ತೀರ್ಮಾನ. ಹಾಸನ ಜಿಲ್ಲೆ ಸಕಲೇಶಪುರ ತಾಲೂಕು ಮರಗಡ ಹಳ್ಳಿ ಗ್ರಾಮದ.
This is the FSO's order. This is fine.
No, my lord, they say that, my lord, may I read this?
This is like SLO's order, madam, recommending.
No, my lord, they are saying
Section-
that ಮನೆ ಕಟ್ಟಿಕೊಂಡು ವಾಸವಾಗಿರುವುದರಿಂದ ಈ ಬಗ್ಗೆ ದಾಖಲೆಗಳು ಇದ್ದು ಈ ಅನಧಿಕೃತ ಸಾಗುವಳಿ ಸಣ್ಣ ಹಿಡುವಳಿದಾರರು ಈ ಪ್ರದೇಶದಲ್ಲಿ ಅವರ ಜೀವನಾಧಾರವಾಗಿರುವುದರಿಂದ ಅವರ ಹೆಸರಿನ ಮುಂದೆ ತೋರಿಸಿರುವ ಪ್ರದೇಶವನ್ನು ಉದ್ದೇಶಕ್ಕೆ ಮೀಸಲು ಅರಣ್ಯ ಉದ್ದೇಶದ ಹೊರತುಪಡಿಸಿದೆ. So my lord, they are
not only concerned about the rest, they are concerned about the other land.
other land they have only marked, my lord.
Don't evict them.
Much obliged.
It matters, serial number 35, address Ballard.
Yes, Ms. Ballard.
But after issuing the notice, my lord, the petitioner has responded.
For respondent number 3. So you're not going to press for your memo of retirement? No. Ready?
Lord, further instructions have to be sought because now they are in possession of that property, my lord, which has been sought for eviction.
Again, adjournment.
Short till
And counsel
31st.
for the petitioner submit that he does not press the memo of retirement filed by him on 23/6/26. The said memo is dismissed.
31st.
At the request of counsel for the petitioner, relist on 11th August.
Lord, interim order may continue.
Interim order earlier granted.
Obliged.
Serial number 36,
36, I request for a passo, my lord.
Passo.
37, Karan Joseph.
Appear for R1, respond number 1.
Is come today or no?
Respond number 1, my lord.
Yes.
Respond with this area. Just kindly, I can seek 1 week time. I'm seeking approval, just 1 week time.
I mean, I'm in your lordship's hands. I can't proceed without the documents.
How long will it take for approval?
I need to just get some instructions, so that's why 1 week time.
There's no instruction, you have to just give him the copies.
Sincere.
At the request of counsel for respond number 2, relist on 11th August, it's made clear that no further adjournment will be granted.
Yes, ma'am.
May I request for the 30th, my lords, if they need a week, I'll take a chance.
30th August, 30th July.
I'm grateful, my lords. It was interim order to kindly be.
Interim order.
I'm most grateful.
38,
Petitioner, my lord.
Yes.
My lord, I have challenged annexure E, page number 44.
Annexure E, page 44.
44, my lord, where my application for enrollment as an advocate has been rejected. My lord, I'm a senior citizen, I'm a retired employee from central government.
By KSBC.
Open university, while in 45, my lord, if page number 45, while they are quoting the reasons in the last paragraph, my lord, last paragraph, fifth line. It's actually sixth line. The legal education rules provide for enrolling applicants who have passed 10+2 plus basic degree and 3 year law degree, or 10+2 plus 5 years law degree from a recognized universities. Only those applicants can seek enrollment under Section 24 of the Advocates Act 1961, along with other ingredients. Here, Sri J. Shukumar has passed only 10+2 plus MA degree, that is open university, they have put in the bracket, and 3 years law degree. While my lord, it's not an open university. I've done this MA course attending contact classes. I've attended the contact classes. I've taken the required permission from the employer. That is a Doordarshan employee. Where that's a correspondence course which I've done, my lord, and plus and. '24 of Advocates Act, it doesn't specify in the text.
Yes, not right. Where is this qualification of 10+2 plus?
Mistake notes, legal education rules.
Rule 5, Your Worship.
Rule 5 of
Part 4, Chapter 3, Rule 5 of Bar Council of India rules.
Bar Council of India rules. No, we have referred section 24 in the order.
But nevertheless, notes subject to qualification notes of
Only those applicants who can seek enrollment in section 24 of the Advocates Act is what you have mentioned in the order. So now
this is not subject to notes of qualifications.
Now Bar Council, which chapter are you referring to?
Your Lordship, it is Part 4, Chapter 3, Legal Education Rules.
Part 4.
Chapter 3.
Where is this? Page?
30.
30. No?
Chapter 2 or 3?
Part 4,
Chapter
chapter
2, it is
1.
chapter 2.
Chapter 2.
It is chapter 2, Your Lordship.
Chapter 2.
Yes.
The standards of professional legal education.
Eligibility for admission. Rule 5.
Recognized university.
Please, not so kindly see the first sentence. The State Bar Council shall enroll as an advocate only candidates. Not sorry.
Only such candidates who are passed from university.
Recognized universities. Rule 3.
My lord, same courtesy
Just,
in
just a moment, please.
I just see. Not so, what minutes of chapter 2? No? Recognized universities.
Yes, recognized university.
Adali first sentence.
Hmm.
The State Bar Council shall enroll as an advocate only those such candidates who have passed from university approved affiliated in Center of Legal Education Departments of Recognized University as approved by the Bar Council of India. The Bar Council of India shall notify a list of such universities and the centers of legal education prior to the commencement of each education year in the prescribed manner, and also put in the website the Bar Council of India. So that is notes for the prescription. That is then notes the law courses. There should be two courses of law leading to bachelor degree as under a 3-year degree course in law undertaken after obtaining a bachelor degree in any discipline, not the kind. Considered equivalent to by the Bar Council of India. Second, B. A double degree integrated course combining bachelor's degree course as designed by the university concerned in any discipline of study together with a bachelor degree course in law, which shall be not less than 5 years duration, leading to the integrated degree in respect to discipline of knowledge and law together. So this is not surveyed BAL, LLB and the 5 years course. That's then the second provision can be lifted. Provided further. Provided further that in the case of integrated double and total time of regular competing of 2 courses, one of each other in the regular and immediate succession, meaning thereby that if a degree course in the basic disciplines such as arts, science, social science, commerce, management, fine arts, engineering, technology, or medicine, etc., is of 3 years duration of studies, integrated course in law with a basic degree in the discipline could be completed in 5 years' time. But where degree course is a basic discipline for takes 4 or 5 years, the integrated course in law, which the degree course in the discipline would take 1 year less than completing in the regular time, then that total time taken for 2 degrees shall be so. Therefore, notes the getting an enrollment, notes enrollment.
This has nothing to do with this. Is only integrated 5-year law course, 3-year law course.
First,
Question is simple. Where do you get this 10 plus 2 plus 3 plus 3?
Your Lordship, it is rule 5. Explanation, Your Lordship, is most important.
3-year law degree, yes.
Eligibility for admission.
An applicant was graduating. Yes.
If I may.
What do you want to say in rule 5?
For admission, notes first aim. An applicant who had graduated in any discipline of knowledge from university established by an act of parliament or state legislature or an equivalent national institution recognized as a deemed to the university or foreign university, recognized as equivalent to the status of Indian university by an authority competent to declare equivalence, may apply for a 3 years degree program in law, leading to conferment of LLB degree on successful completion of a regular program conducted by university whose degree in law is recognized by the Bar Council of India for the purpose of enrollment. Just take notes, explanation is concerned. The applicants who have obtained 10 plus 2 or graduation, post-graduation through Open University system directly without having any basic qualification for prospective studies are not eligible for admission in the law. Notes is that you should have completed 10 plus 2 plus notes any degree, not as the notes in arts, science, not for example, BA LLB ಆಗಿರಬಹುದು, BE LLB ಆಗಿರಬಹುದು, MBBS LLB ಆಗಿರಬಹುದು.
ಅದೆಲ್ಲ ನಾವು ಇವಾಗ ನೋಡ್ತಾ ಇಲ್ಲ. We are looking at
LLB degree should be notes basically supported by notes one degree. In this case, notes here it is not so. He has done 10 plus 2 plus MA.
How did you give him a law degree?
Anybody can get notes enrolled as Millards. For the education purpose, notes you should have done.
Your qualification for admission that you are speaking of in clause 5
Please.
is 3-year law degree course eligibility. You are not speaking of the bar council eligibility in clause 5. You are saying for a 3-year law degree, an applicant who has graduated in any discipline of knowledge from a university established by an act of parliament or by state legislature or equivalent national institution. Now you are contending after he is admitted in a 3-year course to say that he was not eligible to be admitted into a 3-year course. That is your submission.
The city is not made as a party to answer that.
So what action have you taken against this university?
My lord, my first year result was withheld.
Did you cancel their registration with you? You have not done anything.
Your Lordship, according to the petition, they had approached Honorable High Court to continue with their education because the university was not granting them enrollment admit card for the exam, according to their own petition.
My lord, first year result was withheld. That time, Justice Saldana, that is in year 94-95, passed a order saying that I qualify for the admission and basis that I complete my 3 years degree.
Where is that order?
My lord, unfortunately, that order is not there because that time it was not completed as 20 years, 8 years. In fact, respondent 1 is the party there. Bangalore University was the party.
Where is that order?
They were the party. Bangalore University was the party.
Court has passed an order allowing them to continue. Subsequently, it can change.
Even accepting that also. Anybody can do the LLB course for they gain. It's not a note for.
No, that submission is a very dangerous submission if you make it. If you record that, it will be a problem. You can't say anybody can do. If you say clause 5 is applicable, only the people who qualify for clause 5 would be able to do. Now, according to you, it has to be a basic degree. Here is a master's degree without a basic degree. Now, 2 questions are there. One is without a basic degree, when he has done the master's, can you contend that he has not done the basic degree? Number 1, actually for both of you, not actually more for madam.
Yes, sir.
Can you say that since he has done a master's degree, but not the basic degree?
A master's degree directly done without the graduation.
The university has given that degree.
Your Lordship, they had to approach Honorable High Court to get the admit card, Your Lordship.
So
PCI doesn't recognize that, Your Lordship.
Subject to reading the order.
It is a foundational.
Subject to reading the order.
Please.
Subject to it. If there is an order which has been passed by a court of law permitting them to
Just to
enroll,
take the exam, and that order also they have not submitted.
you can also submit. One of you can do that. This is not about the petitioner.
Please.
Please don't make it adversarial litigation. This is not about the petitioner. This is something for people who come forward to take the practice of law.
Please.
Without your registration, it can't happen. Without your registration, we could not practice.
Please.
After that, we have to surrender. All those things are there, which we have to follow. They can't practice without the registration. So when such being the high bar for that, technicalities should not be there, number 1, because it's a Article 19(1)(g), right to profession.
Yes, sir.
Now, the eligibility you are saying, that's why you said 2 questions. One, without BA when they've got MA, can you say they did not have a BA, therefore we won't consider? That is one important question. Second question is that once they've been enrolled into LLB, there is again a qualification for LLB.
Yes, sir.
Not qualification for enrollment. Clause 5 is a qualification for joining the course, LLB course, enrolling into that course, not enrollment as an advocate. Once he has been enrolled into a LLB course and he has completed the LLB course, that is the second question. Can you say that he has not done BA, therefore I'll ignore his LLB?
I'm filing my written submission, sir.
Third, if you consider these and pass, if you want to update it, please update it. Third is, how relevant is BA for the purpose of practicing law? Is LLB which is relevant for practicing law?
Your Lordship, to do LLB, you have to have a basic qualification as graduation to enter into a 3-year LLB. For an integrated course, you should have 10+2.
That contention,
Foundational.
that you could have raised initially.
Yes, sir.
And if it had, that's why I said subject to reading of that order. If that had been accepted at that stage and they have been denied, then valid.
Yes, sir.
But that apparently has been rejected. And they have been allowed to complete the law degree.
Yes, sir.
So for your enrollment is not for joining the law degree, your enrollment is to practice.
Your Lordship, there have been many judgments by Apex Court also,
Yes,
saying that there's a difference between studying law and practicing as a lawyer.
That is there.
Yes, Your
Without
Lordship.
registration with you, nobody can
Yes,
do.
sir. So,
Without a law degree, they can't register with you, no problem.
yes, sir.
Without a BA degree,
No, Your Lordship, that law degree should also be recognized by BCI and State Bar Council.
now the law degree in this case is not recognized.
This law degree is not proper only because it has been done after not having the qualification, foundational qualification.
There is a distinction. Law degree is recognized, but the qualification is not recognized, is what you are saying.
Your Lordship, this kind of law degree is not recognized by BCI for enrollment.
Then which is this college? Take action against that college. Because they are cheating students. Please take action against them. And give instruction to all if that is the stand that you are taking, please give instruction to all of them that if this is not done, it won't be. Please issue instruction to all the universities that degree certificate will not be given.
Perhaps, Your Lordship, that is why university did not grant them the admit card.
And now that an order has been passed by this court, can you go behind
And that order we have.
Can you go behind? That's why we are asking you.
Also, Your Lordship, I would like to draw attention to 26(2) of
20
Advocates Act, Your Lordship.
2.
Yes, Your Lordship. Disposal of application for admission as an advocate. 26 of Advocates Act. A State Bar Council shall refer every application for admission as an advocate to its enrollment committee and subject to the provision of subsection 2 and 3. Direction may be given in writing by the State Bar Council in this behalf. Such committee shall dispose of the application in prescribed manner.
Yes.
Then 2 says, where the enrollment committee of a State Bar Council proposes to refuse any such application, which in this case they have, it shall refer the application for opinion of Bar Council of India, and every such reference shall be accompanied by a statement of grounds in support of the refusal of the application.
This has
So
not been
this
done.
recourse is also there, that they have not done.
We have state evidence rejected his application. But we are state evidence rejected his application. What is the grounds notes that he is not qualified?
The reading of this is you can't reject. You can only propose to reject.
No, if there is any proposal, not any clarification to be sought, then once we can make a reference to the BCI seeking a.
Where the enrollment committee of the State Bar Council proposes to
Dispose
refuse.
of any, yes.
Proposes to refuse any such application. It shall refer the application for opinion to the Bar Council of India. And
Also,
every
Your
such
Lordship,
reference shall be
26(3).
accompanied by a statement of the grounds. So basically you can't reject. You can only propose.
No, Your Lordship, 26(3) also then says, the enrollment committee of a State Bar Council shall dispose of any application referred to the Bar Council of India under subsection 2 in conformity with the opinion of Bar Council.
I'll clarify with respect to that.
You can't reject.
I'll clarify with respect to that.
Your Lordship, may kindly grant me permission.
My lord,
to
I'm
file
already a
written
senior
submissions.
citizen, my lord. And respondent 2, they have already clearly mentioned that there is no objection in written. It's been ordered, taken in order sheet.
You don't get any relief out of it. If we reject it, we'll have to only tell them to send it to the Bar Council of India for opinion.
Yes, my lord. My lord, also one more thought is this is a gray area because for people who have completed 21 years and 25 years, those days Mysore University used to offer the courses. And I'm sure there will be a lot of cases like this, my lord.
That is why 1967 is the cutoff date. Post 1967, this is what it is.
Yes, sir.
But what we see is the qualification.
No, it is foundational qualification. Graduation is a foundational qualification. That is our stand.
My lord,
Bachelor of Arts in History, Political Science.
Or else notes, even notes engineering can also do LLB. But LLB should be always supported by notes.
Correct. But the fact remains here, see, these are things which have happened in the past. We can't go and change it. If anybody has a time machine, they would also have gone and changed it. And they would have said BA, then we'll do MA. Things have happened in the past that they were able to do their MA without doing BA. Right or wrong, that has happened. Right or wrong, they got into LLB. They have completed LLB. But as a lawyer, how many times do we go? We may refer to history books, but how many times do we do that? We refer to law books. That is a training. And even the college, how much do we learn? Because after coming here, only you can learn to practice.
But nevertheless, it's a wisdom.
That is why we will have to look at it, because this would have an impact on. And in that range of people who are there, now they are superannuating.
Please, Your Lordship. There are many cases pending in Supreme Court, Your Lordship.
They are superannuating, and after that they won't have. If they're able to perform, they'll earn some livelihood. And with the kind of senior citizen matters which are coming up, their children will not look after them.
It's true.
They have to fend for themselves.
True.
Larger thought is what you will have to look at. It's up to you.
Absolutely true.
Please look at it so that they can continue to earn a livelihood.
My lord,
Some
section
more
5
lawyers, that's all.
Section 5B, also what it states, my lord, provided that applicants who have obtained +2 higher secondary pass certificate or first degree certificate after prosecuting studies in distance or correspondence method shall also be considered as eligible for admission in the
That is
intermediate
not
years
the
course.
issue. That is not the issue. The issue is not distance or correspondence. That's not the issue. The issue is that you have not done your BA, you have done only MA. Only MA.
And I have produced the appellant court's decision, my lord.
MA without BA is useless is the subject.
Yes.
That appellant court's decision, my lord, overqualification cannot be a rejection, which I have produced appellant's court decision.
Overqualification without the under. That is the problem. Take a decision on that. It will help all the bar councils also.
Your Lordship, I can I present this?
Madam, you want to file it, file it. We are not saying no. But consider these and file.
Please.
My lord, in order sheet, it's already
Not
recorded.
about this case only. It's about so many other cases. You also say that there are so many pending.
Yes, sir. In 26(2), if the KSBC follows, then we may give a recommendation,
Opinion.
opinion. That would be better.
You get your instruction, then we'll do that.
Please.
That is the thing. Be positive about it, that's all.
With that order copy. And which
My
The
lord,
order copy not
no,
available.
28 years. In fact, I searched, my lord. I did my best, but unfortunately that time it was not.
Petition number?
That also I don't have, my lord. If it was there, only 95, 96, the order was passed in front of Justice M.F. Saldana, my lord. Only that information I have.
This petitioner was a party there?
Yes, this petition was the party. In fact, 2 more people were there along with this petitioner.
J. Shivakumar ಅಂತ ಚೆಕ್ ಮಾಡಿ ಆ ಟೈಮಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಇದೆಯಾ ಅಂತ take note. We'll see.
And there is no conditional order, my lord. That's what I can confirm.
Without seeing the order, we cannot say this way or that way. But the fact that you have, only thing in your favor is the fact that you finished your law and got the certificate is speaking in your favor. That's all. Relist on
My lord, it can be taken as parted, my lord.
11th August.
Parted, my lord.
The government was not filed in petition. The petition filed with the government has to be dismissed. Matter relating to the compensation was not paid, unpaid in nearly 15 years. Some of the victims also blood livelihoods. Taken after this.
We got 19 plus 37 matters. After that, we will come back to this. So quite a bit of matters are there.
Pass an order. The government
Mr. Counsel, if we make an exception for you, other people will also ask for an exception. We can't make an exception like that. If it is something about demolitions or arrest, yes, we make exceptions, not for anything else. Compensation is money, so it's not something that we can do. You want the adjournment?
Item 45.
45, you want the adjournment or what do you want? We don't know where.
Passport has been listed.
Lordship, humble submission.
If it reaches,
Compromise petition, my lord.
yes.
Number 3, Lords. Serial number 19.
We'll take it up.
My Lordship,
My lord, humble submission,
my
if it can be taken as parted, my lord, my matter, because my friend, to get my friend, it was very difficult. 3 years, I mean.
Just because we seem to be in your favor today, don't think we may be in your favor later.
My Lordship, serial number 59, my Lordship. Morning, the respondent advocate has taken the adjournment. They informed that they will take the adjournment for the petitioner.
Yes.
But at 10:30, they did not mention.
They
At 10:30,
mentioned.
they will take the adjournment.
They mentioned and it's been adjourned.
No, my Lordship, interim stay is granted, my Lordship.
Interim stay, 59 interim order.
My Lord, kindly extend the interim order.
Yes, we have extended. 52. You're for? No, we have rejected this in the morning. We have rejected it in the morning. Please don't do this.
My lord, serial
Just
number,
because another council appears from morning to afternoon.
my lord, serial number 41, my lord. It's regarding the recommendation. 41. Recommendation of the Honorable Lokayukta, my lord. My lord, I have another 9 cases connected along with this. My lord.
41, the outcome date?
12th August.
12th August, connect with zones.
Please.
Number 43, my lord.
48 मेरा start date में kindly detail.
48. The request of council for the petitioner released on 12th August.
Serial number 43.
When it reaches, we are not making an exception. Yes. 43. Heli.
I am for the respondent objected, my lord. The respondent number 5 is 81 years, my lord.
You
Senior
are
citizen.
opposing?
Opposing.
Rejected.
My lord, it's serial number 50.
54. ಚೆನ್ನಾಗಿದೆ. 50 ಇದೆಯಾ? ಓಕೆ.
Serial number 61. Serial 11.
ಅವ್ರು ಕೊಡ್ತಾರೆ ಸೈನ್ ಆಗೋದು ಬಿಡೋದು ಅವ್ರಿಗೆ.
58 ಅರ್ಜನ್ ಆಗಿದ್ಯಾ ಮ್ಯಾಮ್? 58 ಅರ್ಜನ್ ಆಗಿದ್ಯಾ ಮ್ಯಾಮ್?
ಸೀರಿಯಲ್ ನಂಬರ್ 5.
ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಡಿ ಗ್ರೂಪ್ ಟು ಮ್ಯಾಮ್. ಮ್ಯಾಮ್ ಇದು ಅಲ್ಲ ಲಂಚ್ ಬ್ರೇಕ್ ಆದ್ಮೇಲೆ ಕೇಳ್ಬೋದಾ ಮ್ಯಾಮ್ ಮಧ್ಯಾಹ್ನ? ಈಗ ಬೆಂಚು ಲಂಚ್ ಬ್ರೇಕ್ ಆಮೇಲೆ ವಾಪಸ್ ಅವಾಗ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಕೇಳಲ್ಲ ಮ್ಯಾಮ್ ಮಧ್ಯಾಹ್ನ?
ಅಲ್ಲ ಇಲ್ಲಿ ಕರ್ದಾಗ ಕೊಡಿ. ಮಾಡಿ ಮಾಡಿ ತುಂಬಾ ಜನ ಇದಾರ ಪಾರ್ಟಿಸ್ ಮಾಡಿ ಹಂಗಂತಾನೆ ಹೇಳಿ. ಮುಂದೆ ಬಂದ ತಕ್ಷಣ ಇನ್ನ ಬುಕ್ ಇಲ್ವಲ್ಲ ಪಕ್ಕದಲ್ಲಿ? ಬುಕ್ ಯಾವ್ದಿಲ್ವಾ? 3 ಬುಕ್ ಕೊಟ್ಟೆ, 2 ವಾಪಸ್ ಬಂದಿದೆ. ಜಾಫರ್ ಇರಿ ಇನ್ನೊಂದ್ಸತಿ. ಈಗ ಒಂದ್ ವಾರದಿಂದ ಎಲ್ಲ ಚೇಂಜ್ ಆಗಿದ್ದಾರೆ, ನೋಡಿ ಹೇಳ್ತೀನಿ. ಆರ್ಸಿ ದೇವರಾಜ್ ಈಗ ಒಂದ್ ವಾರದಿಂದ ಚೇಂಜ್ ಆಗಿದ್ದಾರೆ. ಈ ಮಂಡೆಯಿಂದ 3 days ಆಯ್ತು. ಮಧ್ಯಾಹ್ನ ಒಂದ್ 4 ಗಂಟೆ ಆಗುತ್ತೆ. 44 ಅದೇ ಸ್ವಲ್ಪ ಟೈಮ್ ತಗೊಳುತ್ತೆ. ಮಧ್ಯಾಹ್ನ ಬೇರೆ ಬೇರೆ ಲಿಸ್ಟ್ ಅವೆ, ಅದಾದ್ಮೇಲೆ ಆಯ್ತು. ಇಲ್ಲಿ ಡಿಸ್ಪ್ಲೇ ನೋಡ್ಕೊಳಕ್ ಹೇಳಿ, ಅವ್ರಿಗೆ ಗೊತ್ತು ಯಾವ ಕೇಸ್ ನಡೀತಾ ಇರುತ್ತೆ ಇಲ್ಲಿ ಅಂತ. ಇನ್ನ ಆಯ್ಬೇಕು. ಸರ್ ಫಸ್ಟ್ ಧಾರವಾಡ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಅವಾಗ ಬರುತ್ತೆ, ಒಂದು 4 ಗಂಟೆ ಆಗುತ್ತೆ. 4 ಗಂಟೆ ಆಗುತ್ತೆ. ಪಿಸಿಗೆ ಬರ್ತೀರಾ? ಪಿಸಿಯಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ತೀರಾ? ಹಾ ಹೌದು, ಫಸ್ಟ್ ಧಾರವಾಡ, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ. ಕಾಯ್ಬೇಕಷ್ಟೇ. ಬರ್ಬೋದು, ಲಿಂಕ್ ಎಲ್ಲ ಸಿಗುತ್ತೆ, ಇಲ್ಲಿರುತ್ತೆ ನೋಡಿ, ಟಾಪಲ್ಲಿ ಇರುತ್ತೆ, ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಹೇಳ್ತಾರೆ. ಥರ್ಡ್ ಲಿಸ್ಟ್ ಇಲ್ಲಿ, ಥರ್ಡ್ ಲಿಸ್ಟ್ ಇಲ್ಲಿ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇಲ್ಲಿ ಧಾರವಾಡ ಇತ್ತು, ಧಾರವಾಡ ಬಂತು. ಥರ್ಡ್ ಲಿಸ್ಟ್ ಇಲ್ಲಿಗೆ ಇಟ್ಬಿಡಿ. ಎಷ್ಟಿದಾವೆ? ಜಾಗ ಸಾಲಲ್ಲ ಅನ್ಸುತ್ತಲ್ಲ ಇದು? ಬೇಕಾದ್ರೆ ಇದನ್ನು ಕೆಳಗೆ ಇದ್ಯಾವುದು? ಹೋಗ್ಬೇಕು, ಇದೆಲ್ಲ ಇರ್ತಾವಲ್ಲ ಬೇಸಿಕ್ ಕೆಲಸ ಮುಗಿಸಿ ಹೋದ್ರೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ನೋಡ್ಸಿರ್ಕೋಬೇಕು, ಏನಿದೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇರುತ್ತೆ ಅದೆಲ್ಲ ಮಾಡ್ಬೇಕು.
ಜೂನ್ 1 ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. 2 ಸಲ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಮೊನ್ನೆ 22 ಬರುತ್ತೆ, 30 ಬಂದಿಲ್ಲ.
ಅಲ್ಲಿ ಯಾಕೆ ಅಂತ ಹೋಗಿ ಕೇಳಿ ನೀವು ಬ್ರಾಂಚ್ ಅಲ್ಲಿ.
ಅದು ಒಂದ್ಸಲ ಆರ್ಜೆ ಮುಂದೆ ಬಂತು.
ಆರ್ಜೆ ಎಷ್ಟು ಟೈಮ್ ಕೊಟ್ರು?
ಅದೇನಿರ್ಲಿಲ್ಲ, ಆಫೀಸರ್ ಜೊತೆ ವಕಾಲತ್ ಇರ್ಲಿಲ್ಲ.
ಅಲ್ಲ ಏನಾದ್ರು ಆಗ್ಲಿ, ಅಲ್ಲಿ ಏನೋ ಒಂದು ಆರ್ಡರ್ ಆಯ್ತಲ್ವಾ?
ಬಿಫೋರ್ ಕೋರ್ಟ್ ಅಂತ ಆಗಿದೆ.
ಆ ಫೈಲ್ ಅಲ್ಲಿಂದ ಬಂತೋ ಬರ್ಲಿಲ್ವೋ ಗೊತ್ತಿಲ್ವಲ್ಲ. ರಿಜಿಸ್ಟ್ರಾರ್ ಕಡೆಯಿಂದ ಫೈಲ್ ಬಂದ, ಫೈಲ್ ಇದ್ರೆ ತಾನೇ ಹಾಕಕ್ಕೆ. ಅಲ್ಲಿಂದ ಫೈಲ್ ಬಂದಿದ್ಯಾ ಇಲ್ವಾ ನೋಡ್ಕೊಳ್ಳಿ. ತುಂಬಾ ಅರ್ಜೆನ್ಸಿ ಇತ್ತು ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಹಿಂದೆ ಬಿದ್ದು ಮಾಡಿಸ್ಕೋಬೇಕು. ನಾವ್ ಎಲ್ಲಿರ್ತೀವಿ?
ಜೂನ್ 1 ರಿಓಪನಿಂಗ್
ಇವತ್ತು ತೆಗಿತಾ ಇದೀವಿ.
ಜೂನ್ 1 ಮೆಮೊ ಮಾಡಿದ್ರು.
ಅದೇ ನಿಮ್ ಬ್ರಾಂಚ್ ಹೋಗ್ಬಿಡಿ. 48 31977 ಆಗೋಯ್ತಾ? ಹಾ, ನೆಕ್ಸ್ಟ್ ಹೇಳ. ಅಷ್ಟೇ ಅಷ್ಟೇಪ್ಪ, ತೆಗೆದ್ಬಿಟ್ಟಿದೀನಿ. ನೀವು ತೆಗಿತಿದ್ದೆ ಅಷ್ಟೊಂದು ಡಿಸ್ಟರ್ಬ್ ಆಗ. 41 ಅಷ್ಟೇ. ಫಾಸ್ಟ್ ಓವರ್ ಜೋಡಿಸ್ಕೊಂಡು ಹೇಳಿ. ಸೊ ಇಷ್ಟಿದೆ ಸರ್, ಒಂದು 5-6 ಇದೆ. 21 ಮುಂಚೆ 1, 2, 4th one. ಹೌದು ಇದೆ ಇವತ್ತು. ಇದೆ ಇವತ್ತು ಬಂದಿದೆ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಹೌ ಲಾಂಗ್ ಎಲ್ಲ ಗೊತ್ತಿಲ್ಲ, ಒಟ್ನಲ್ಲಿ ತಗೊಂತಾರೆ ಫಸ್ಟ್ ಅದೇ. ವಿಚ್ ಲಿಸ್ಟ್? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್. ಪೆರೋಲ್ ಮ್ಯಾಟರ್. ಈಚ್ ಫೈಲ್ ಅರೌಂಡ್ 3 to 4 minutes.
Because my case is in 40,
It will reach. Don't worry.
So that I will
Wait. It will take 2-3 minutes to each file. Then an hour. No, second list. First Dharwad, then second list, third list.
Second list taken short time, but third list taken some time.
Third list is first second list only, then only third list. First Dharwad, second list, third list, past hours, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ಕಾಯ್ಬೇಕಷ್ಟೇ. First Dharwad, only one matter, then second list, then third list, past hours, continue. ಒಂದೊಂದ್ ದಿನ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಇರೋದೇ ಇಲ್ಲಪ್ಪ. ಹೌದು.
ಅವರಿಗೆ ತಮ್ಮ ಅವಧಿ ಸಂಪೂರ್ಣ ದಾಖಲಾತಿ ಮಾಹಿತಿ ಪ್ರಭಾರವನ್ನು ಹಸ್ತಾಂತರಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಪ್ರಭಾರವನ್ನು ಹಸ್ತಾಂತರಿಸಿದ್ದಲ್ಲಿ ದಾಖಲಾತಿಗಳನ್ನು ಪಡೆಯಲು ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಅನುಸರಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಆದರೆ ಯಾವುದೇ ಕ್ರಮ ಅನುಸರಿಸದೆ ಇರುವ ಕಾರಣ ಸಂಬಂಧಪಟ್ಟ ಅನುಮಾನ ಉಂಟಾಗಿರುತ್ತದೆ. ದಿನಾಂಕ 4/3/23ರಂದು ನಡೆದ ವಿಚಾರಣೆ ಸಂಘದ ಸಂಸ್ಥೆಯ ಕಾರ್ಯದರ್ಶಿಯವರಾದ ಕುಮಾರ್ ಮತ್ತು ತಮ್ಮ ಮೌಖಿಕ ಹೇಳಿಕೆಯಲ್ಲಿ ನೀಡಿ 97ರಿಂದ ಈವರೆಗೂ ಸಂಸ್ಥೆಯ ಎಲ್ಲಾ ವ್ಯವಹಾರವು ಅಧ್ಯಕ್ಷ ಸುಪರ್ದಿಯಲ್ಲೇ ನಡೆಯುತ್ತಿರುವುದೆಂದು ಆರೋಪಗಳು ಸಂಬಂಧಪಟ್ಟ ದಾಖಲಾತಿಗಳು ಮಾಹಿತಿಗಳು ಅಧ್ಯಕ್ಷರು ಸಲ್ಲಿಸಬೇಕಾಗಿರುತ್ತದೆ ಎಂದು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಆರೋಪಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ದಾಖಲಾತಿಗಳನ್ನು ಒದಗಿಸುವ ಬಗ್ಗೆ ವಿವಿಧ ದಿನಾಂಕದಂದು ವಿಚಾರಣೆಯಲ್ಲಿ ಅಧ್ಯಕ್ಷರು ಹಾಗೂ ಕಾರ್ಯದರ್ಶಿಯವರು ಗೊಂದಲ ಹೇಳಿಕೆ ನೀಡಿರುವುದು ಹಲವು ಅನುಮಾನಗಳಿಗೆ ಎಡೆಮಾಡಿಕೊಟ್ಟಿದೆ. ದಾಖಲಾತಿಗಳನ್ನು ಸಲ್ಲಿಸಲು ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶ ನೀಡಿದ್ದರೂ ಸಹ ತಮಗೆ ನೀಡಿರುವ ಅವಕಾಶವನ್ನು ಉಪಯೋಗಿಸಿಕೊಳ್ಳಲು ವಿಫಲರಾಗಿದ್ದು ಅಧ್ಯಕ್ಷ ಆರೋಪಿತ ಅಂಶಗಳಿಗೆ ಸೂಕ್ತ ಹೇಳಿಕೆ ಹಾಗೂ ದಾಖಲಾತಿಗಳನ್ನು ಒದಗಿಸಲು ವಿಫಲರಾಗಿರುವುದರಿಂದ ಸದರಿಯವರು ಈ ನಡೆಯ ಉದ್ದೇಶಪೂರ್ವಕವೆಂದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿದ್ದು ಆರೋಪಗಳು ಗುರುತರವಾಗಿದ್ದು ಕ್ಲಬ್ಬಿನ ಆರ್ಥಿಕ ವ್ಯವಹಾರಕ್ಕೆ ಹಾಗೂ ಸದಸ್ಯತ್ವ ಹಕ್ಕುಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟಿರುವುದು ಕಂಡು ಬಂದಿದ್ದು ನಾಗರಬಾವಿ ಕ್ಲಬ್ನ ಸರ್ವ ಸದಸ್ಯರ ಸಂಸ್ಥೆ ಸದಸ್ಯರ ಹಿತಾಸಕ್ತಿ ಪ್ರಾಮುಖ್ಯವಾಗಿದ್ದೆಂದು ಅಭಿಪ್ರಾಯಪಟ್ಟು ಸದರಿ ವರದಿಯನ್ನು ತಮಗೆ. Notes, I just read this to show.
But according to you have given 400 pages.
Notes, we have given 400 pages on the first hearing date, 1350. He did not receive it. He records the proceedings in his own way. But what is next required is, it's an inquiry. Section 25 inquiry, the registrar who conducts an inquiry or the officer who is authorized to conduct the inquiry exercises the power of a civil court. Let's kindly have a look at the rules. Section 25 I will read and then go to the rules, my lords. Rules I'll read. Act. Niyama.
Yes, 25.
So just. But section 25 is an enabling provision. The registrar may on his own motion and shall on an application of the majority of the members of the governing body or of not less than 1/3 of the members of the society hold an inquiry or direct some person authorized by him in order in writing in accordance with the rules made in this behalf to hold an inquiry into constitution, working and financial condition of the registered society. Then the registrar or the person authorized by him under subsection 1 shall have the following powers, namely, he shall at all reasonable times have free access to the books, accounts, documents, security, cash and other properties belonging to or in custody of society. Documents, security, produce the same at any place at the headquarters of the society or the branch thereof. He may summon any person who has reason to believe had the knowledge of any affairs of the society to appear before him in any place at the headquarters of the society or any branch thereof, and he may examine such person on oath. He may, notwithstanding anything contained in this act or any rule or regulation prescribing the period of notice for a general meeting of society, require the governing body of the society to call for a general meeting at such time and place at the headquarters of the society or any branch thereof to determine such matters as may be directed by him. If the governing body of the society refuses or fails to call a meeting, he shall have the power to call it himself. Any meeting called under clause 1 shall have the powers of general meeting called under the rules and regulations of the society, and its proceedings shall be regulated by such rules. When an inquiry is made under this section, registrar shall communicate the result of the inquiry to the society concerned. Now, this is the extensive powers which is vested in the registrar of the societies. He cannot say that I am going to decide a dispute like an adversarial litigation. This is an inquisitorial proceedings which is conducted. Therefore, the word used is inquiry. He has to conduct an inquiry. He has got access to everything. Now, assuming, my lords, that the office bearers are not cooperating, he can go himself and take a custody of all the documents which is available. He can summon any person whom he suspects is having the custody of the documents for the purpose of looking into as to whether these allegations are true or correct.
Is it your case that you are not given, or is it your case that you are given?
Lords, we offered to give these documents. He never accepted these documents. Once 400, once 1,350
You have all
pages.
the documents that you want to give with you?
We have it.
Yes, madam.
We have it. Lords, just one more statement, my lords. Now, the other exercise which is undertaken is, he says that this is to be done. But what is to be done in an inquiry, my lord? These are all serious matters. My lords, I wanted to say this. Once he wants to recommend for appointment of an administrator, it is an expropriatory exercise. Because a body which is coming to existence in accordance with law, he cannot dislodge it. What is that which is required to do is, there are 35 allegations. In relation to each one of the allegation, he has to record a finding. Inquiry officer is required to record a finding. This is the allegation. This is the statement made. This is the materials which I have collected, on the basis of which I am reaching these findings.
Right
He
now,
cannot
we
say.
come to a conclusion that you are not given. Now you are ready to,
Lords,
whether you gave it or not, you are ready to give it now.
Lords,
Yes,
then
sir.
the order of the government, my lords, if your lords may kindly have a look at the order of the government, annexure H.
Just one. Their main grievances, whatever they wanted to give, has not been considered. Now your contention is it was not given. Now that they are ready to give, we'll set this aside. Let them give the papers. You consider all the papers.
My lords, even now he can cooperate with the inquiry. The inquiry, we have asked the administrator to give the documents. The administrator says it's under lock and key.
Administrator is a different.
Administrator has now taken over. My lords, it is, my lords, two arguments, my lords.
Administrator has already taken over.
He has taken over in the month of April.
After filing the petition, my
No,
lords.
Okay, then you complete your argument.
Kindly have a look at, my lords. Now page number 70, annexure R12, your lords may kindly take, which is filed along with the statement of objections. Lords, the apathy is that the order appointing the administrator is not communicated to the society. It goes to the administrator, and administrator comes and says that I want to take charge. 14th, my lords, we have filed this petition. 14 lords will see 14/5/2026.
Learned senior counsel, my lords.
When did you file your?
I will make a mention.
I'll just
14/5/2026.
interrupt learned senior counsel. My lords have protected them. There is an interim order.
I am arguing the matter. Why is my learned friend interrupting?
As of now, my lords, it was brought to the notice
No,
of the honorable
I'm
court.
arguing this matter.
Just a moment.
An expropriatory exercise, you can't hold for.
Shankar, you can't be aggressive in everything.
No, my lords, I'm sorry, my lords. They wanted to
submission
interrupt, therefore I
being
told them that it is not necessary to interrupt. I'll conclude my arguments, then the field is theirs. I'll not interrupt them.
Sometimes some submission which comes from the other side may be in your favor.
Maybe, my lords. Of course, last time it happened.
It happened.
It happened.
You should have that. Yes.
It happened. Lords, kindly have a look at annexure R12. Lords, we had filed this writ petition on 14th May 2026, initially saying that this entire exercise is mala fide. Please don't permit any further proceedings to take place, because we know that it's going to be a fait accompli. Lords, then on 14/5/2026 itself, the government passes an order appointing the administrator, which we have subsequently produced and challenged it by means of an amendment. Now, Lords, may kindly have a look at annexure R12. Produced along with the statement of objections. Can I just pursue it? Lords, may kindly see page 72, my lords.
Yes.
Lords, up to that numericals, my lords, he only extracts whatever is the proceeding said to have been conducted by the inquiry officer as reported by the inquiry officer. ಸಂಘದ ಪ್ರಾರಂಭದಿಂದ 97ನೇ ಇಸ್ವಿಯಿಂದ ತಹಲ್ವರೆಗೂ ಇದೇನಿದೋ ಅವರು ಖಜಾಂಚಿ ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತಾರಲ್ಲ 1 2 3 4 ಅಂತ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರು. ನೆಕ್ಸ್ಟ್, ಆರೋಪಿತ ಅಂಶಗಳಿಗೆ ದಾಖಲಾತಿಗಳನ್ನು ಸಲ್ಲಿಸಲು ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶ ನೀಡಿದ್ದರೂ ಸಹ ತಮಗೆ ನೀಡಿರುವ ಅವಕಾಶವನ್ನು ಉಪಯೋಗಿಸಿಕೊಳ್ಳಲು ವಿಫಲರಾಗಿದ್ದು, ಅಧ್ಯಕ್ಷರು ಆರೋಪಿತ ಅಂಶಗಳಿಗೆ ಸೂಕ್ತ ಹೇಳಿಕೆ ಹಾಗೂ ದಾಖಲಾತಿಗಳನ್ನು ಒದಗಿಸಲು ವಿಫಲರಾಗಿರುವುದರಿಂದ ಸದರಿಯವರು ಈ ನಡೆಯು ಉದ್ದೇಶಪೂರ್ವಕವೆಂದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿದ್ದು, ಆರೋಪಿಗಳು ಗುರುತ್ವವಾಗಿ ಕ್ಲಬ್ಬಿನಲ್ಲಿ ಆರ್ಥಿಕ ವ್ಯವಹಾರಕ್ಕೆ ಮತ್ತು ಸದಸ್ಯತ್ವಕ್ಕೆ ಹಕ್ಕುಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಕಂಡು ಬಂದಿದ್ದು ನಾಗರಬಾವಿ ಕ್ಲಬ್ ಸದಸ್ಯರ ಸಂಸ್ಥೆಯಾಗಿದ್ದು ಹಿತಾಸಕ್ತಿ ಪ್ರಮುಖವೆಂದು ಅಭಿಪ್ರಾಯಪಟ್ಟು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಇಲ್ಲಿ ತನಕ ರಿಪೋರ್ಟ್. ನೆಕ್ಸ್ಟ್, ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ಸಹಜ ನ್ಯಾಯ ತತ್ವದಡಿ ದಾಖಲಾತಿಗಳನ್ನು ಹೇಳಿಕೆಗಳನ್ನು ನೀಡಲು ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶ ನೀಡಿದ್ದರೂ ಸಹ ಅಧ್ಯಕ್ಷರು ಆಡಳಿತ ಮಂಡಳಿ ಗೊಂದಲಕರ ಹೇಳಿಕೆಗಳನ್ನು ಹಾಗೂ ಪತ್ರಗಳನ್ನು ನೀಡಿರುವುದು ಕಂಡು ಬಂದಿದ್ದು, 24-25 ವಾರ್ಷಿಕ ಮಹಾಸಭೆಯನ್ನು ಕಾನೂನು ರೀತಿಯ ನಡೆಸದೇ ಇರುವುದು, 25-26ನೇ ಸಾಲಿನ ಆಯವ್ಯಯ ಅನುಮೋದನೆ ಆಗದೇ ಇರುವುದು ಅಲ್ಲದೆ ಕ್ಲಬ್ನ ವಿರುದ್ಧ ಮಾಡಿರುವ 30 ಆರೋಪಗಳಲ್ಲಿ ಹಣ ದುರುಪಯೋಗ, ಅಧಿಕಾರ ದುರುಪಯೋಗ, ಸದಸ್ಯತ್ವ ನೀಡಿಕೆಯಲ್ಲಿ ಗೊಂದಲ ಹಾಗೂ ಅವ್ಯವಹಾರ, ಅಸಮರ್ಪಕ ಲೆಕ್ಕಪತ್ರ ನಿರ್ವಹಣೆ, ಬೈಲಾ ಉಲ್ಲಂಘನೆ, ಸದಸ್ಯತ್ವದ ಪಟ್ಟಿಯಲ್ಲಿನ ಗೊಂದಲ, ನೂತನ ಕಟ್ಟಡಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಅವ್ಯವಹಾರ, ಕ್ಲಬ್ಬಿನಲ್ಲಿ ಉಂಟಾಗಿರುವ ಆರ್ಥಿಕ ನಷ್ಟ ಇತ್ಯಾದಿಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ್ದು ಆರೋಪಗಳಿಗೆ ದಾಖಲಾತಿ ಮುಖೇನ ಸಮಜಾಯಿಷಿ ನೀಡಿ ಆರೋಪಿಗಳನ್ನು ಒಪ್ಪಿಕೊಳ್ಳುವ ಅಥವಾ ತಿರಸ್ಕರಿಸುವ ಪ್ರಯತ್ನವನ್ನು ಮಾಡದೆ ನೀಡಿರುವ ಅವಕಾಶವನ್ನು ಬಳಸಿಕೊಳ್ಳದೆ ಇರುವುದು ಕಂಡಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಸಂಘಗಳ ನೋಂದಣಿ ಅಧಿನಿಯಮ 27 ಅನ್ವಯ ಆಡಳಿತಾಧಿಕಾರಿಗಳು ಇಟ್ಸ್ ಲೈಕ್ ಎನ್ ಎಕ್ಸ್ಪರ್ಟ್ ಡಿಗ್ರಿ. You have not come and contested the proceedings. I am passing an ex parte decree. But if your lordships were to see notes 27A, that's not the exercise. 27A is not that wherever there are allegations made, everything may come within the purview of section 25. Section 25, my lords, an inquiry may be conducted and the report will be sent to the society.
Yes.
It never contemplates the circumstance that the report is required to be sent to the government under section 25, which I read to your lordships. 27A now, your lordships may kindly see, my lords. But your lordships have dealt with in extenso 27A, 1A and 1B in Shivanna's case.
Yes.
Now this is 27A, 1C. Where on a report, lords, I'll just read it from the beginning. Notwithstanding in this anything in this act, where on a report, I'm going to subclause C. Where on a report made by the registrar or otherwise, on inquiry, the state government considers it necessary in public interest so to do. The state government may by order publish in the official gazette appoint an administrator for the society for such period not exceeding 6 months as may be specified in the order and manage the affairs of the society. Notice what is the condition precedent is if the government considers it necessary in public interest so to do. Not every allegation requires the appointment of an administrator. If the government does not record in its order explicitly that public interest requires that the administrator is to be appointed, the government does not have the factual background or the foundational facts for the purpose of exercise of jurisdiction under 27A 1C. That is the requirement. Next, government is required to conduct an inquiry. Let us assume there is a report which is submitted by the registrar.
Where is the government required to conduct?
Lordships may kindly see C, my lords, that of course covered by the judgments of the
Report made
coordinate
by the
benches.
registrar or
Where on a report made by the registrar or otherwise on inquiry, the state government, this is interpreted, my lords, by the coordinate bench where it says that government is to conduct the inquiry. Lords, this is again, my lords, the reason why I am submitting this is these are not some kind of adversarial proceedings that there is one complainant, you make 20 allegations, you make an issue a notice to the president. President does not come. I am passing an ex parte order saying that administrator is to be appointed. That's not at all how it is designed. It is an expropriatory exercise. It's an extreme step. You are dislodging a democratically elected body. So the only condition which is imposed on the state, which is required to be complied with, is that there is an overwhelming public interest to exercise such powers. Now the rules, my lords, can I just take your lordships to the rules? 69.
Yes.
It is in consonance with what is specified in 25, section 25, my lords. Rule 8, inquiry by the registrar. Where the registrar proposed to hold an inquiry under 25, either on his own motion or on an application, he or the person authorized in his behalf under the said section to hold an inquiry shall issue notice to the society concerned. Said notice shall specify a date on which the place in which the time at which and also the matters in respect of which the inquiry will be held. Notice shall call upon the society to furnish its explanation respect of matters referred to therein before the date specified. Society shall furnish its explanation to registrar or the authorized person before such date. On the date fixed for inquiry or on such other date, the date or the dates on which the inquiry might be adjourned, the registrar or the authorized person shall give the society a oral hearing
He may also examine such persons as may be considered necessary. He may receive all relevant document. If the society fails to furnish its explanation as required under sub-rule 3 or to attend the inquiry on the date fixed or the adjourned date, the registrar or the authorized person may proceed with the inquiry ex parte. On the completion of inquiry, registrar or the authorized person shall record his findings and communicate the same to the society concerned. Notes, the reason why I read this to your lordships is, let us assume we don't participate in the proceedings. Nobody participates in the proceedings. Even then, what is required is he has to record the findings in relation to, notes, that is sub-rule 2, the matters in respect of which the inquiry will be held, sub-rule 2. So he will tell these are the matters for which I will conduct an inquiry. Then he has to give findings on all the matters on which he is conducting an inquiry. Not similar to an articles of charge.
Yes.
I'm in a position to demonstrate. Neither the inquiry officer makes this effort.
No charges have been framed.
No charges. Charges are spelled out. But after they, what happened? They first gave one list of charges, and they 19 charges were pointed out at the first instance.
Page number?
They commenced the inquiry.
Page number, where is the charge?
It's page number 24.
Of the petition.
Yes. There are 19 points in this, up to page 27. And then, this is the inquiry notice on 9/12/2025. This is the order appointing the inquiry officer. Then, my lords, your lords may kindly see page number 28.
Annexure B.
ಹೆಚ್ಚುವರಿ ವಿವರಣಾ ಅಂಶಗಳು ಅಂತ ಅಲ್ಲಿ ಸೇರಿಸಿದ್ರು 27/1/26 ನಲ್ಲಿ. ಅಷ್ಟರೊಳಗೆ ಒನ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಮುಗ್ದೋಗಿತ್ತು ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ಮುಂದೆ. ಇದಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನಂಬರ್ 43, 23/1/26. they add 11 more points. Same thing. ಅದನ್ನ 19 ಇತ್ತು, ಆಮೇಲೆ ಅದನ್ನ 4 ಹಾಕಿದ್ರು, ಇವಾಗ ಇನ್ನೊಂದು 11 ಮಾಡಿದ್ರು. ಇಲ್ಲಿದೆಯಲ್ಲ 28 ತನಕ ಇದೆ, ಹಿಂದೆ ಮುಂದೆ ಆಗಿದೆ ಇಲ್ವಾ?
43, 11 more charges.
Yes. Now, if your lordships were to see, my lords, the inquiry officer's report. Sorry.
Where is the addition? Okay.
Where is the
next page?
A report, my lords, in the inquiry officer's report, which is at page 31.
What is 46, 47?
46, 47 is again the same list, my lords.
That is different.
19. It is actually what happens is they have included along with this. This has come as a continuation. This is that same 19 which was there in the first notice. The same 19 which was in the first notice.
What happened to the other 4?
Now, after this, my lords, if your lordships were to see page number 31, inquiry officer's report. At page number 32, he extracts up to serial number 19. At page up to page 34. Then from page 35, he adds this 11 more charges at page 35.
Yes.
After that, page 37, I have read it to your lordships. Ulleka, Nakra, Adasha, so all these things which you have read it out.
So the time, yes.
Yes. Now, other than this, there is no individual findings given in respect of each one of the charges. What materials is available, how he has considered, how prima facie he finds that there is something which is on the base of which I have to be held guilty.
Yes.
Of course, then what happened, my lords? The administrator takes charge on that same day, though he was not an administrator because it was not gazetted on that day, to our information. They are yet to come out with that information. We could not get that information. But as on that date, there was no gazetting. When the matter comes before this honorable court, it came before a vacation bench. Then the learned single judge directed that you get the instructions whether it is. The next date of hearing, that is recorded in the order sheet, which your lordships have already seen. The administrator comes and opposes the grant of an interim order by engaging the service of a counsel. Then your lordship specifically directed, of course, don't
Yes.
Therefore, my lords, even if I have no difficulty, my lords, we had got those documents on the first hearing date only to show that we had these bundles of documents which we wanted to hand it over to the inquiry officer, which he did not receive. Even before the state, my lords, they never issued an inquiry notice. They said that this is not an inquiry notice. They say that you will have to come and give a response whether or not. It is not an inquiry notice. Inquiry is required to be conducted again to find out whether or not the charges are there in a manner that it attracts the public interest for invoking the jurisdiction under section 27A1C.
Yes.
So that's my submission.
Yes, madam.
Can I seek your lordship's excuse? I just.
May I reply day after tomorrow, my lords?
I'm reading a message who are a complainant. After the complaint, they explained everything. Before the complaint, what is complaint? Kindly permit me to read that complaint.
Let the additional advocate general is appearing. You are only a complainant. Day after tomorrow. L. Shri D.R. Ravishankar and senior counsel for the petitioner. For the submissions of learned additional advocate general, relist on 24th at 2:30 p.m.
Great,
Interim order earlier granted is extended till next date.
grateful.
Serial number 7. Delegation.
Impleading applicant is the first petition. I have also filed a writ.
You are impleading application. We thought we had completed all those things last time. Still some things are left. You have filed it subsequently.
We have filed our objections to the impleading applications.
You are opposing it.
My lord, I am upgrading applicant. I had 2 for 26 in impleaded application.
Yavrali.
Ugradi application.
In serial number 7. IA 2 of 26. BN Jaydeva. Shri BN Jaydeva submit that he does not press IA 2 of 26. Hence IA 2 of 26 is dismissed as not pressed. Memo hakidra. Shri BN Jaydeva has filed a memo.
No objections. ಸತಿ ಖುಷಿ ಮಾಡ್ತೀರಾ ಯಾರ್ದು
One Mr. Mohammed Shafiq Arshad had filed an application IA 2 of 26. A memo has been filed on his behalf today, which reads as under. Signed by the impleading applicant and counsel for the impleading, which reads as under. Accepting the said memo, the impleading application is dismissed as withdrawn. In IA number 2 of 26 is dismissed as withdrawn.
Please, my lord, I have filed IA number 3 and 4.
You have filed IA 3 and 4. And you have filed IA 6 and 7. And you have filed objection to both the set of applications. So yes, Mr. Who will start? 3 and 4?
I have to start.
Or 6 and 7? 3 and 4 seniority is this, in terms of number. Between both of you, whoever starts, which one?
Lords, I have to only say 2 things.
In the arguments on the impleading application, because he is opposing it. So who wants to start?
There's one IA 1 of 26. I'm IA 1 of 26.
1 of 26, then you have the seniority. 1 of 26.
No, seniorities.
Lord, sir.
Whosoever IAS first gets the seniority.
Lord, sir, in this matter,
Yes.
what had happened is, my Lord, sir, there was an arbitration award which was passed by a majority tribunal. I got the arbitration. I appear for the proposed respondent number 6 and 7.
Any conflict that we have with this parties?
I have no idea, my Lord, sir. I don't think so.
We are not sure, but
It's a matter of Richmond Road, my lord.
that yes, that we don't have any conflict.
No, I'm saying
This,
that Muslimji developers and
but then
I'll have to ask the client, my Lord, sir. Otherwise,
have we appeared for them ever?
I don't know, my Lord, sir. I'm not sure.
Remember, but there's some doubt.
Then, my Lords, may take it up next week in the meantime. And even otherwise, my Lords, according to me, the petition has become infructuous because, very well, very well. I'll just keep it at that.
May I make one request? Vichar's Monday or Tuesday, my lord, because our problem is on the time constraint.
Relist on 28th. Verify that and.
I'll verify.
Same list ಇದು list 2 ಅಲ್ಲಿ 2:30.
At 2:30. It will continue in list 2.
Please, please.
Yes, Mr. Abhijit.
I have two judgments to my lord, the place before your lordship, my lord. Two judgments, my lord.
You want to place 2 more?
Yes, my lord.
Yes.
Here, my lord, Shamsher Singh has been followed by Constitution Bench, the Supreme Court.
Just one submission. Valla sir and AG will be arguing, lords. There's one difficulty. The KPSC has something to say in this matter. I had some personal difficulty, my lords. I may be permitted to reply on tomorrow or Friday, my lords.
How long?
They will take some time, lords. But
They're not
therefore,
disciplinary
there
authority,
was-
nor
I
the
had-
controlling authority, not
I had-
appointing authority.
I was leaving for Kalburgi.
That
night,
petition
I had to
they
catch a
had
flight.
failed.
That was a difficulty.
What time is your flight?
6 o'clock, it got postponed to 7:10. I have to leave by 4:45 minutes. That was a difficulty. So I will reply. They will take some time, my lords.
So you will appear on VC tomorrow and.
Please, my lords. Tomorrow I can appear on VC. VC, my lords. Please. my lords.
We'll have it tomorrow after.
Please, my lords. Please. Great.
Yes.
Or if it could be Friday, my lords, it would be on.
You want to be here personally?
Please, my lords. It's for the commission had something to say. Please. Grateful. I'll take leave, my lords. Grateful.
Yes, please.
Yes, great.
Two judgments and 4 ಕೊಟ್ಟು. Yes, which one? Very good.
Judgment, Nabam Rabia.
Nabam Rabia.
Powers of the Article 163, aided assistance.
Hmm.
But the page 158. Para 153 on.
Yes.
Though the debate could be endless, we have to consider the opposite adversary decisions rendered by this court in Sundarlal case and Shamsher Singh case. Insofar as Sundarlal is concerned, this court has there is the president of or the governor applicable to pass an order only on his personal satisfaction. In the above case, this court, while examining the case of the employee under Article 311 clause 2, more particularly under proviso C thereof, recorded the conclusions in the manner expressed above. The same issue was placed before the second-judge bench to examine the position adopted in Sundarlal case, Sardarilal case. The position came to be reversed. The court in case Shamsher Singh case declared that wherever the constitution required the satisfaction of the president or the governor for the exercise of any power or function, as for example under Article 123, 213, 311 clause 2, 317, 352(1), 356, 360. The satisfaction required by the constitution was not personal satisfaction of the president or the governor, but it is the satisfaction of the president or the governor in the constitutional sense under the cabinet system of the government. It is therefore clear that even though the governor may authorize to exercise some functions under the different provisions of the Constitution. The same are required to be exercised only on the basis of the aid and advice rendered to him under Article 163 unless the governor has been expressly authorized by or under constitutional provision to discharge the functions concerned in his own discretion. There are 54 more. We are therefore the considered view that insofar as exercise of discretionary powers vested with the governor same is limited to situations wherein constitutional provision expressly so provides that the governor should act in his own discretion. Additionally, the governor can exercise his functions in his own discretion in situations where the interpretation of the constitutional provision is concerned could not be construed otherwise. We therefore hereby reject the contentions advanced on behalf of the respondent that the governor has the freedom to determine when in the situation he should take a decision in his own discretion without the aid and advice of the chief minister and his council of ministers. He accordingly also turned down the contention that whenever the governor in his discharge of his functions takes a decision in his own discretion, the same would be final and binding and beyond the purview of judicial review. We are of the view that the finality expressed in Article 163 clause 2 would apply to the functions exercised by the governor in his own discretion as are permissible within the framework of the Article 163 clause 1. And additionally, situations where the clear intent underlying a constitutional provision is so requires, that is, where the exercise of such power on the aid and advice would run contrary to the constitutional scheme or would be contradictory in terms. The conclusions we are therefore summarize our conclusions on that. Point 1. Firstly, the measure of discretionary power of the governor is limited to the scope postulated thereof. The article is 163 clause 1. Secondly, the article 163 clause 1 discretionary power of the governor extends to situation wherein the constitutional provision expressly requires the governor to act on his own discretion. And thirdly, the governor can additionally discharge functions in his own discretion where such intent emerges from the legitimate interpretation of the provision concerned. The same cannot be considered otherwise. Fourthly, in situations where the court has declared that the governor should exercise a particular function in his own hand without any aid or advice because of the impermissibility of their alternative by reason of conflict of interest. The submission advanced on behalf of the respondent that exercise of discretion under Article 163 clause 2 is final and beyond the scope of judicial review cannot be accepted, firstly because we have rejected the submission advanced by the respondents that the scope and the extent of discretion vested in the governor has to be ascertained from Article 162 clause 2, 163 clause 2 on the basis of whereof the submission was cannot. And secondly, any discretion exercised beyond the governor's jurisdiction authority would certainly be subjected to judicial review. So now, the para 166 classitum B and C below. In a situation where page 165.
Yes. 166 in view of the consideration.
In a situation where governor has reason to believe that the chief minister and his council of ministers have lost the confidence of the house, it is open for the governor to require the chief minister and his council of ministers to prove their majority in the house by a floor test. Only in a situation where the government in power on holding of such a floor test is seen to have lost the confidence of the majority, it will be open for the governor to exercise the powers vested with him under Article 171 at his own and without any aid and advice. This is the situation where governor can act without the aid and advice. But now, conclusion, set aside 169, para 176. Article classical B, Article 161.
Page number? Page number?
Page
169.
We have therefore no hesitation to conclude that the message addressed to the governor to the assembly must abide by the mandate contained under Article 161 plus 1, namely that same can be only addressed to the legislature. the message of the governor was therefore beyond the constitutional authority vested with the governor. But accordingly, liability is set aside and ordered accordingly. Then, my lord, para 183 at page 171. Page 171.
Yes.
Tacitum H. In our final analysis, we are satisfied that the concluding that interdicts the hands of the governor in functioning of the state legislature not expressly assigned to him. However, bona fide would be extraneous and without any constitutional sanction. A challenge to an action beyond the authority of the governor would fall within the scope of the judicial review and would liable to be set aside. It may be the orders of the government, but if it is beyond the scope or without the jurisdiction, it has to be set aside. That's what the conclusion. Para 387, Lord, this is concurring, Lord, by judges, Lord, they
Page
383.
383.
Para 383. So 387 at page 249.
387 or 383 na?
249 page number.
Para
387.
387. That's it.
D.
Yes.
This clearly has reference to Article 163 of the Constitution of India and must be understood as meaning of framing the rules under Article 166(3) of the Constitution. It's not discretion of the governor, but an executive exercise undertaken by the Council of Ministers. Article 167 of the Constitution relates to the duty of the Chief Minister of a state to communicate the decision of the Council of Ministers to the governor and furnish information to the governor. Chapter 2 and of the Constitution is therefore quite compact and delineates the relations between the executive and governance of the state. But therefore, some shades has been not followed, appreciated in this constitutional judgment, but that is the final authority as on today. Apart from this, whenever governor exercises jurisdiction beyond or without the aid and advice, it has to be set aside, as set aside in this case. But these two judgments, have been followed in Mangalashram. Therefore, aid and advice is compulsory. And apart from these two judgments, post facto approval or advice, 2021 when SEC 20th SEC page 12.
Yes.
Relevant para is 264. So we have extracted the relevant portion in the written submission.
No, let us see what it is. 264.
Yes.
Para?
Para 264. Page 264, para 40.
Yes.
40, 15 and 70. We do not think that the absence of the expression prior approval in the aforesaid rule would have any impact so far as the present case is concerned, as the same rule has been construed by the court in B.V. Gopanath, and it has been held that the charge sheet or charge memorandum not having approval of the disciplinary authority would be non-est in the eye of law. Same interpretation has been given to the similar rule, all India services disciplinary rules 1969 by another coordinate bench of this court in the state of Tamil Nadu, and so now the question arises as to whether concluding proceedings and the pending proceedings against the appellant is capable of giving different interpretation to this. The High Court's reasoning referring to the notes on which the approval for initiation of the proceedings was granted is that the disciplinary authority had taken into consideration the specific charges. The ratio of the judgment in Ashok Kumar Das and Baja Hindustan in our opinion do not apply in the facts of the present case. We hold so because these authorities primarily deal with the question as to whether the legal requirement of granting approval to ex post facto approval, particularly in case where the statutory instrument does not specify taking prior or previous approval. It is the fact that the rules which we are concerned there is no stipulation of taking prior approval. But since there is this very rule has been construed by the coordinate bench to the effect that the approval of the disciplinary authority should be there before issuing the charge memorandum, the principles of law enunciated in the aforesaid two cases that the Ashok Kumar Das and Bajaj Hindustan would not aid the respondent. The distinction between the prior approval and the approval simpliciter does not have much impact so far as the statutes is status of subject charge memorandum is concerned. The next question we shall address is as to whether there would be any difference in the position of law. This case vis-a-vis Gopinath. In the later authority, the charge memorandum without approval of the disciplinary authority was held to be non-est. In a concluded proceeding, the High Court has referred to the variance of the expression non-est used in two legal phrases in judgment under the appeal. In the context of all these, the term non-est conveys meaning of something treated to be not existence because of some legal lacuna in the process of creation of subject instrument. It goes beyond a irremediable irregularity. That is how the coordinate bench has construed the impact of having approval, not having approval of the disciplinary authority issuing the charge memorandum. In the event the legal instrument is deemed to be not in existence because of certain fundamental defects in its existence, subsequent approval cannot revive its existence and ratify the acts done in pursuance of such instrument, treating the same to be valid. In fact, that the initiation of the proceedings received approval of the disciplinary authority would not lighten the obligation on the part of the employer in complying with the requirement of subsection 3 of Rule 14 of TCS CCA 1965. We have quoted the two relevant subclasses earlier in the statement. Contemplate the independent approval of disciplinary authority at both stages for initiation of the inquiry and also drawing up for the cause of be drawn up for the charge memorandum. In the event of requirement of subsection 2 is complied with, not having the approval of the time of issue of charge memorandum under subsection 3, which render the charge memorandum fundamentally defective and not capable of being validated retrospectively. What is non-existent in the eye of law cannot be revived retrospectively. Life cannot be breathed into the stillborn charge memorandum. In our opinion, the approval for initiating disciplinary proceedings and approval to a charge memorandum are two divisible acts, each one requiring independent application of mind on the part of the disciplinary authority. There is any default in the process of the application of mind independently at the same would get at the time of issue of charge memorandum by the disciplinary authority, the same would not get cured by the fact that such approval was there at the initial stage. But now in para 17, 267, allegations, that may be serious, but the procedures should be followed. We are of the conscious fact that the allegations against the appellant are serious in nature and ought not be scuttled on purely technical ground, but the tribunal in the judgment which was set aside by the High Court had reserved liberty to issue a fresh memorandum of charges under Rule 14 of TCS Rules 1965 as per the rules laid down in the matter, if so advised. Thus, the department's power to pursue the matter has been reserved and not foreclosed. But so far as the charge is concerned, even assuming it is grave, but the procedure, the rules, and the constitution should be followed. That's what the 269, 1999 3 SEC 422. This is for the purpose of saying about 31 page 279. Two judgments allowed to say that if law says something to be done in a particular manner, the same has to be done in that manner only. There cannot be any deviation. Para 13 is settled after the time and again has been quoted. Para 31.
Yes.
also, my lord, para 31, my lord, one more judgment, 2025 SEC online 774. On the same principle, my lord. 30 para 15. Page 286. Now, but all these propositions and there are points for consideration, you are placed on record, my lord, along with the written submission.
Yes.
And relevant portions are also extracted, my lord. Lordship may kindly set aside, my lord, the order of His Excellency Governor of Karnataka, suspending the petitioner.
Yes.
Lord, please take Article 166.
Constitution code.
Yes. One 163, my lord. 166 is what they were saying. Please come to 163. There shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his functions, except in so far as he is, by or under this constitution, required to function, exercise his functions, or any of them in his discretion. If any question arises whether any matter is or is not a matter in respect to which the governor is, by or under this constitution, required to act in his discretion, decision of the governor in his discretion shall be final. Validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his own discretion. The question whether any, and if so, what advice was tendered by the ministers to the governor shall not be inquired into in any court. This is, my lord, the provision of the article of the Constitution.
Yes.
What I am submitting before your lordship says, on the last occasion, my lord, if my lord sees, I, my lord, am required to act, my lord, whether in my own capacity or, my lord, on the basis of the aid and advice. My learned friend, my lord, pointed out one judgment, my lord, pertaining to, my lord, the Nabia's case, where their lordships have held that, my lord, I have to, my lord, act. Governor has to act in the my lord, taking the aid and advice of the Council of Ministers.
Yes.
Even there, if your lordship sees, it's something, my lord, far more drastic. If my lord sees, that was a case, my lord, where legislature was to be, my lord, prorogued and all that kind of a thing.
Yes.
Not, my lord, where somebody, my lord, has to be dismissed or, my lord, suspended. This is one aspect. The judgment there, my lord, has to be, my lord, construed in the factual background there. Is first submission of mine.
Mr. Walder, what would have to be established is whether
Please, my
this
lord.
action which has been taken,
Correct.
as to aid and advise the governor in the exercise function, except insofar as he is by or under this constitution required to exercise his function or any of them in his discretion.
Correct.
If this action comes under the exception, then there is no aid and advice
That's right.
required. If
Only
this
thing is, my lord, what I am relying upon is
not coming under that because
subsection
317 uses those words.
clause 2. Clause
Yes.
2 of Article 163.
But Shamsher Singh and Nabam,
My lord, I know that.
said
My lord, more than that, I don't want to say.
yes.
Now, the second issue is, what has happened is subsequently, my lord, on the last occasion, my lord, the state government, my lord, produced, my lord,
Yes.
with the memo, the documents. There has been a ratification of, my lord, the action of the governor.
There is no ratification.
I'll tell you, lord, ratification, my lord, is permissible. I'll point out.
Yes.
Please come to. Yaudu. My lords have that, my lord, day before yesterday or yesterday, they filed
What a
memo.
Memo filed by the state.
Yes, my lord. Yes, correct. Idea.
Yes.
If your lordships come to, my lord, page 1.
Yes.
On 16/7,
This is, my lord, the letter sent by, my lord, the chief secretary to the secretary to the governor with reference to the order dated 10/7/2026 of the honorable governor placing Shri so and so, chairman of the Karnataka Public Service Commission, under suspension until further orders with the view in view of the allegations of misconduct and misbehavior under spirit of Article 317(2) of the Constitution of India, pending inquiry by the Honorable President of India, ordering that the next senior most member of the Commission shall act as the chairman of the Karnataka Public Service Commission until further orders. State government concurs with the order passed by the Honorable Governor. Same may kindly be brought to the notice of the Honorable Governor. This is one. Now please turn the next page. Cabinet note. Subsequently, my lord, they have held a cabinet. The note, my lord, is
Subject
please
suspension.
come. Yes, my lord. Please come to page 6. This is a cabinet note which was placed in before the cabinet.
Yes.
Para 7, my lord, or paragraph 7 at page 6. Under Rule 21B of the Karnataka Government Transaction and Business Rules of 1977, following matters are submitted for the perusal and concurrence. By order number so and so dated 10/7/2026, Honorable Governor has, under Article 317(2) of the Constitution of India, placed Shri so and so, Chairman of the Karnataka Public Service Commission, under suspension with immediate effect, pending further orders from the Honorable President of India. The Honorable Governor has also directed next senior most member of the Commission shall discharge the function of the chairman until further orders. This has been approved. Please come to the next page.
This is Rule 21B.
21 of the, my lord, transaction of business rules.
What does that say?
Karnataka.
I'm just giving it.
Idea.
1 second. You're taking it.
Copy.
I can give the iPad itself.
The
In fact,
Advocate
copy is coming in a
General
minute. Copy is coming in a minute. In fact, I anticipated that. I just give it in a minute. Oh, sorry.
ಇರ್ಲಿ ಪರವಾಗಿಲ್ಲ
21B.
ಇದೆ ಇದೆ ನನ್ನ ಲ್ಯಾಪ್ಟಾಪ್ ಎಲ್ಲ ಹಾಕೊಂಡಿದ್ದೀನಿ ನಾನು ಇರ್ಲಿ doesn't matter.
So this is being brought before the chief minister.
Correct.
Or the minister in charge of the department.
Correct. And then, my lord, it is placed before the cabinet
The
itself.
contention is the chief minister is also the minister of DPR.
Correct.
Administrative.
As on today.
And it is placed before the cabinet. Cabinet ratifies it. The full cabinet ratifies it.
This is, shall not be placed.
This is a procedure. This is a procedure for laying down a decision. What and all can come to the cabinet, Malad. For example, Malad.
Certain things may not need not come before the cabinet. This, my lord, requires that it should become.
And what is the procedure? The in-charge minister has to place it to the cabinet.
That is fine, but where the question of post facto?
That's a legal position.
That's a legal question, but I'll answer that.
Yes, please.
If your lordship sees, my lord, today it is approved. Whether, my lord, post facto, my lord, is permissible or not, I'll, my lord, give your lordship, my lord, two authorities for my lord's consideration.
Yes.
Which has not been considered, my lord, in the judgment which my learned friend has relied upon. Larger bench judgment, my lord, of the 3-judge bench. Avaru kotra. DG ಅವರು ಕೊಟ್ರ ಆಫೀಸ್ ಮಾಡಿಸ್ಬೇಕ್ರಿ ಇಲ್ಲ ನಾನೇ ಮಾಡಿಸ್ತಾ ಇದ್ದೆ ಕೊಡ್ಬೇಕು ಎಲ್ರಿಗೆ
Which judgment?
First, my lord, page 1, my lords, get that at page 1.
The division bench judgment. Yes, 2 judgment.
3-judge bench ಇದೊಂದು ಇಟ್ಟಿದ್ನಲ್ರಿ ಅದನ್ನೆಲ್ಲ ನೀವು ಮೇಲೆ ಕಡೆ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ ಇದರಲ್ಲಿ para 26 my lord, if your lords has come to ಬೇಕಾಗಿಲ್ಲ ಇದು ಅದನ್ನು ತೋರಿಸ್ಬೇಕಷ್ಟೇ ನೀವು ಎಲ್ಲ ಕೆಳಗೆ ಏನೆಲ್ಲ ಹಾಕಿದೀರಿ
ಇಲ್ಲ, only the 16 paras in Suganti Suresh Kumar.
ಇಲ್ಲ ಇಲ್ಲ, ಪ್ಲೀಸ್ ಕಮ್ ಟು my lord. ನಾನು ಅವತ್ತು ಕೊಟ್ಟಿದ್ದೀನಿ, ನಾನು ನಿಮಗೆ ಎಲ್ಲಿ ಹಾಕಿದ್ದೀರಿ?
Oriental Insurance.
My lord, please come to page 42 my lord. ಅದನ್ನ ಫಸ್ಟ್ ಹಾಕೋ ಬದಲು ಇವರು ಎಲ್ಲೋ ಹಿಂದ್ಗಡೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. Sorry, my apology. 42 my lord. 2003 4 SCC 239.
Yes.
239. ಕೊಡ್ರಿ ಕಾಪೀಸ್ ಮಾಡಿ.
Yes, please.
Paragraph ಯಾವುದು?
The three-judge bench.
Three-judge bench. Whether, my lord, the question that arose for consideration is whether, my lord, an order, my lord, earlier view was two judges have all held, my lord, that illegal orders, my lord, cannot be ratified. This three-judge bench holds that, my lord, even illegal orders can be, my lord, ratified.
Para?
Please come to, my lord, paragraph, page, my lord, 63. Paragraph 42.
Yes.
In any view of the matter, even in case where the initial action is illegal, same can be ratified by a body competent therefore. This aspect of the matter has not been considered by the High Court at all. In Parameshwari Prasad Gupta versus Union of India, this court held that even if it be assumed that the telegram and the letter terminating the service of the appellant by the chairman was in pursuance of an invalid resolution by the Board of Directors passed on 16/12/1953 to terminate his services, it would not follow that the action of the chairman would not be ratified in a regularly convened meeting by the Board of Directors. The point is that even assuming that the chairman was not legally authorized to terminate the services of the appellant, he was acting on behalf of the company in doing so because he purported to act in pursuance of the invalid resolution. Therefore, it was open to the regularly constituted meeting of the Board of Directors to ratify that action, though unauthorized, was done on behalf of the company. Ratification would always relate back to the date of the act ratified, and so it must be held that the services of the appellant were validly. ಇದೆಲ್ಲ ಇನ್ನೊಂದಿದೆ ಪ್ಯಾರಾಗ್ರಾಫ್. ಆಯ್ತು, ನಾನೇ ಮಾಡಿದೆ. Paragraph 42, my lord, which your lordship
That is
saw.
what you read.
That's right. My submission to your lordships is an action, my lord, which is ratified relates back to, my lord, the date. In fact, even, my lord, in Bondu Ramaswamy's case, this matter, my lord, came up for consideration.
Yes.
ಅದರಲ್ಲಿ ಹಾಕಿಲ್ಲ ಅವರು. ನಾನು 3 paragraph ಮಾತ್ರ, I'll, my lord, give you a lordship, my lord, since, my lord, it is getting adjourned and your lordships are taking it up on Friday, I'll give the full judgment. ಈಗ ಅರ್ಜೆಂಟ್ ಅಲ್ಲಿ ಅಲ್ಲ, ಅದು ಒಂದೇ ಕಾಪಿ ಹಾಕ್ಬಿಡಿ, ಒಂದೇ, ಎರಡಿದೆ ಅಲ್ಲಿ. ನಿಮ್ಗೊಂದು ಕೊಡ್ಬೇಕ್ರಿ, ಸಾರಿ, ಮೈ ಅಪಾಲಜೀಸ್. ಇಲ್ಲ ಇಲ್ಲ, ಇದೆ ಇದೆ ಮಾಡ್ತೀನಿ. Please come to, my lord, paragraph 114, 115 at page, my lord, 182. In this matter, this again, my lord, is a three-judge bench.
Yes.
All these, my lord, three-judge bench has not been looked into at all in those judgments, my lord, which the two judgments which my learned, on one judgment which my learned friend gave. In this case, the matter relating to sanction under section 18(3) of the BD Act was placed before the chief minister, who also happened to be the minister in charge, on 20/2/2004.
But
He granted
Navam,
approval.
Rabia is a constitutional bench judgment.
Is,
Five
my lord?
judges. Navam Rabia is
No,
constitutional.
no, my lord, Rabia does not relate to, my lord, ratification.
Ratification.
We are only concerned with the ratification, my lord. The first one, my lord, your lordship must have seen, I was reading on a thin ice.
Yes.
I didn't want to, my lord, I just submitted that and
First
left
matter
it.
is little difficult.
I know that. That's why I did not even press, my lord, too much. But please have a look at this, my lord, 114. In this case, the matter relating to sanction under 18(3) of the BD Act was placed before the chief minister, who happened to be the chief minister in charge, on 20/2/2004. He granted approval subject to ratification by the cabinet. In view of the subsequent ratification by the cabinet, there is nothing irregular in the procedure adopted. Delay in ratification was on account of the dissolution of the House. The contention that sanction is void is untenable. As noticed above, Rule 12 requires the matter to be ordinarily considered at the meeting of the cabinet. This itself would show that there can be exceptional circumstances where it will not be possible to place it before the cabinet. The approval granted by the Chief Minister, subject to ratification of the cabinet, was treated by the Urban Development Department as approval for sanction under Section 18(3), and a government order was made on 21/2/2004 in the name of the governor granting sanction under so and so. State government also issued a final declaration under Section 19(1) of the BD Act. It is thus evident that the state government proceeded on the basis that the order of approval of the Chief Minister for sanction was sufficient for grant of sanction, even if it be assumed that such approval was irregular as it was made subject to ratification. As a ratification was subsequently made, the challenge for want of proper approval of the cabinet for sanction cannot be accepted. Then, my lord, of course, the other things, my lord, strictly may not apply. 163(3). Whether, my lord, the court can go into this aspect. That, my lord, page 66. I don't want to, my lord, I'm just submitting it, leaving it at that. I don't want to say anything more. Paragraph 8 of this judgment.
Now with Rabia, then it is amenable to
Have a look at,
judicial.
my lord, Rabia again. Let's look at Rabia, my lord, for a minute. All that Rabia says is, he has to act, my lord, in aid and advisory, with the aid and advisory of the governor, cabinet.
Yes.
If, my lord, it is subsequently, my lord, ratified, it relates back to the date of, my lord, the act itself.
Ratification was not dealt with it.
You know,
Whether
no, it was not a subject matter, my lord, before Rabia at all.
any discretion exercised beyond the governor's jurisdiction authority would certainly be subject to judicial review.
Naturally. Judicial review, yes.
Yes.
I, my lord, don't want to, my lord, say, though, if you are to look at 163(3), judicial reviews, my lord,
Is left to the discretion. His decision is final. But that
and
is
163(2) also says that same thing, but I do not want to, my lord, venture into that at all. Because today, sometimes, my lord, what we do is, if, my lord, kaddi lagadu kol beda, there is a ratification. Therefore, my lord, I would say that, my lord, I will rely upon that. I don't want to venture into anything else because idರಲ್ಲಿ 163(3), this honorable court has held, my lord, that it can't be gone into, looked into all that. But I don't want to, my lord, go into that aspect. I leave it at that. But the fact is, ratification, my lord, relates back to, my lord, the date of the act itself. And therefore, my lord, the act, my lord, of the governor, in keeping them under suspension, my lord, is valid. And please also bear in mind, my lord, two things. In this case, there was urgency, my lord. Cabinet meeting, my lord, takes time. All the ministers, my lord, must be available. Here was, my lord, there was a public furor. Here was a person who, my lord, was he is a constitutional authority.
Yes.
Chairperson, my lord, of the KPSC, my lord, he is a constitutional authority. He is required to, my lord, to be above board. He, my lord, does something, my lord, which is, I don't want to say strong words, which is not proper, which is wholly illegal.
the allegation is against the daughter, not against him.
Please, my lord.
The daughter has given a false certificate.
No, he also, my lord, says something. I'll tell your lordship. He gives his, this thing is, it's not as if, it is placed before, my lord, the KPSC. He knows about it. I can understand, my lord, if he is ignorant.
He should have at that time said something.
I can understand, my lord, he gives it. It's not as if, my lord, he doesn't know. He knows about it. And yet, my lord, proceeds, my lord, so brazenly. That's why I pointed out, my lord, on the first day, the judgment of the Supreme Court, my lord, in 2017, where charge was similar to this. Daughter, my lord, applied. And he did not recuse. Here, he, my lord, is aware of it. And therefore, my lord, there is some urgency. And therefore, my lord, I kept him under suspension, subject to ratification. It is not necessary that, my lord, I should say it is subject to ratification. If it is ratified, it validates, my lord, the whole thing. This is all, my lord, that I want to say.
If your submission is that the Council of Ministers had disagreed, and if
Then,
they
my
had
lord,
said no,
then my lord.
then the order would have to be reformed.
Correct. Absolutely. This is all that I have to say.
Yes, Mr. How long will you take? You've got 4 minutes.
Then I'll do it on next day.
5:15.
We are meeting at 5:30. Illadre will be sitting till 6. Heard further arguments, further arguments, I think, of Mr. Arun Sham, Senior Counsel for the petitioner, Sri Udayalal and Senior Counsel for Respondent number 1. arguments of the other respondents relist on 24th at 2:30 p.m.
I may have something to say about this written submissions. ಒಂದು 5 ನಿಮಿಷ ಮಾಡ್ಬಿಡ್ತೀನಿ. ನೋಡಿಲ್ಲ ಇದನ್ನ ಯಾಕಂದ್ರೆ ಈಗ ಕೊಟ್ಟರು ಅವರು. ನೋಡಿ ಹೇಳ್ತೀನಿ.
Sir, the written submission filed by the counsel for the petitioner has also memo of citation, memo of list of authorities, Roman 2 is taken on record.
Please.
55 memo of withdrawn. All interim orders will be extended.
45. Without the compensation of the victim, the morning and short time. Because we are waiting 15 years.
Whatever is reaching is what we are able to take. We will take it up. Now 45, it did not reach unfortunately today. You want a date, convenient date, we'll give you a convenient date. Hopefully it will reach that date. What date do you want?
Any day is not convenient.
We don't know anything. Every day is convenient for matter which reaches.
On top of the
We won't change the status of the matter.
next week, next Friday.
Which date you are coming from outside? Then 31st to 2:30 list. That we
Serial number 63 and 64, my lords. By suppressing earlier dismissal of writ petition, my lords, these petitions are filed. That's urgency, my lords. Consumer award is there, my lords. Now consumer award now, my lords, I am unable to.
Arrest warrant.
Court officer 63, 64 date.
14th August entry ಮಾಡಿದ್ರೆ extend ಆಗುತ್ತೆ. 14th August list to tomorrow. List to tomorrow.
List ಇಲ್ಲ ಅದು.
List 2 ಅಲ್ಲ, list 3. List 3. List 3 tomorrow. ಅದೇ ಎಲ್ಲ tomorrow. List 1 ಎಲ್ಲ 14th August entry ಮಾಡಿದ್ರೆ extend ಆಗುತ್ತೆ. List 2 passed over 5/8. List 1 14th August. List 3 tomorrow. Passed overs ಎಲ್ಲ ನಾಳೆ. Passed overs ನಾಳೆ. 45 ಹೇಳಿದ್ದಾರೆ. ಡಿಕ್ಟೇಷನ್ ಆಗಿದೆ, ಅವ್ರು ಮಾಡ್ತಾರೆ. ಇಲ್ಲ ಎಲ್ಲ 14th August. ಅದೇ ಸ್ಪಾ ಮ್ಯಾಟರ್ಸ್ ಗೊತ್ತಿಲ್ಲ. ರಿಪೋರ್ಟ್ ರೆಡಿ ಇದೆ. ಯಾವತ್ತು ಹಾಕೋಣ ಹೇಳಿ, ಡೇಟ್ ಹೇಳಿ. ನಾಳೆ ಹಾಕೋಣ. ಸ್ಪಾ ನಾಳೆ. ಈಗೆಲ್ಲ ನಾನು ಯಾವ್ದ್ಯಾವ್ ಸ್ಪಾ ಅಂತ ನೋಡ್ಬೇಕು. ನಿಮ್ದು ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರು? 20 ಪಾಸ್ ಓವರ್, ಅದು ಬಿಟ್ಟು ಬೇರೆದು ಇದೆ. ಎಲ್ಲ ಪ್ರೇಯರ್ ನೋಡ್ತಾ ಕುತ್ಕೋಬೇಕು. ನಿಮ್ ಯಾವ್ದು ಇದೆಯೋ 78 ಇದೆ, ಆಮೇಲೆ 20, ಆಮೇಲೆ ಪ್ರೇಯರ್ ನೋಡ್ಬೇಕು. ಇದಾವೆ, ಇನ್ನೂ ಇದಾವೆ. 14 ಮ್ಯಾಟರ್ ಇದೆ. ನಾಳೆ ಇಲ್ಲ, ಎಲ್ಲ 14th August.
Serial number 90, 17th August. 14th ಇರಲ್ಲ.
17th August. ಪರವಾಗಿಲ್ವಾ? ಜಾಸ್ತಿ ಬೇಕಾದ್ರೆ ಕೊಡ್ತೀವಿ. ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್?
ಜಾಸ್ತಿ ಬೇಕಾದ್ರೆ ಕೊಟ್ರೆ ಇನ್ನೂ ಜಾಸ್ತಿ ಕೊಡಿ.
ಯಾವ್ದು?
90.
ಹೇಳಿ, ಡೇಟ್ ಹೇಳಿ ನೀವೇ. 17th August. ಆಯ್ತು. 14th August ಆದ್ಮೇಲೆ ಇದ್ರೆ ಹೇಳಿ, ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಇದ್ರೆ ಹೇಳಿ. 57 ಯಾವತ್ತು? 57 24. ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ನೀವು? ಥರ್ಡ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ ನಾಳೆ. ಜುಲೈ 5 ಲಿಸ್ಟ್ 1. ಅದೇ ಅದೇನ್ ಸಬ್ಜೆಕ್ಟು, ಯಾವತ್ ಬೇಕು? ಫಾಸ್ಟ್ ಓವರ್ ಫ್ರೈಡೆ. ಆಯ್ತು ಸರ್, ಫ್ರೈಡೆ 24 ನಾಳೆ. ಲಿಸ್ಟ್ 3 ಎಲ್ಲ ನಾಳೆ. ಅದು ಪಾಸ್ ಓವರ್ ಅಲ್ಲ. ಏನ್ ಶಿವರಾಮ ಸರ್ ಯಾವತ್ ಬೇಕದು? 12 ಯಾವತ್ತು? ನಾಳೆ. ಥರ್ಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಒಂದಿದೆ. ಸರಿ ಆಯ್ತು. ಅದ್ ನಾಳೆ 12 ಕನೆಕ್ಟೆಡ್ ಒಂದಿದೆ ಇದ್ರಲ್ಲಿ. ಥರ್ಡ್ ಲಿಸ್ಟ್ 14th August 52. 17. ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಯಾವುದು ಸರ್? 63, 64. 63, 64 ಎರಡು 17th ಆಗಸ್ಟ್. ಹೌದು ನಿಮ್ದೇ. ಅಲ್ಲ 14th ಆಗಸ್ಟ್ ಆದ್ಮೇಲೆ ಹೇಳಿ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಇಲ್ಲ. ಇಲ್ಲಾಂದ್ರೆ 14th ಆಗಸ್ಟ್. ಯಾವುದು ಸೀರಿಯಲ್? 42. ಬೆಳಗ್ಗೆ ಅವ್ರು ಇರ್ತಾ ಇದ್ರಲ್ವಾ? 25th ಆಗಸ್ಟಾ? 47 14th ಆಗಸ್ಟ್. ಆಫೀಸು ಇದೆ 18th ಆಗಸ್ಟ್. ಏನಕ್ಕೆ? ಆನ್ಲೈನ್ ತಗೊಂತೀನಿ ಬಿಡಿ, ಅಲ್ಲಿ ಬೇಡ ಫೋನ್. ಬಂದೆ ಇಲ್ಲಿ VC ಅಲ್ಲಿ ಇದಾರಂತೆ, ಒಂದು ಕನೆಕ್ಷನ್ ತಗೊಳ್ಳೋಣ. ಹ್ಮ್ 17 ಯಾವ್ದು?
ಮೇಡಮ್ ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 72 14th ಡಿಫಿಕಲ್ಟಿ ಇದೆ, 17th ಅಥವಾ 18th ಕೊಡಿ ಮೇಡಮ್.
17th ಆಗಸ್ಟ್
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು.
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಓಕೆ,
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
Court officer madam, serial number 87 in list 1. Madam,
I'll be your voice. Wait, madam.
Sir, ಹೇಳಿ sir.
Madam, list 1 serial number 85 madam.
85 14th ಆಗಸ್ಟ್.
Done.
Madam
47.
Madam list 1 serial number 83.
No, I wanted to be after 10.
ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡಕ್ಕೆ.
ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಇಲ್ಲ, ಚೆಕ್ ಮಾಡಿದೀನಿ, ಎಲ್ಲ ನೋಡಿದೀನಿ. ಇದೆ, ಹೌದು ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್. ಯಾವ್ದು? ಒಬ್ರು ಹೇಳಿದ್ರೆ ಯಾವ್ದು ಕೇಳಿಸಲ್ಲ ನನಗೆ. ಅವರು ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ, ಅವರೇ ಎಂಟ್ರಿ ಮಾಡೋದು. 17 ಅದು ಆರ್ಡರ್ ಆಯ್ತಲ್ಲ. ಅದ್ಯಾವ್ದು PDS ಅಲ್ಲ, ಯಾವ ಲಿಸ್ಟು? 3ನೇ ಲಿಸ್ಟ್ ಇರ್ಬೇಕು ನೀವು ಹೇಳೋದು. 17 ನಾಳೆ 2:30 65 ಎಂಟ್ರಿ ಮಾಡಿದೆ ಸರ್. 14th ಆಗಸ್ಟ್ ಚೆಕ್ ಮಾಡಿದೆ, ಆಗಿದೆ. ಲಿಸ್ಟ್ 3 ಅಲ್ಲ, ಎಲ್ಲನೂ ರಿಪೀಟ್ ಮಾಡಿ ಅಂದ್ಬಿಟ್ಟಿದೆ ಥರ್ಡ್ ಲಿಸ್ಟ್. ಅದಕ್ಕೆ ಈಗ ಯಾವತ್ತು ಹಾಕೋದು? ಆಯ್ತು, 14th ಆಗಸ್ಟ್. ನಾಳೆ. ಇನ್ಯಾವ್ದಾದ್ರು ಇದೆಯಾ? ಸ್ಪಾ ಮ್ಯಾಟ್ರ್ ಇನ್ಯಾವ್ದಾದ್ರು ಇದೆಯಾ? ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ 23 ಪಾಸ್ ಓವರ್ ಆಯ್ತಲ್ಲ, ಅದನ್ನು. ಲಿಸ್ಟ್ ಸ್ಪಾ ಅಂತ ಒಂದಿತ್ತಲ್ಲ 23 ಸೀರಿಯಲ್ ನಂಬರ್ 23, ಅದು ಮಾತ್ರ ನಾಳೆ. ಮಿಕ್ಕಿದ್ದೆಲ್ಲ 58. ನಾಳೆ. ಯಾವತ್ ಬೇಕೀಗ? ಅಲ್ಲ, ಇವತ್ತು ಬಂದಿದ್ಯಾ? ಇವತ್ತಿದೆ. 84 ಯಾವತ್ ಬೇಕು? ಯಾವತ್ತು? ಅಲ್ಲ ಹೇಳಿ ನೀವೇ. ಅಲ್ಲಿ ರೀಚ್ ಆಗಲ್ಲ, ನಾನ್ ಕೊಡೋ ಡೇಟಿಗೆ ಬಂದ್ರೆ ರೀಚ್ ಆಗುತ್ತೆ. ಈಗ 14th ಆಗಸ್ಟ್ಗೆ ಬಂತು ಅಂದ್ರೆ ರೀಚ್ ಆಗುತ್ತೆ ನನ್ನ ಪ್ರಕಾರ. ಅದಕ್ಕೆ ಯಾವತ್ ಬೇಕು ನೀವ್ ಹೇಳಿ, ಯಾಕಂದ್ರೆ ನೀವು ಕಾಯ್ಬೇಕಲ್ವಾ. ಬೇಗ ಹಾಕಿಸ್ಕೊಂಡ್ರೆ ಕಾಯ್ಬೇಕಾಗುತ್ತೆ. ಅದಕ್ಕೆ ಯಾವತ್ ಕಾಯ್ತೀರಾ ಆ ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಹೇಳಿ ನೀವೇ ಹೇಳಿ. ನಿಮ್ ಅಡ್ವೊಕೇಟ್ ಯಾವಾಗ ಕಾಯ್ತಾರೆ? ಹೇಳಿ ಡೇಟ್ ಹೇಳಿ, ನೀವೇ ಹೇಳ್ಬಿಡಿ. ನೀವು ಕೇಳೋ ಡೇಟೇ ಕೊಡ್ತೀನಿ. ಈಗ ಹೇಳಿದ್ರೆ ನಾನು ಮಾಡ್ತೀನಿ. ಹೇಳಿ ಒಂದ್ ಡೇಟ್ ಹೇಳಿ ನನ್ಗೆ. ಈಗ ನೀವ್ ಹೇಳಿ ಡೇಟೇ ಕೊಟ್ರೆ ಖುಷಿ ಇರುತ್ತೆ ನಿಮ್ಗೆ, ಹೇಳ್ಬಿಡಿ ಅವತ್ತೇ ಹಾಕ್ತೀನಿ. ಅದೇ 14th ಆಗಸ್ಟ್ ಹಾಕೊಂಡ್ರೆ ಸ್ವಲ್ಪ ಮೇಲಕ್ಕೆ ಬರುತ್ತೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹಾ ಅಷ್ಟೇ. ಹೇಳಿ ಸರ್. 14th ಆಗಸ್ಟ್.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 87 ಇನ್ನು
87 14th ಆಗಸ್ಟ್ ಸರ್.
ಇನ್ನೊಂಚೂರು ಮೊದಲು ಕೊಡಕ್ಕಾಗುತ್ತಾ ಮೇಡಮ್?
87 14th ಆಗಸ್ಟ್.
14th ಮೇಡಮ್, ಇನ್ನು ಪ್ರೀವಿಯಸ್ ಡೇಟ್ಸ್ ಯಾವ್ದು ಆಗಲ್ಲ?
ಪ್ರೀವಿಯಸ್ ಅಂದ್ರೆ ರೀಚ್ ಆಗಲ್ಲ. ನೀವ್ ಯಾವತ್ ಕಾಯ್ತೀನಿ ಅಂತೀರಾ ಅವತ್ ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಯಾವತ್ ಕಾಯ್ತೀರಾ?
ಇಲ್ಲ ಇರ್ಲಿ ಬಿಡಿ ಮೇಡಮ್, 14th ಆಗಸ್ಟ್ ಅಂದ್ರೆ ಪರವಾಗಿಲ್ಲ. ಓಕೆ
ಸರ್.
14th
Madam,
ಹಾ ಹೇಳಿ.
Madam, serial number 83, Madam.
83 14th ಆಗಸ್ಟ್.
14th August, Madam. Okay. Thank you, Madam.
Okay. ಈಗ ಲಿಸ್ಟ್ ಆಯ್ತಾ ಆಗ್ಲಿಲ್ವಾ ನಿಮ್ದು? ಯಾವತ್ತು? 44. ಯಾವತ್ ಬೇಕು? ನಾಳೆ ಬರ್ತೀರಾ? ನಾಳೆ ರೀಚ್ ಆಗುತ್ತೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ. ನಾಳೆ. ನಿಮ್ದು ಒಂದ್ ಸ್ವಲ್ಪ ಕಮ್ಮಿ ಇರೋದಕ್ಕೆ ಇವ್ರಿಗೆ ಚಾನ್ಸ್ ಇದೆ. ನಿಮ್ದು 80 ಚಿಲ್ಲರೆಲ್ಲಿದೆ. ನಾಳೆ ಹಾಕಿರ್ತೀನಿ. ಅಲ್ಲ ಏನೋ ಈಗ ಆಗಿದೆ. ನನ್ ಬರೀ ಡೇಟ್ಸ್ ಕೊಡೋದು ಒಂದೇ, ಬೇರೆ ನನ್ಗೂ ನನ್ ಕೆಲಸ ಇದಾವೆ, ಮುಗಿಸ್ ಹೋಗ್ಬೇಕು ಅಷ್ಟೇ. ಅದಕ್ಕೆ ನಾಳೆ ಬಂದ್ರು ಎಂಟ್ರಿ ಮಾಡಿರೋದ್ರಿಂದ ನಾಳೆ ಹಾಕಕ್ ಬರಲ್ಲ ನಿಮ್ದು. ಇವ್ರ ಕೇಸಲ್ಲಿ ಆದ್ರೆ ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ, ನಾಳೆ ಹಾಕ್ಬೋದು. ನಿಮ್ ಕೇಸ್ ನಾಳೆ ಹಾಕಕ್ಕೂ ಬರಲ್ಲ. 14th ಆಗಸ್ಟ್ ಇರ್ಲಿ. ಹಾ ಆಯ್ತು. ಆಯ್ತು. ಅಲ್ಲಿ ನಮ್ ಕೈಲಿ ಆಗೋದ್ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ. ಬರ್ತೀನಿ. ಒಂದ್ ಕಡೆಯಿಂದ ಹೇಳಿದ್ರೇನೆ ಅದ.